Dharwad bench matter, adjournments, list number 1, page number 40.
Fix the date.
मतलब serial number 47 मतलब
47 or 43?
47 मतलब serial number 47 मतलब if you are-
ಇಲ್ಲ, ಒಂದ್ ನಿಮಿಷ ಇರಿ.
My lord, serial number 46, my lords. 2 weeks may be granted, appearing for respondent, my lords.
Respond number 1.
Yes, my
Respond number 1 state up. Respond number 3.
3, R3, my lords.
PV Somapur,
Inform ಮಾಡಿದೀರಾ?
Madidi, my lords.
2011 matter.
Yes, my lords.
Why? It's a
Senior.
dated matter.
Senior out of station.
At the request of counsel for respond number 3, relist on 20th, it is made clear that no further adjournment would be granted. If arguments were not advanced by respond number 3, the matter would be considered on the basis of submission made by the counsel for the petitioner.
page 11,
मतलब serial number 47 मतलब
Yes.
मतलब serial number 47 मतलब I'll be there physically on Tuesday my lord, your lordship may have it on 11th मतलब some inconvenience today मतलब
Have you informed everybody else?
Yes, I've informed Mr. Hatti, my lords, is contested.
47 at the request of the counsel for the petitioner, relist on 11th. It is made clear that no further adjournment would be granted if arguments were not advanced on that day. The petition would be liable to be dismissed for non-prosecution.
Please.
page 7, 48 to 52, page 12, 53 to 59,
54, my lords. I'm appearing on behalf of Vidyavati Kottoshettar, ma'am. It is covered by decision.
Covered by decision mention alla madadu. Reach adre.
page 13, 60 to 65, page 14, 66 to 70,
Inform ಮಾಡಿದೀರಾ?
Simkalwad,
At the request of counsel for the petitioner, relist on 24th. Interim order earlier granted is extended.
page 15, 71 to 78,
Serial number 78, Mars. For the petitioners, maybe taken next week, Mars. Already informed the other side, Mars.
At the
Give it,
request of the counsel for the petitioner, relist on 17th February.
please.
Represent Ramchandra Mali in this. It may be taken next week, my lord, since he is facing some inconvenience today. He is not, our colleague or Madhvi this one. 70.
At the request of counsel for respond number 4, relist on 20th. ಮದ್ವೆಗೆ ನಮ್ ಕರೆದಿಲ್ಲ.
Serial number 79 one.
79. Yes. At the request of counsel for the petitioner, relist on 20th.
Lord, serial number 78.
Hmm.
That matter pertains to no confidence motion. Now they are having a benefit of an interim order not to precipitate. And they are seeking time.
78 ಹೊಡೆದಾಕಿ no adjournment. Yes.
list 1,
My lord, serial number 80, my lord. 80. Advocate on record is out of station, my lord.
ಯಾವ್ದಮ್ಮ?
Serial number 80.
80.
Serial number 80, I'm appealing for the respondent in first matter. Some urgency in this matter, my lords.
ಏನದು? Is not in town ಅಂದ್ರೆ ಎಲ್ಲಿಂದ ಕರ್ಕೊಂಡು? 80 at the request of counsel for the petitioner, relist on 19th February.
Must may be taken in preliminary short point for consideration.
Final hearing ಇದೆ ಅದು.
ಅಲ್ಲ, ಅಗದಿ preliminary hearing ಅಂದ್ರೆ ಬರೀ only the allot.
In the meanwhile, compliance with office objections to be made. If not complied, petition would be liable to dismiss for non-prosecution. ಇನ್ನ compliance ಇದೆ ನೋಡಿ.
Preliminary.
Connected matter, it was listed for preliminary hearing on the last occasion. The connected, that is at serial number 80. Since it is admitted, it is connected along with. First matter itself is not admitted. Second, 80.1 is not yet admitted.
ಆಗಿಲ್ವಾ?
ಹೌದು.
For preliminary hearing on 19th. Next to ಯಾವ್ದು? CPC ನ? 19 matters, 2 days. List 2, serial number 1 to 10 will be repeated on 7/3, 11 to 19 on 10/3. Interim orders and all the matters will be extended.
With kind permission, my lord. In serial number 40, orders matter, my lord. It may be taken Tuesday or Monday, my lord.
Wait, man, no.
List 1, orders, preliminary, 1,
My lords, I appear for the
Please.
petitioner, my lords.
Yes.
My lords, I'm before your lordships, my lords, on a very, very short point, my lords. My lords, the scheduled property, my lords, was brought by...
Mohammed Ali.
Lord, this
Yes,
is,
Mohammed Ali.
these are similar covered matters in regarding deleting the name of word in column number 11.
Column number 11. The petition scheduled property, my lords, was purchased by my ancestors. Ultimately came to be allotted to me, my lords, in a partition suit.
Petitioner is before this court seeking for the following reliefs. Yav the number?
Lord. Allah number. Yes. Allah number.
100-611. ಇದರಲ್ಲಿ ಏನು ಎಂಟ್ರಿ ಡಿಲೀಟ್ ಆಗಿದೆಯಾ?
ಇಲ್ಲ ಎಂಟ್ರಿ
ಬರೀ ಅಡಿಷನ್
ಅಡಿಷನ್ ಮಾಡಿದ್ದಾರೆ ವಫ್ ಬೋರ್ಡ್ ಕಾಲಮ್ ನಂಬರ್ 11 at page 30 ವಫ್ ಆಸ್ತಿ ಅಂತ ಬರೆದಿದ್ದಾರೆ.
Delete the name of respondent number 3 in column number 11 within 15 days.
Two, B. Mangdi.
Please, my lord. My lord, this connected matter is 18th to my lord. Kindly list on along with connect that matter.
18 to.
Please, my lord, 18 to.
WP number, my lord.
My lord, one more submission, my lord. Last time ಅದಕ್ಕೆ connect ಆಗಿತ್ತು ಆ ನಂಬರ್ ಬಟ್ ಬೈ ಓವರ್ಸೆಟ್ 8 ಆಗುದು 9 ಆಗುದು 8 ಆಗಿದೆ. ಕೈಂಡ್ಲಿ ಕನೆಕ್ಟ್ ಸೇಮ್ WP ನಂಬರ್, my lord.
ನಂಬರ್ ಏನು ಕನೆಕ್ಟ್
107-696 of 24, my lords.
696.
Please, my
So
lords.
ಇದು 686 has to be dealing.
696.
Registry is directed dealing WP number 107686 of 2024 and connect WP 107-696 of 2024 and
Yes.
released on 18th. ಇನ್ನೊಂದು ಯಾವ್ದು
18 to.
18 to.
ಇನ್ನೊಂದು ಯಾವ್ದಿದೆ 18th?
The same, my lords.
Present case, my lord, and another. My lord,
18.
copy also served, my lord.
Yes.
Please.
accept notice for R6. R6 accept.
R6 ನೀವಾ? And AGA accepts notice for respondent number 6 registry is directed.
345, my lords, VM Shilwant. They already served.
Served copy, my
Accept
lord.
notice for respondent number
Please.
3 to 5.
Please.
Please, my lord.
3, Subendu, Akalwadi.
That's for
Yes.
petitioners, Milords. But this is for writ of mandamus, Milords, for consideration, Milords, of my representation dated 26/6 at Annexure H. Milords, sparing all the Milords initial orders, may I take Milords to Annexure E, page number 27, Milords. This is the finality, Milords, wherein this honorable court has allowed my earlier writ petition, that is at Annexure E.
Yes.
Milords, page number 31, Milords, paragraph number 8. May I read, Milords? A perusal of the order passed by Additional Taluka Shirastadar Hubli discloses that the land in question was not the subject matter of the suit. The name of third respondent was mutated in respect of land other than the land in question. However, Deputy Commissioner concerned erroneously came to a conclusion that the land in question is also the subject matter of the order passed by Additional Taluka Shirastadar Hubli. Hence, the impugned order passed by Deputy Commissioner is not sustainable in law. Accordingly, the writ petition is allowed. That's the Annexure J, Milords, the order of DC is quashed. It is made clear that the entry in revenue records in respect of land in question is subject to the judgment of the jurisdictional civil court. Milords, pursuant to this, I submitted, Milords, a representation vide Annexure F. I got an endorsement, Milords, saying if there are any pending cases. Subsequent to that, I've also made another representation that is at Annexure H, Milords, 26/6/2023. That pursuant to that, Milords, have received no representation, Milords, wherein I mentioned everything with regards to the order of this honorable court also. Seeking, Milords, representation of that consideration, Milords.
So there is no suit now pending.
No, Milords, there's no suit pending, Milords.
Suit ಇಲ್ಲ
And AGA accepts notice for
already ಆಗಿದೆ. Accepted ಆಗಿದೆ.
petitioner is before this court seeking for the following relief. The grievance of the petitioner is that the representation submitted by the petitioner at Annexure H dated 26/6/2023 in furtherance of the orders passed by this court in WP number 62493 of 2010 dated 19/11/2021 have not been considered, has not been considered by respondent number 1. Whenever any representation is submitted by a citizen to an authority, the same is required to be considered in a reasonable time frame and necessary orders passed thereon. In the present case, the representation having been submitted way back on 26/6/2023 has not been considered. In that view of the matter, I have passed the following order. Writ petition is allowed. A mandamus is issued. Respondent is directed to consider the representation dated 26/6/2023 at Annexure H in accordance with law and pass necessary orders within a period of 30 days from the date of receipt of a copy of this order.
Please, great.
4, Jagdish Patil.
My lords, I request for short accommodation, my lords. My lords, I need to seek instruction with respect to the office of objections which the respondents have filed. My lords. Requested on Tuesday, my lords.
Objections filed madidira.
I have filed the objection at produce document. On the same day,
Counsel for the petitioner seeks for and is granted 2 days time to get ready and address arguments. Relist on 12th.
Please.
5, Tabil Ahmed.
Request for the pass-over, my lords.
Paso.
6, A Part.
Appear for the petitioner in this matter, my lords. Lord, 3 applications filed by the petitioner rejected, my lord, recall, reopen, and my lord, to production of documents. Only ground that, my lord, I filed application after lapse of 9 years of initiation of suit, my lords. Page 70.
Suit for?
Suit for, my lord, declaration and injunction, my lords.
You are the plaintiff.
Yes, please, your lordship.
What stage did you file the applications?
My lord, at the stage of evidence itself. Matter, my lords.
Stage of evidence of whom? Your evidence.
Please, your lordship.
Why do you produce the entire order sheet?
My lord, sir, office will raise objection with respect to the same, my lord, because the single order ಕೊಟ್ಟರೆ ಅವರು ಕೊಡೋದಿಲ್ಲ single order. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಿಂಗಲ್ ಆರ್ಡರ್ ಕೊಟ್ಟು ಪೂರ್ತಿ ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ ಕೊಟ್ಬಿಡ್ತಾರೆ.
ಯಾಕೆ?
ಅದು ಸಿಂಗಲ್ ಆರ್ಡರ್ ಕೊಟ್ರೆ ಮತ್ತೆ ಫಸ್ಟ್ ಪೇಜ್ ಸಿಗಲ್ಲ. ಫಸ್ಟ್ ಪೇಜ್ ಸಿಕ್ಕರೆ ಅದು ಇದಾಗ್ಬಿಡುತ್ತೆ. ಫಸ್ಟ್ ಪೇಜ್ ಆರ್ಡರ್ ಶೀಟ್ ಇದ್ದ ಟೈಟಲ್ ಶೀಟ್ ಇರುತ್ತೆ my lord.
ಫೇಸಿಂಗ್ ಶೀಟ್.
ಎಸ್ ಪ್ಲೀಸ್.
ಇವಾಗ ನೀವು ಆರ್ಡರ್ಸ್ ಆನ್ I-11 ಕೇಳಿದ್ರೆ
ಅಲ್ಲಿ ಇದು ಕೊಡಲ್ಲ, ಡೈರೆಕ್ಟ್ ಆಗಿ ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಫುಲ್ ಶೀಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ.
So basically you are wasting 65 pages.
No my lord.
46 to 110 are not necessary.
Yes please your lordship.
So not only the money on copying but 65 pages are wasted.
Please your lordship.
ಇದು ಯಾರು objection raise ಮಾಡೋದು? ಇಲ್ಲಿ raise ಮಾಡೋದಾ ಅಲ್ಲ?
ಅಲ್ಲಿ ಫುಲ್ ಕಾಪಿ ನಮಗೆ ಕಳಿಸಲ್ಲ my lords. ಅಲ್ಲಿ ಕೇಳಿದ್ರೆ ನಾವು ಫಸ್ಟ್ ಶೀಟ್ ಅಷ್ಟೇ ಹಾಕ್ಬಿಟ್ಟು ಆರ್ಡರ್ ನಂಬರ್ 10 ಅನೆಕ್ಸ್ IML ಆರ್ಡರ್ ಕೊಟ್ಬಿಟ್ರೆ ಇಟ್ಸ್ ಸಫಿಶಿಯಂಟ್ ಫಾರ್ us my lords. ಅವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಆರ್ಡರ್ ಕಾಪಿ ಅಪ್ಲೈ ಮಾಡಿದ್ರೆ ಆರ್ಡರ್ ಶೀಟ್ ಜೊತೆ ಪೂರ್ತಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಟ್ಬಿಡ್ತಾರೆ. It happens in number of cases. I also face the same.
We have seen that. That's why we ask. We find in order ಯಾವ್ದು impugned order ಹುಡುಕೋದ್ರಲ್ಲೇ ಅದು ಟೈಮ್ ಆಗುತ್ತೆ. Annexure G ಅಂತ ಹಾಕ್ಬಿಡ್ತೀರಾ ಫುಲ್ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆ.
Moreover,
actually this Annexure G has 100 orders.
Please your lordship.
The office is also insist for production of the entire order sheet also. Even though if the order impugned order which has been challenged it will be part of the order sheet. But the office insists to produce the entire order sheet. Since the order sheet is incomplete. If you produce only first page and the impugned order, they will seek for to produce the entire order sheet.
ಅಲ್ಲಿ ಆರ್ಡರ್ ಶೀಟ್ ಬರೆಯೋದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂಷನ್ ಮಾಡ್ತಾರಲ್ಲ ಸ್ವಾಮಿ, ಅದು ಸ್ಟಾರ್ಟಿಂಗ್ ಇಂದ ಆರ್ಡರ್ ತಗೊಂಡ್ಮೇಲೆ ಸೂಟ್ ಇನಿಷಿಯೇಟ್ ಆದ್ಮೇಲೆ ಮತ್ತೆ ನಾವು ಪೇಜಿನೇಷನ್ ಕಂಟಿನ್ಯೂ ಮಾಡಕ್ ಆಗಲ್ಲ, ಬಿಕಾಸ್ ಅಲ್ಲಿ ಆರ್ಡರ್ ಅರ್ಧ ಕಟ್ ಆಗ್ಬಿಡುತ್ತೆ. ಸೊ ಒಂದ್ ಪೇಜ್ ಕಟ್ ಮಾಡ್ಕೊಂಡು ನಾವು ಮಾಡಿದ್ರೆ ಆಫೀಸ್ ಆಗಿ ಅಬ್ಜೆಕ್ಷನ್ ರೈಸ್ ಮಾಡುತ್ತೆ. ಆರ್ಡರ್ ಶೀಟ್ ಇಸ್ ಇನ್ಕಂಪ್ಲೀಟ್, ಪ್ರೊಡ್ಯೂಸ್ ಎಂಟೈರ್ ಆರ್ಡರ್ ಶೀಟ್.
But that order sheet is not numbered. Trial court order sheet is not numbered.
Number ಮಾಡಿಲ್ಲ.
ನಂಬರ್ ಮಾಡಿ Annexure G page 46.
ನೀವು ನಂಬರ್ ಮಾಡಿದ್ರೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಂಬರ್
ಅವ್ರ ನಂಬರ್ ಮಾಡಲ್ಲ, ಬಟ್ ಆರ್ಡರ್ ಕಟ್ ಆಗ್ಬಿಡುತ್ತಲ್ಲ my lords. ಅವ್ರ ಸೂಟ್ ಸಮನ್ಸ್ ಆಗಿ ಸಮನ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ಮೇಲೆ ಪೇಜ್ 47 ಮೇ ರಿಕ್ವೆಸ್ಟ್ ಯು ಲಾರ್ಡ್ಶಿಪ್. ಈ ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೇಕು ಅನ್ನೋದು ವಿ ಫೇಸ್ ದ ಡಿಫಿಕಲ್ಟಿ my lords. And one more submission is that my lord, ಈಗ ಅವ್ರು ನಾವು for first page ಹಾಜರ್ ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ they will not come to know who are the parties to the ಯಾಕಂದ್ರೆ ಇದರಲ್ಲಿ ಇರುತ್ತೆ full.
That is understandable, but when a copy is applied first page, this is not a problem in Bangalore. Bangalore ಅಲ್ಲಿ ಬರೀ ಇದೆ ಕೊಡ್ತಾರೆ.
ಇಲ್ಲಿ ನಮ್ಮ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಸ್ ಅಲ್ಲಿ ಅಲ್ಲೇ ಕೊಡ್ತಾರೆ ನೋಡಿ. I am facing ಬಳ್ಳಾರಿ ಮತ್ತೆ ಹಾಸ್ಪಿಟಲ್.
ಅದರಲ್ಲೂ we are finding so much of paper being wasted.
Lordship may please to pass any specific directions. I will be abide my lords. I'm grateful lordship.
Annexure G is the entire order sheet in case number 66 of 2015, pending on the file of the senior civil judge and JMFC Kudulgi. What is being impugned is only the orders dated 30/10/2024 passed on IA number 12 to 14. The entire, the annexure G starts from page 46 and goes on till page 129. What is impugned is only the order dated 30/10/24 passed on IA number 12 to 14, which is found at page 125 to 129. Thus, in effect, what was required to be produced were only the pages 124 to 129 and the facing page of the order sheet to denote the cause title. On inquiry with the learned counsel appearing for the petition as to why the entire order sheet has been produced, since only the orders at page 126, 125 to 129 are impugned, he submits that when an application for certified copy is made to the trial court for a order which forms part of the order sheet and not passed as a separate order, the entire order sheet is asked to be applied for and the entire order sheet is furnished as a certified copy. He further submits that the office of this court also raises an objection if the entire order sheet is not produced. The above situation has now resulted in page number, in the entire annexure G having been produced from page number 46 to 129, when what was required was only page 46 being the facing sheet and the impugned orders at page 125 to 129. In most cases, the other orders passed on other dates, which as reflected in page 47 to 124 was not required to be produced before this court. In that view of the matter, not only is the copying branch of the trial court burdened with extra work, but also a valuable resource of paper has been wasted, which is not required. Needless to say that use of unnecessary paper would also have an environmental impact. In that view of the matter, the Registrar General is directed to consider the same and issue necessary directions to the concerned courts after the approval of Honorable the Chief Justice, directing the trial court to only issue the facing sheet and the operative portion of the order, which is and the order which is being challenged, which is applied for by the council instead of insisting for an application to be made of the entire order sheet and furnishing it. Secondly, necessary instruction would have to be issued to the filing branch of the High Court, to the scrutiny branch of the High Court, that objections are not raised as regards non-production of the entire order sheet when the same is not required, unless there are any references made to earlier orders which require the production of the earlier orders, and or unless the council were to be of the opinion that the entire order sheet is required to be produced and as so produced, objections ought not to be raised on non-production of the entire order sheet. Really?
DW1 cross examination was the stage, my lord. ಅದು cross examination ಮುಗಿದಿತ್ತು.
DW1.
Please, your lordship. Page number 109, may I request your lordship? 107, I'm sorry.
ಇದು 107 ಇಂದ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಆಗಿರೋದು.
ಇಲ್ಲ ನೋಡಿ ಸರ್. Only observation made by trial court is that, my lord, after lapse of 9 years and the document which plaintiff want to produce is, my lord, the public documents, and no reason was shown by the plaintiff to show that, my lord, what prevented him to file such and such application at earlier stage, my lords.
There was a impleading application filed. 16 rule 6. But ನಿಮ್ cross examination ಆಗಿದೆಯಲ್ಲ ಸಬಿ?
ನಮ್ದಾಗಿದೆ, my lords.
You are the plaintiff.
Yes, please, your lordship.
The further proceedings in OS number 66 of 2015 pending on the file of the senior civil judge in JMFC Kudalgi, he stayed till the next date of hearing. Issue notice to respondent returnable by 19th March. Counsel for the petitioner, process fee and copies to be furnished by end of day 10th February, and acknowledgement of service on the counsel appearing for the respondent to be filed by end of day 14th February, failing either of which the above interim order will stand automatically vacated. A perusal of the order sheet, impugned order, indicate that the same is also not in compliance with the circular issued by this court, by this court on blank. Hence, the additional registrar judicial is directed to forward a copy of the said circular to the senior civil judge and JMFC Kudalgi for compliance in all future orders.
Please, your lordship.
7 AL Sandrimani.
Yes. This is suit for partition and separate possession.
Yes.
The respondent has filed application to restoring the defendant number, present petitioner, and that was confirmed. And on that order, miscellaneous application has been filed.
Repeat ಮಾಡಿ Michael on ilva?
Yes, you are.
Yes,
That-
suit for partition and separate possession.
Yes, you are. In that, the respondent, the present respondent number 1 has filed a application not to restoring the defendant number 3 and 4, the present petitioner, Your Honor. And that was confirmed, and on the said order, the present petitioner has preferred a miscellaneous appeal, Your Honor. That was also confirmed, Your Honor. And the petitioner and defendants are, respondents are the co-owners of the suit properties and possessor of the suit property.
Yes, injunction has been granted.
Yes.
Ian, what is the ground?
Yes, Your Honor.
Restraining construction ಕೊಟ್ಟಿದ್ದಾರೆ.
Respondent number, defendant number 1 against these petitioner, defendant, the present petitioner and respondents are the co-owners and possessor of the
Yes.
yes, Your Honor, and family properties, Your Honor. Injunction cannot be granted against the co-owners by the passing the order on that time.
What happens to the construction tomorrow? FDP ಅಲ್ಲಿ? ಹೇಳಿ ನೀವೇ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ ಹೇಳಿ.
In FDP, it is coming, I will.
ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಮಾಡಿ ಆಮೇಲೆ FDP ಅಲ್ಲಿ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಹೊಡೆದಾಕ್ಬೇಕು ಅಂದ್ರೆ ಏನ್ ಮಾಡೋದು?
ಕೊಡ್ತೀವಿ ಸರ್. It will be written.
ಹೊಡೆದಾಕ್ತೀರಾ?
ಕೊಡ್ತೀವಿ ಸರ್.
ಏನ್ ಮಾಡ್ತೀರಾ?
It will give us, ಕೊಡ್ತೀವಿ ಸರ್.
ಕೊಡ್ತೀರಾ? You won't claim equities.
Yes, Your.
But we can't vacate it ex parte. ಅದು ಒಂದು ಅಂಡರ್ಟೇಕಿಂಗ್ ಹಾಕಿ. Issue notice to the respondents returnable by 11th March Learned counsel for the petitioner submits that if the petitioner were to be permitted to go on with the construction, the petitioner would not claim any equities in the said construction. And if the constructed area were to be allotted to any other member of the family in the final decree proceedings, the petitioner will not claim for any cost of construction or the like. She is directed to file the affidavit of the petitioners in that regard. Pre-list on 11th. Counsel for the petitioner is also permitted to serve the counsels for the respondents appearing in the trial court.
8, Shivraj Mudhol.
I beg to appear for the petitioner, my lord.
Yes, Mr. Mudhol.
The petitioners are agriculturists, my lord. Adjoining to, my lord, the petitioner's agriculture land. But respond number 6, MSIL, but they want to, my lord, put up, my lord, start the MSIL, my lord, wine shop. My lord,
identical case, the lordship
identical
has already
annexure G,
granted an
page
interim
24, my
order.
lord.
Page 24.
My lord has not passed an interim order. My lord,
Not to precipitate, not
Page
to
25
restrain
not-
from establishing.
Yeah, who is the standing counsel?
my lord,
BS
standing
Gautam.
counsel is, my lord,
Accepts notice for
BS
respondent
Gautam
number
appear for, my lord, MSIL.
1 to 4. 5 Yarrow.
5 and 6 BS Gautam.
PS Gautam is directed to accept notice for respond number 5 and 6.
7
Seven,
ಗೆ
Lord,
RC
Shivraj-
Hiremat.
Shivraj Hiremat appears, my lord.
Shivraj Hiremat is directed to accept notice. RC Hiremat.
ಅಲ್ಲ ಅದರಲ್ಲಿ RC Hiremat ಅಂತ ಇದ್ದಾರೆ.
ಇಲ್ಲಿ is appearing, my lord. Shivraj Hiremat.
Gram Panchayat Lokur.
Gram Panchayat.
Lokur, Dharwad.
ಧಾರವಾಡ ಇಲ್ಲ ಅಂತ ಅವ್ರು. ಅದಕ್ಕೆ RC Hiremat.
RC Hiremat is directed to accept notice for respond number 7. Connect the above matter with WP number 1000277 of 2024. The response are restrained from establishing a retail outlet in and around the property covered under survey number
255
bar
bar
1
4, my lord.
in and 255 bar 4. Yav village, Lokur
Not
village,
Lokur.
Dharwad Taluk,
Yes.
Dharwad district.
Plot
Till the
1
next
and
date
2.
of hearing.
Plot 254 bar 4, plot 1 and 2, my lord.
Relist 12th idea ado. Out. Relist on 12th. Counsel for the petitioner furnished 2 sets of the petition along with annexures by end of day today.
Please, my lord.
9, Dhyan Bandi. Pass over, my lords.
Pass over.
Please.
10, Pallavi Pachapura.
Annexure A, B, and C, my lords, are the demand notices issued by the respondent number 2, CMC, my lords, calling upon the petitioners to pay the difference in the property tax along with penalty, my lords, and accrued interest for a period, my lords. Annexure A may kindly be seen, my lords, page 25. This is with respect to petitioner number 1, my lords, for a period from 2012-13 to 2024-25.
1213 5 6 ಇದೆ ಇಲ್ಲಿ.
That is annexure B, my lords.
Hmm.
That is with respect to petitioner number 2 and 3. 2005-6 to 2025, my lords.
Petition number 1 is 1213.
Please, my lords. Other
2
two
is
petitions,
5 6.
5-6. Other two petitioners.
So what is the limitation period? 5 years, 6 years?
6 years, my lords. Preceding the year.
You will pay the balance from 6
Please,
years.
my lords. Annexure F, my lords, your lordship's order, my lords.
Page 59.
57, my lords.
59.
Particular matter, my lords.
And AGA accepts notice for respond number 1. Respond number 2 ಯಾರು?
B Sharan Basu. B Sharan Basu.
ಶರಣ್ ಬಸವ. ನೀವ್ ಹೇಳ್ಬೇಕು.
Please,
For the petitioner, not for the AGA to say that.
Sharan Basu.
B. Sharana Basava is directed to accept notice for respond number 2. The operation of annexure A, insofar as the petitioner is concerned,
Petitioner number 1, my lords.
petition number 1 is concerned, relating to the year 2012-13 to 2018-19, he stayed, subject to the petitioner making payment of the differential tax from the year 18-19 till date. insofar as
Excluding the
number-
interest and penalty, my lords. Excluding the interest and
excluding the
penalty.
interest and penalty. Insofar as petition number 2 is concerned, the operation of annexure B is state for the period 2005-6 to 18-19, same. Connect with WP 107645 of 2023.
And annexure C also, my lords.
Relist on 7-2 ಆಗಿದೆ. ಇವಾಗ 7-2 ಇಂದ ಎಲ್ಲಿ ಹೋಯ್ತು?
My lords, after that it was listed, my lords, they did not file any objections.
ಅದು ನೋಡಿ ಡೇಟ್ ಯಾವುದು ಅಂತ.
And annexure C also.
Annexure C, insofar as petition number 3 is concerned, from 2005-6 to 2018-19.
Please, my lords.
11, Shivardhan Patil.
Lord, damages have been imposed as per section 14B of the EPF Act, my lord. There is an alternative remedy to prefer appeal before CGIT, but since it is not functional, my lord, this petition.
ಇನ್ನ ಆಗಿಲ್ವಾ? ಆಗಿರ್ಬೇಕಲ್ಲ CGIT.
No, my lord.
ಮೊನ್ನೆ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆಗಿಲ್ವಾ?
I am informed that still it is not been functional.
We had directed appointment ಮೊನ್ನೆ ಏನೋ compliance report ಇಲ್ಲ, names have been sent.
Please.
Yes.
For limited purpose, my lord, till it is being functional. Similar orders have been passed, my lord, in the.
Yaar standing counselor.
PV Gunjal, my lords.
Shri PV Gunjal is directed to accept notice for respondent.
Prashant Mogli is appeared, Vinayak Kulkarni, now newly panels counsels to the Provident funds to the High Court.
Maybe.
Wrong submission.
He is also one of the counsels.
ಅವರು ಅದಾರೆ, ಪ್ರಶಾಂತ್ ಮೊಗ್ಲಿ ಇದ್ದಾರೆ.
Shri Prashant Mogli is directed to accept notice for respondent. Respondents are restrained from taking any coercive steps against the petitioner in pursuance of annexure A till the next date of hearing. Relist on 4th March.
Please, grateful, my lords.
12, Srikanti Patil.
Lord, Lord, the FSL, my lord, Bangalore, my lord, as per the directions of this honorable court, my lord, in one of the writ petition, earlier writ petition, direction was, my lord, issued to, my lord, FSL, my lord, RFSL, for making investigation in respect of thumb impression of, my lord, defendant number 1. Lord, the report has been submitted, my lord, by the forensic lab. Lord, challenging that, my lord, the objection statement were filed, and, my lord, application was, my lord, filed, Lord, for summoning the said expert. Lord, he has been cross-examined. Lord, we, my lord, argued the matter, my lord, in respect of the commission report, saying that, my lord, it is not by due procedure law, and proper procedure has not been followed by the expert at the time of examining, my lord, the thumb impression of defendant number 1. Lord, challenge, my lord, the trial court, my lord, in the suit. Lord,
where is the impugned order? 2111.
Impugned order, my lord, at page number annexure M.
Annexure M as ನಿಮ್ದು 50 page ಇದೆ. Page number ಏನು?
Page number 96, my lord.
96. Yes.
Now, my lord, lordship may kindly see, my lord, page number 99 for a moment.
Yes.
Lord, in that, my lord, in the middle portion of, my lord, the paragraph, it starts at, my lord, it is to be noted that. Lordship got it, my lord. May I read, my lord, for a moment? That it is to be noted that the court is an expert of an expert. Therefore, whether the court commissioner has followed the proper procedure or not, and the opinion given by CW1 is acceptable or not, could be considered at the proper stage. It is pertinent to note that CW1 has given his opinion only, and it is not the conclusive proof, and it is only the opinion. Therefore, the purpose of for the above observation, this court declined to reject the report filed by the CW1. Hence, following orders. But here, my lord, my lord, as per, my lord, the directions of, my lord, this honorable court, my lord, the RFSL, my lord, Withdrawal of Bangalore, my lord, is directed to, my lord, to do the, my lord, examination of the said document and submit the report. My lord, now, my lord, one person in my, my lord, writ petition.
Where is the commissioner's report?
Lord, commissioner report is, my lord, Lord, page number 73.
Seventy-three is issued by,
Lord, this is a report, my lord, issued by my lord. By the assistant, my lord, of commissioner of police, my lord, Hubli Dharwad, my lord.
there's a FSL in Hubli Dharwad.
There, my lord, there is a direction from the court to, my lord, referring the said, my lord, matter to, my lord, the RFSL, my lord, Bangalore.
There is no RFSL at Bangalore. There is a FSL at Bangalore.
Please,
RFSL is at Hubli.
Please.
So if there is a RFSL at Hubli, why should it go to Bangalore? He's an expert.
Please.
There's no personal malice.
But, my lord, in respect of he, my lord, having a permission regarding examination of the document, there is no order from the trial court or from the high court.
That's okay.
But here, my
This is
lord,
a
regarding
competent person, if when it has been referred to and it has gone to the RFSL having jurisdiction over this area, why should it go to Bangalore? That cannot cause you any
as per
prejudice.
the findings of the trial court, Lord, they say that, my lord, whether his report has to be considered at the proper stage, my lord, giving that finding. But here, when there are lapses, my lord, in respect of, my lord, examining the said document.
What is the lapse?
Please.
There's a lapse on that, you show
Lord,
us.
I have produced, my lord, the cross
Merely
examination.
sending it to Hubli is not a lapse.
Please, Lord, page number 90, my lord, annexure L. The examination of the said expert.
Yes. This will be considered when the final judgment is going to be passed.
Lord, the difficulty is, my lord, we have specifically made a direction, my lord, requested, my lord, given instruction to refer particular document.
Yes.
Regarding, my lord, the examination of thumb impression of defendant number 1. Lord, that has not been done by, my lord, the expert.
That you can take advantage of in your final arguments if something has not been done.
Lord, because
the commissioner report has been submitted. Now you are asking for the commissioner report to be rejected.
On the ground that, my lord, he has not done it, my lord, properly.
Petitioner is before this court seeking for the following relief. Notice to the
But I
respondent
have
is
challenged, my
dispensed
lord,
with
one submission.
in view of the proposed order to be passed.
I have, Lord, challenged one more order in respect of, my lord, directing, my lord, the defendant number 1 and 2. That is annexure Q, my lord.
Page
number 108. Lord, I have filed application, my lord, seeking, my lord, necessary direction, my lord, from the court to produce the original seal deed, which was executed, my lord, by defendant number 1 in favor of defendant number 2. Since, my lord, I am the plaintiff, filed a suit for special performance of contract. Lord, during the pendency of the suit, my lord, the defendant number 1 has executed a seal deed in favor of defendant number 2. In fact, my lord, by perusing, my lord, the seal deed, certified copy of the, my lord, the seal deed has been produced before the trial court. By going through, my lord, the seal deed, certified copy, it is not the defendant number 1 who has executed it, because on the
as defendant number 1 denied it.
Lord, because she is in collusion with, my lord, defendant number 2.
As if defendant number 1 has not denied it, how can you ask for it?
Lord, my grievance before the court is, my lord, that it is not a defendant number 1 because her photo is not there in the seal deed. Her thumb
She is
impression is
represented
not
by
there.
a GPA holder.
No, my lord, not by the GPA holder. Even there is no reference to the effect of, my lord, power of attorney.
Defendant number 1 is examined as DW1 through her GPA holder. During cross of DW1, defendant number 1 has filed affidavit in person to show that she has
GPA
executed
holder?
seal deed in favor of defendant number 2. The affidavit filed is only for the purpose of his presence and not to this own. So, yes.
Lord, execution of seal deed by defendant number 1 in favor of defendant number 2 has not taken place. That we have disputed.
A registered document, Mr. Kant. How can you say that?
Lord, the photograph, Lord, because for that reason, Lord, they have not produced the original seal deed.
Dispensed with. By way of the above petition, 2 orders passed in OS number 205 of 2010 have been challenged. OS number 205 of 2010 had been filed by the petitioner seeking for specific performance.
Please.
And certain other reliefs. In the said suit, an application having been filed for appointment of for referring certain documents to a handwriting expert under Order 26, Rule 10, capital A of the Code of Civil Procedure. The same was rejected, which came up before this court in WP number 100294 of 2024. And this court, wide order date 27th January 2024, had referred the matter in the RFSL Belgaum, not Bangalore.
It is done by my lord, earlier
The
my lord,
matter was referred to RFSL Belgaum,
Belgaum, later on it was modified.
was directed to be, was referred to the RFSL Belgaum, which came to be modified by order dated
Lord, order dated my lord 1/3/2024.
page.
Lord, that is not the my lord, it is a separate order.
Wide order date 1/3/2024 and forwarded to Superintendent Fingerprint Bureau, Madiwala, Bangalore, for doing the needful. When the same was, instead of the same being sent to Fingerprint Bureau, Madiwala, it was sent to the Fingerprint Bureau though it was sent to the Fingerprint Bureau, Madiwala, a report of the fingerprint expert at Dharwad had been submitted to the court. The fingerprint expert has been cross-examined, and thereafter an application came to be filed by the petitioner seeking for rejection of the report submitted by the commissioner. Only page.
Lord, impugn order is my lord.
which came to be dismissed by order dated 21/11/2024. It is the said order, one of the orders challenged is the said order. Another application had been filed by the petitioner under order 11 rule 14 of the Code of Civil Procedure, seeking for a direction to the defendant number 2 to produce the original sale deed executed in favor of defendant number 2 by defendant number 1 on the ground that defendant number 1 has not executed any sale deed in favor of defendant number 2. The said application came to be dismissed while the impugned order dated
Lord,
24/11/2024. 24,
23 my lord.
23. It is the said order also which is under challenge in the present proceedings. Learned counsel for the petitioner submit that when this court had initially directed the matter to be referred to the Regional Forensic Science Laboratory, Belgaum, and subsequently modified it by order date 1/3/2024 for examination to be conducted by Superintendent Fingerprint Bureau, Madiwala, a report of the fingerprint expert of Dharwad could not have been issued. As such, the trial court ought to have rejected the said report submitted by the fingerprint expert at Dharwad, the same not being in accordance with the order passed by this court. Insofar as the application under order 11 rule 14 is concerned, his submission is that there is no sale deed which has been executed by defendant number 1 in favor of defendant number 2. What has been produced is only the certified copy, and for purpose of verification of the fact of execution of sale deed by defendant number 1 in favor of defendant number 2, the original document is required to be produced. And as such, he submits that both the request for rejection of the commissioner's report as also the application under order 11 rule 14 was required to be allowed by a trial court. Having perused the order passed by a trial court, as also having perused the report submitted, it is seen that the covering letter is issued by the Superintendent Fingerprint Bureau, Madiwala, enclosing the report of the fingerprint expert at Dharwad. There being a fingerprint expert at Dharwad, the examination by the said expert at Dharwad cannot be found fault with. Initially, there was only a forensic science laboratory at Bangalore. Subsequently, there are regional forensic science laboratory which are being established at different commissionerates in the state. And going forward, it is expected that FSLs would be established at each district with all the facilities as directed by this court in WP number so and so. In that, the purpose, the purport and intent of the same being for providing the forensic science services at each district. In the present case, at the time of passing of the order dated 1/3/2024, it was not known to this court as to whether there was a fingerprint expert attached to the Assistant Commissioner of Police Office at Hubli, Dharwad. In that view of the matter, the Superintendent Fingerprint Bureau, having forwarded to the Assistant Commissioner of Police Office in Hubli, Dharwad for examination by the fingerprint expert posted there, cannot be found fault with. Whether, so far as the merits of the report are concerned, the same would be subject to the result, the same would have to be examined by the trial court in terms of the arguments which have been advanced, the evidence led and arguments which have been advanced. The report cannot be rejected only on the ground that the examination is done by the fingerprint expert at Hubli, Dharwad and not by the fingerprint expert at Madiwala, Bangalore. Insofar as the second contention is concerned, the application under Order 11 Rule 14 was filed for production of the original sale deed executed by defendant number 1 in favor of defendant number 2. The plaintiff contending that defendant number 1 has not executed a sale deed in favor of defendant number 2. There's a positive affirmation by defendant number 1 that defendant number 1 has executed a sale deed in favor of defendant number 2. There being no denial by defendant number 1, the question of plaintiff denying a registered sale deed to have been executed by defendant number 1 in favor of defendant number 2 would not arise. As said, there would be no requirement for production of the original sale deed executed by defendant number 1 and 2. No grounds being made out, the petition stands dismissed.
Please.
Case.
Suit was dismissed for default and later on it was restored.
13, Harish Maigur.
Yes, Mr. Maigur.
Order is at Annexure J. For my lords, resolution number 7 was challenged by the respondent 4 to 6. They have nowhere concern, my lords, and it has challenged under section 269 of Karnataka Panchayat Raj Act by filing an appeal. For 30 days limitation is there, my lords. Resolution was granted on 12/7/2023.
Yes.
And appeal was filed on 25/6/2024 after lapse of 11.5 months. So, my lords, no application for condonation of delay was filed. So, my order passed by Panchayat came to be set aside. And against that, my lords, I have preferred an revision. Revision without issuing notice to the other side, my lords, one line order came to be passed as per Annexure G. Kindly, page 100.
Yes, 100.
Please. Without considering my revision, and my lords, just passed one line order confirming the order passed by the my lords, sir.
Issue notice
1 to 3, my lords,
Respondent number 4 to 6, returnable by 12th March. Is there 1 to 3 arrow?
Bhushan Kulkarni is up.
Bhushan Kulkarni is directed to accept notice for respondent number 1 to 3.
Please.
Counsel for the petitioner to furnish 2 sets of the petition and along with annexures on the said counsels. The operation of the order dated 8/10/24 at Annexure G. Stay ಮಾಡಿ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ.
ಅಂದ್ರೆ ನನ್ನ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ನನ್ನ ಹೆಸರು ಇದೆ, ಅದನ್ನ ಡಿಸ್ಟರ್ಬ್ ಮಾಡಿ ಡ್ಯೂ ಟು ಪೊಲಿಟಿಕಲ್ ಪ್ರೆಷರ್.
Annexure J stay ಮಾಡಿ ಏನು ಪ್ರಯೋಜನ ಇಲ್ಲ.
ಅಲ್ಲ my lords, because annexure J ಮತ್ತು G, the order resolution is cancelled. So entering my name in record of right, in view of that order, my lords, by putting political pressure, my lords, they are taking benefits.
The respondents are restrained from, ನಿಮ್ಮ prayer ಕೇಳಿರೋದು ಸರಿ ಇಲ್ಲ ಅಂತ. Respondents are restrained from taking any action in furtherance of the order date 8/10/24 at annexure G till the next date of hearing. Process fee and copies to be furnished by end of day 10th February, failing which the interim order will stand automatically vacant.
14, Sonu Suher.
I am for petitioner, my lord.
Yes.
Writ of certiorari, my lord. Defendant petition, my lord. Petitioner seeking recalling of further examination of PW1, my lord.
At what stage was it filed?
We challenging IA-12, my lord.
ಹೇಳಿ.
Earlier, my lord, we file IA number 9, my lord. IA number 9 ಅಲ್ಲಿ ನಮಗೆ ಒಂದು ಚಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, my lord. On 29/2024 ಗೆ ಒಂದು ಚಾನ್ಸ್ ಕೊಟ್ಟಿದ್ದಾರೆ, my lord. After 1/10/2024 ಗೆ ಅಡ್ಜರ್ನ್ ಮಾಡಿಬಿಟ್ಟು ಡಿಫೆಂಡೆಂಟ್ ಪ್ಲೇಂಟಿಫ್ ಎವಿಡೆನ್ಸ್ ನಿಲ್ ಮಾಡಿ ಪೋಸ್ಟೆಡ್ ಫಾರ್ ಡಿಫೆಂಡೆಂಟ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದಾರೆ, my lord.
For cross of PW1 and 2.
ನಿಲ್ ಮಾಡಿದ್ದಾರೆ, my lord.
To lead evidence of PW1 and 2.
Plaintiff ಪಿಟಿಷನರ್ ಕೌನ್ಸಿಲ್ ಅವರ ಇಲ್ ಹೆಲ್ತ್ ಇಂದ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, my lord. ಬಟ್ ಅವತ್ತಿನ ದಿನ ಪಿಟಿಷನರ್ ಅಂಡ್ ಹಿಸ್ ಸನ್ ಅವ್ರು ಅಪಿಯರ್ ಆಗ್ಬಿಟ್ಟು ಫರ್ದರ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಗೆ ಟೈಮ್ ಕೇಳಿದ್ದಾರೆ, my lord. ಬಟ್ ಕೋರ್ಟ್ ಇಸ್ ನಾಟ್ ಕನ್ಸಿಡರ್, my lord. ಕೈಂಡ್ಲಿ ಒನ್ ಚಾನ್ಸ್, my lord.
So this one is issue emergent notice to respond number 1 to 3 returnable by 15th April.
Interim order may be
further proceedings in OS number 133 of 2021 pending on the file of the principal senior civil judge Belgavi is stayed till the next date of hearing. Process fee and copies to be furnished by end of day 10th February. Acknowledgement of service on the counsel for respondents to be filed by end of day 14th February, failing either of which the interim order will stand automatically.
Much obliged, my lord.
15, Dear Lord Khan.
Petitioners is a case wherein her date of birth was entered by her relatives at 15/4/1999.
Correction.
Correction is
Yaar say first respondent.
Sole respondent is represented by Bhushan Kulkarni.
Shri Bhushan Kulkarni is directed to accept notice for respondent. Counsel for the petition furnished 2 sets of petition along with annexures set. Relist on 13th.
Please.
16, Santosh Raut.
Please, ma'am. I have filed wakalat after obtaining NOC from Santosh Raut.
Yeah,
It is RP, my lord, sir.
Counsel who has argued.
Different from.
Please. BV Somapur's name may kindly be shown in the list.
Yaar who had appeared?
BV Somapur.
BV Somapur has filed wakalatnama for the petition, review petitioner. Registry is direct print his name as such and delete the name of Shri Santosh B. Raut and AD Shilendar as that appearing for the petitioner.
Please, please, ma'am. Kindly on Tuesday.
At the request of counsel for the petition, relist on 13th.
Please.
17, Tunjay Tata Pangi.
Complaint. Last occasion, my lords have
Registry 81 days for recall.
Recall.
ಏನಕ್ಕೆ recall ಮಾಡಬೇಕು? ಮರ್ತೆ ಹೋಗಿದ್ರೆ ಹೆಂಗೋ ಕೇಸ್ ಮರ್ತೆ ಹೋಗ್ಬಿಡಿ. ಏನಕ್ಕೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದ್ದು?
Steps to be in respect of respondent number, my lords,
This is dated 9 June 22.
Some no respondent.
Office objections have not been complied with.
Office objection complied, my lords.
ಯಾವಾಗ ಮಾಡಿದ್ರಿ?
ಅದಕ್ಕೆ recalling ಕೇಳಿದ್ದೆ ಅದು office objection, my lords. The order dated
to comply. ಎಲ್ಲಿ ರಿಪೋರ್ಟ್? ಎಲ್ಲಿದೆಯಪ್ಪ ರಿಪೋರ್ಟ್ ಕಂಪ್ಲೈಂಟ್ ಅಂತ? Has complied with authorization. The above petition had been dismissed for non-prosecution by order dated 9 June 2022 on account of non-compliance with the office objection. Hence, IA
1 of 24, 2 of 24.
2 of 24 have been filed for recalling the said order. Pending consideration of the said application, this court permitted the counsel for the petitioner to comply with the office objection. Registry has put up a note that the office objection have been complied with. In that view of the matter, IA 2 of 20, accepting the reasons stated in support of IA 2 of 22, the said application is allowed. Delay of 881 days is condoned, subject to payment of cost of rupees 10,000.
Reasonable.
5,000 to the Advocate Clerks Association. By allowing IA 1 of 24, the order dated 9/6/24 is recalled. The petition is restored to file.
In item number 3 is concerned, my lord, the paper publication in respect of respondent number 4A and B, 12A and
ಸತಿ ಹೋಗಿದೆ notice.
notice.
3 times are so.
ಇಲ್ಲಪ್ಪ, ಒಂದೇ ಸತಿ.
ಅಪ್ಲಿಕೇಶನ್ ಮೇಲೆ ಒಂದೇ ಸಲ ಅದು.
I'll take first step.
IA 3 of 24 is being filed for subservice by way of paper publication. As regards proposed respondent number 4A and B, 12A and 13 capital A. A perusal of the records indicate that notice to them has been only issued once. Hence, the application is not maintainable. IA 3 of 2024 therefore stands rejected, directing the counsel for the petitioner to make payment of process fee in respect of those respondents.
Please.
Then IA 2, you know.
2, my lord, recalling the order dated 17/11/2011, my lord. Other complaints irodu.
Dismissed. Steps.
Steps.
2011 in the
earlier council, my lord, has passed away.
Who was appearing?
Rajsekhar Pasapur, earlier, my lord.
ಯಾವಾಗ?
2008 ಇಂದ onwards.
8
in the, along with me, my senior Mrityunjay Tata Bangi.
ಆಮೇಲೆ ನೀವು ರೆಕಾರ್ಡ್
ಆಮೇಲೆ ರೆಕಾರ್ಡ್ ಮೇಲೆ ಬಂದಿದೆ.
Accepting the reasons stated in support of IA 2 of 25, the delay of 4070 days in filing a recall application for recalling the order dated 17/11/2011 is allowed since the counsel for the petitioner is stated to have expired and a new counsel appeared much subsequently. IA 1 of 25 is allowed. The order dated 17/11/2011 is recalled.
Item number 6, 7 or 8 are concerned, notice has to go, my lord.
During the pendence of the above matter, respondent number 6 is expired. Issue hence IA 1, 2 and 3 of 2020 has been filed. Issue notice on IA 1, 2 and 3 of 2020.
And also 10.
Respondent number 6 and respondent number 3 have expired.
Please.
Hence IA 1 to 6 of 2020 have been filed. Issue notice. Returnable by 16th April.
Memo along with main matter.
The memo has been filed.
Treating respondent number 3 to 8.
That respondent number 9 who is expired, that respondent number 3 to 8 are the legal representatives deceased respondent number 9. The said memo is accepted. Respondent number 3 to 8 are treated as legal representatives deceased respondent number 9. Counsel for the petitioner to carry out necessary endorsement in the cause list, in the cause title. 10A to C ಯಾರು?
ಶಿವರಾಜ್ ಮುದೋಡ್.
ಯಾರು ಬಂದಿಲ್ವಾ?
ಯಾರ ಪೇರು ಬಂದಿಲ್ಲ?
ಇಲ್ಲ, ಅವರು ಎಂಟೈರ್
ನಾವು ರಿಸ್ಟೋರ್ ಆದ್ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕು.
ಪ್ಲೀಸ್.
A memo dated 10/1/25 has been filed by Sri Shivraj Mudol seeking for permission to retire from the matter. The memo is accepted. Sri Shivraj P. Mudol is discharged from appearance on behalf of respondent number 10A to 10C. Registry is issue notice to respond number 10A
A
to
to
C,
C. Please.
returnable by same date.
Next, I
In those IS.
4 expire ಆಗಿದೆನಾ?
Please.
Notice ಹೋಗಿದ್ಯಾ?
7 to 9.
Yeah.
ಇಲ್ಲ, abated.
Respond number
Notice
2.
has to go.
2 ಹೋಗ್ಬೇಕು. 4A to B substituted service ಹಾಕಿದ್ದೀರಾ. Already notice ಆಗಿದೆ. Reissue notice on IA
7 to 9.
7 to 9.
and 10 to 12. IA
And also 13 to 15.
15
Please.
of 2020, returnable by 15.
Please, oblige.
Process fee and copies to be furnished by end of day 10th February.
Please.
Proper process fee and proper copies to be furnished by end of day 10th February.
Please.
If the proper process fee is not furnished and adequate copies are not, proper process fee is not paid and adequate number of copies are not furnished by 10th February, the order of dismissal earlier passed will again come back into force.
Please.
18 J Shetty.
Yes, what is the
The
memo? of
application is filed by Malad certain additional documents. Subsequent to the event, Malad, there is also inquiry conducted by the competent authorities.
Reference to IA1,
My lord, I will file, my lord. 1 week time, my lord.
ಏನು
ಅಲ್ಲ,
objection?
I filed the memo of calculation along with the account extract.
ನಿಮ್ಮ
my
ಮೆಮೋ
lord.
ಆಫ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ತಗೊಳ್ಳೋಣ, ಈ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ತಗೊಳ್ಳೋದ?
ಅಲ್ಲ, ಅದಕ್ಕೆ ನಾ ಕಳ್ಸಿದ್ದೇನೆ ಸ್ವಾಮಿ, ಒಂದೆರಡು ಕ್ಲಾರಿಫಿಕೇಶನ್ಸ್ ಇದೆ ಅವರಿಂದ.
What document are you producing, Mr. Shah?
Malad, the inquiry has been conducted so far as the
It's a public document.
public.
Yes, ma'am.
How can you have objection?
Please, my lord, in
You
before.
can
my lord,
argue on that, not object to production.
ಅದೇನು
Accepting the reasons stated in support of IA 1 of 24, the additional documents have been produced by the petitioner is taken on record, subject to any arguments to be advanced thereon by respondent number 1. The memo of calculation filed by respondent number 1 is taken on record. Yes. Ready?
with regard to, along with memo of calculation, my lord, I produced the account extract, my lord. My lord, they are, my lord, disputing this.
Argument ready na?
ಇಲ್ಲ, next date ಮಾಡ್ತೀನಿ.
At the request of both the councils, released on 19th.
Please.
Entry mart. Entry mart may kind.
Interim order earlier granted is extended till next day.
19 Surabhi Kulkarni.
That's challenging the endorsement at annexure.
My lord, I appear for respondent 4. I request for week's time, my lord. I want to file objections.
Okay.
I have to file objections, my lord. Our corporation has filed objections. Order is passed by the corporation for regarding
Contesting
payment of profit.
respondent is corporation, my lord, sir.
Next, layout is approved by Buddha. Layout is approved by Buddha, my lord. So therefore I want to file objections next week.
Arvind, ನೀವು ಫೈಲ್ ಮಾಡಿದ್ದೀರಾ?
Please, my lord.
The impugned endorsement is issued by corporation, my lord, sir.
Change of land use
ನೀವು
was
acquire
given by.
ಮಾಡ್ಬೇಕಾ ಅವ್ರು acquire ಮಾಡ್ಬೇಕಾ?
ಅಲ್ಲ,
Yeah,
change of
let's-
land use was approved by the Buddha.
Let's, this petition property has been used for, annexure A is the impugned endorsement. Annexure F is the sanction plan by Buddha, my lords.
No, this is for compensation.
Compensation. My lord, some of the portion of the property of the petitioners has been used for road back in the year 2009 without acquisition of
By
law.
whom?
My lords, the corporation has laid down the road.
Corporation.
Please. And my
Corporation
lords,
ಬುಡಾನ?
Let him.
Corporation,
There is
corporation,
some-
not
ಮತ್ ನಿಮ್ದೇನು objection ಬೇಡ. ಸುಮ್ನೆ ಏನಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಮಾಡು? Yes.
No, my lord, because as my layout is approved by Buddha, and there's the owner has himself has handed over the Ida Cordway Road. That's why I want to file objection.
They have handed it over to Buddha and you got the corporation to form the road.
The corporation will form the road.
ನಿಮ್ದೇನು objection ಹೇಳಿ? Why do you need to file objection?
Because layout is approved by Buddha, that's why I want to file objection.
Either we'll record your statement that layout has been formed by Buddha.
Please, ma'am, please.
lords, the impugned endorsement is at annexure A. Relevant page, my lords, 23.
Yes.
The representation was filed by petitioner seeking for acquisition of the property in accordance with law and payment for payment of compensation, my lords. Page, para 15, my lords, at page number 23.
Yes.
The representation has been rejected, stating that the petitioner has executed a release deed in favor of Buddha. On the basis of all the documents furnished by the petitioner, Buddha has approved the single layout plan. The said layout plan was approved by the Buddha under its order so-and-so, dated 21/1.
Yes.
It's, my lords, the date is wrong. I have carefully perused the plan approved by Buddha, and they have clearly demarcated the area that is to be left for road widening. The plan approved by Buddha bears the signature of the applicant, M.J. Sita, and that of her consulting engineer. I have also perused the conditions imposed by Buddha while granting permission for change of land use. Condition number 4 clearly states that in the approved layout, area reserved for road and open space shall be transferred to local authority free of cost. Hence, the petitioner, after obtaining the permission of change of land use, is stopped from contending contrary. As per section 32, subsection 5 of Karnataka Urban Development Act, states that the authority may require the applicant to deposit before sanctioning the application the summons necessary for meeting the expenditure for making roads, side drains.
Where is the plan sanction?
Mullards, it is at Annexure F, page number 47, Mullards. It was a single layout plan, Mullards. Page 47, Mullards.
The plan is at page 52.
Please.
This is not the plan sanction. Single layout.
Let's they rely on clause 4 at page 48 in the sanction.
Let's see the plan.
Please.
Your CTS number
5384, Mullards.
84. This is for widening of existing road.
Please.
Not for, it's a single layout plan.
No, it was earmarked for the widening of the road, Mullards. Initially, Mullards, the petitioner.
Yes, Arvind.
Please, the petitioner's claim is that the original owner was Mr. Anant Gundappa Hulbatti. He had executed a lease deed in favor of the petitioner. My lords, may kindly see the petition at para 2 of the petition may kindly be seen.
Yes.
It says, it is submitted that the subject matter of the present writ petition is plot number CTS number 5384, measuring 559 5 by 9 square yards.
Yes.
Please. They claim that they have become the owner by virtue of a sale deed executed by the original owner. Sale deed may kindly be seen at page number annexure D, page 34. It commences from page number 34. 35 may kindly be seen.
Yes.
Para 1, lots, may I read lots?
Yes.
Whereas the vendor are the absolute owners of the property bearing CTS number 5384 so and so Belgaum, which is shown in the city survey records as ad measuring about 599.5 square yards. However, remained, which is more particularly described in the schedule written under the foot of this deed. Now, let's kindly see the schedule. What has been sold to the petitioner?
Sold is only 233.7.
Please, page 39. Schedule is also given.
Yes.
Original owner has sold only insofar as 233.78 square yards.
Yes.
Subsequently, let's That is the
taking
reason
action.
he was insisting. That is one thing.
ಇನ್ನೇನಾದ್ರು ಇದೆಯಾ?
ಇದೆ ಇನ್ನೂ ಒಂದಿದೆ. And to what extent now they have gone to, because they have gone creating the documents, plus they file a suit also against the owner without making the any of these respondents as parties to this parties to the suit.
Yes.
That was filed on annexure H, page number 53. That came to be filed on 22/4/2009. Summons were issued. Within a span of 1 month, the suit was compromised between the original owner and the present petitioner, without there being he himself being the owner. He consents for claiming that he is the owner to the fullest extent. This is totally a collusive suit. Compromise petition was subsequently within a span of 3 months from the date of compromise. The petitioner number 1 executes a gift in favor of petitioner number 2. They went
For
on
599.
creating the registered deeds as well as suits.
Yes.
This is the second aspect. Third aspect is the other side is relying upon the annexure of page number 47. That is the conversion order passed by the Buddha.
Change of land use.
Page number 42. Clause number 4. ಅನುಮೋದಿತ ವಿನ್ಯಾಸದಲ್ಲಿ ಕಾಯ್ದಿರಿಸಿದ ರಸ್ತೆಗಳ ಮತ್ತು ಬಯಲು ಜಾಗೆಗಳ ಕ್ಷೇತ್ರದ ಮುಲ್ಕಿ ಹಕ್ಕನ್ನು ಸಂಬಂಧಪಟ್ಟ ಸ್ಥಳೀಯ ಪ್ರಾಧಿಕಾರಕ್ಕೆ ಮುಫತ್ತಾಗಿ ವರ್ಗಾಯಿಸತಕ್ಕದ್ದು. This was the one of the condition.
That condition is only if a layout had been formed. It's a single this one. That may not be clear. But this fraud which is being played is very much relevant.
Peruse that initially, since that portion was reserved for widening of the road, there appears to have been some.
Your sale deed is only for 299.
I agree, Thereafter, there has been a suit filed for declaration in
Which is a
respect of the.
collusive suit. So that's why we'll direct action against both you and your vendor.
It can't be a collusive suit, I and my vendor, entered into.
2 days you get a compromise.
Vendor intended.
Is it a contested
Initially, the vendor intended to sell the whole property. Since that portion was shown as reserved for
There
road
is no
widening.
sale deed as on today for 599. The sale deed is only for 233.
I agree, even
Your vendor is not
that
sold.
portion has not been acquired at all, The original vendor at least should have been paid the compensation.
Then he should come, not you. And you
Here
are creating these documents
the
by
corporation cannot be disputing this document because it is a civil
having them
dispute.
you are under notice. Please advise your clients properly. We'll direct the corporation to file criminal complaint against your client and also to take action against Mr. Ulial's officers. That is why we'll give them an opportunity to file an objection.
The intention of the vendors may be seen.
Your intention is completely fraudulent to cheat. You are under your clients. It is clearly
They
apparent.
intended to sell the whole property. Since
There is
it
no
was
sale deed,
reserved.
madam. Please tell your clients that they will be facing criminal action. Learned counsel for respondent number 4 seeks for and is granted 1 week's time finally to file a statement of objection. If objections are not filed by 13th, the 14th, the matter would be proceeded with. The submission of Shri Arvind Kulkarni, learned counsel for respondent number 3 and 5, is that the sale deed executed in favor of petition number
Petitioner number
1 is only to an extent of
233.78 square yards.
233.78 square yards. Thereafter, the petitioners have created documents to claim interest in 599.5 square yards. There being no right title and interest in favor of the petitioner as regards 599.5 square yards. The effort made by the petitioners is to defraud the corporation and obtain compensation when it is not so due. His submission is that a false application had been filed before the respondent number 4, seeking for change of land use for the entire extent of 599.5 square yards, which has been wrongly granted by respondent number 4 without verification of the title documents and the facts on ground. It is for that reason that respondent number 4 is granted 1 week's time to file a statement of objection explaining as to in what manner the change of land use was granted, the documents which were verified, as also the names of the officers who granted such change of land use in terms of Annexure F,
please.
dated 21/1/2008, released on 17th February. Mr. Ulial, please explain.
Yes, please, sir. I get
Obliged.
Though we'll be taking action against the petitioners, action will also be taken against you.
No, I'll explain, madam.
20, Ingraj Maradi.
For further hearing.
I'm the proxy advocate, my lord. The advocate on record, Lingraj Mardi, is out of station, my lord. May kindly be requested to post on 13th, my lord.
The request of counsel for the petitioner released on 13th.
Please, my lord.
21, V. Vidya. Raghvendra Rao.
She is held up, my lord.
Pass over, right?
One mara time ಕೊಟ್ಬಿಡು. ಅಲ್ಲ ಅವ್ರು held up ಇದ್ದಾರೆ.
The request of counsel for the petitioner.
Kindly, it may be urgent lordship.
ಅದೇ ಅವರು ಹೇಳಿದ್ರು. ಅವ್ರೇನ್ ಬೇರೆ ಏನು?
She has got
The request of counsel for the petitioner released on 20th.
interim order.
Interim order are there.
22, H.M. Darigon. H.M.
Pass
Darigon.
over. 2011 pass over.
23, Shuraj Balwali.
My lords, kindly have it on Monday, my lords. Kindly have it on Monday.
Amended cost title ಹಾಕಕ್ಕೆ ಏನು problem?
We'll file on Monday, my lords.
Wakalat is filed, my lord, on behalf of
R1 to R1A to E.
Yes, I have filed. And in the connected matter on behalf of appellant, my lord. Appellant
ಬರೀ ಅಷ್ಟೇ ಜನನ ಇರೋದು R1A to E.
ಹೌದು.
23.1 ಕೊಡಿ. R1A to E ಆಯ್ತು. R2 to 6 have been served.
They are served
ಅದರಲ್ಲಿ
and represented. In the connected matter, they are the appellants, my lord. So I filed wakalat on behalf of them also. MSA.
MSA, they are the appellants.
Appellants.
Petitioner 1A to E. Respond number 1 and 2. Are Narayan and Ravalu. First one, Kodi.
My lord, they are the appellants in, they are the petitioners in WP, my lord, 100264. They are the petitioners.
First matter, 264. Is 264. Is
MSC.
10058. ಎರಡು ಅದೇ ಅಂತ ಇಲ್ಲೇ ಇದೆ. ಓಕೆ. ನಾರಾಯಣನ್ ರಾವ್. ನಿಮ್ಮ ಹೆಸರು ತೋರಿಸಿದ್ದಾರೆ ಮತ್ತೆ ಯಾಕೆ ಫೈಲಿಂಗ್ ಆಫ್ ವಕಾಲತ್ ಅಂತ ಹೇಳಿ? ವಕಾಲತ್ ಫೈಲ್ ಮಾಡಿದೆ ಆಗಿರ್ಲಿಲ್ವಾ?
ಅವಾಗ ಮಾಡಿದ್ದಿಲ್ಲ.
23 Sri Sangam Kulkarni submit that he has filed wakalatnama for respond number 1A to E registry to verify. Counsel for the petitioner is granted a week's time to file amended cost title. The same is not done by 14th. The petition would be liable to be dismissed for non-prosecution. 23.1 Sri Sangam Kulkarni submit that he has filed wakalatnama for petition number 1A to E. Registry is directed to verify and print his name as verify. Shri Shivraj Badoli, who appears for the petitioners in WP 100264 of 2017, who are the respondents in MSA 1000058 of 2015 accepts notice for the respondents in MSA 1000058 of 2015. Registry is directed to print his name as such on 19th February.
Please, ma'am.
24 Mallikarjun Swamy.
20 pass over. ನೀವು ಇರ್ಲಿಲ್ಲ.
22 pass over ಆಗಿದೆ.
22 ready na?
We are ready,
22 put.
Covered by large judgment.
Covered ಅಂದ್ರೆ ready.
ಅಲ್ಲ my lord
Covered ಅಂದ್ರೆ not ready.
Lordship judgment maladi. But the land comes under the maladi restricted area of the maladi.
I have filed a statement objection in pair number 11, my lords.
During pendency of the writ petition, the honorable direct the central government to hold an inquiry, submit report. Now submitted by the report by the central government, stating that lands comes under the maladi restricted area maladi. In identical circumstances of this honorable court maladi allowed the writ petition maladi land acquired by the government.
Preliminary notification ಆದ್ಮೇಲೆ
Now ಇದರಲ್ಲಿ maladi KID challenge maladi position notice maladi.
ಫೈನಲ್ ನೋಟಿಫಿಕೇಶನ್ ಆಗಿದೆಯಾ?
Please.
ಯಾರಿಗೆ ಅಕ್ವೈರ್ ಮಾಡ್ತಾ ಇರೋದು?
ನಾವು maladi KIDB maladi.
So this is where is the location of this property? Survey number?
Survey number, I have filed the statement objection along with the inspection report, my lord. That is page number 44 of my statement objection.
Page 44.
Page number 44, my lord. Inspection report. That in pair number 2, my lords.
Same, it is, location is very close between two monuments.
ಬರುತ್ತೆ ಅದು ಇದ್ರ ಜೊತೆಗೆ ಬರುತ್ತೆ ಅದು. Is command
To acquiring like this for industrial area.
That is what, my lords.
You are supposed to protect everything.
We have to protect. That is what we, my lord, is come under the restricted area. That may be.
Petitioner is before this court seeking for the following reliefs. The submission of learned counsel for the petitioner is that the list in the present matter has already been considered by this court in detail, while it's ordered dated 31st August 2020 in WP number 69273-69277 of 2010. The land subject matter of the present petition is also situate between two protected monuments, though not within 300 meters of each of those monuments. In that view of the matter, I am of the considered opinion that the said order would be equally applicable to the present matter, and the land between two protected monuments cannot be used for any industrial purposes, putting at risk the protected monuments. In that view of the matter, I pass the following order. Writ petition is allowed. The notification bearing number so and so and so and so.
Next C and D maladi.
Very notice challenge.
Notice maladi subsequent notice challenge.
The notification date in. The certiorari is issued. The notice issued by first respondent dated 22/7/2009 at annexure C and D are quashed. You will challenge a model.
Subsequent point notification. Last occasion, not direct KID would produce the notification.
You are not challenging the notification.
But subsequent notice, position notice has been challenged before this.
ಅದು ಮಾಡಿಬಿಟ್ರೆ ಆಮೇಲೆ notification ಅಲ್ಲೇ ಇರುತ್ತೆ. What is the point? File an amendment application.
Please.
Last occasion, this court has directed.
ಅಲ್ಲ ಡೈರೆಕ್ಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿ ನೋಟಿಫಿಕೇಶನ್
KID ಕೊಡು ಅಂತ ಹೇಳಿದ್ರು ಬಟ್
ಅವ್ರು ನೋಟಿಫಿಕೇಶನ್ ಕೊಡ್ತಾ ಇಲ್ಲ ನಮಗೆ.
ಏನಿದಕ್ಕೆ ಇಷ್ಟು ಅಡ್ಜರ್ನ್ಮೆಂಟ್? ವಾಟ್ ಇಸ್ ದಿಸ್? ನೋಟಿಫಿಕೇಶನ್ ಕೊಡಿ ಕಾಪಿ.
Soundable granted in interim order in day 2011.
Notification by KIDB, my lords.
I will place it, my lord. They are sought for amendment. I will place it. Final notification.
When? Tomorrow. Monday.
Monday ಆಗಲ್ಲ.
Please.
Tuesday.
For respond number.
Tuesday ತಗೋ, Monday ಆಗಲ್ಲ.
1 seeks for and is granted 2 days time to place on record the notifications, both preliminary and final, perpetually under which the land of the petitioner has been acquired. Released on 10th.
Please. Fairly submitting, my lord, the land is in restricted area. No development zone.
No development. ಅವರು ಮಾಡಂಗಿಲ್ಲ.
ಅವರು purport
ಬಕ್ವೈರ್ ಮಾಡಂಗಿಲ್ಲ, ಅವರು ಏನು ಯೂಸ್ ಮಾಡಂಗ, ಬರೀ ಅಗ್ರಿಕಲ್ಚರ್.
Intent of the, my lord, acquisition was to construct hotel by Taj.
Yes, that is.
Can't construct it there. Constructed elsewhere, not between them.
Please, highly obliged.
24, Mallikarjun Swamy.
During the course of the debates.
Counsel for the petitioner submit that she will carry out the amendment during the course. They relist on 17th.
Please.
If amendment is not carried out by end of day, the petition will be liable to be dismissed for non-prosecution.
Yes, please.
25, Sadiq Gudwala.
Ten days time is granted to make payment of process fee in respect of unserved respondent and compliance with the office objection. If neither are done, the petition would be liable to be dismissed for non-prosecution. If process fee is paid, issue notice to unserved respondents returnable by 22nd April.
26, Shunath Hegde.
Registry has raised office objection, my lord, with regard to the.
Recalling is pending.
ಹೌದು, recalling pending ಇದೆ.
Comply ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೇನೆ ಸ್ವಾಮಿ, ಒಂದಕ್ಕೆ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೀನಿ. My lord, since no relief is claimed against any other, my lord, we make the respondent number 1 to 3 as party, my lord.
Where is the impugned order?
My lord, annexure A, my lord. Annexure A passed by, my lord, Deputy Commissioner Dharwad, my lord, ULC. Page number 15, 15, my lord.
This notice to VR Belamkar, TR Belamkar, YN.
Yes, our ಇದಾರೆ ಸರ್.
ಇನ್ಯಾರಿದ್ದಾರೆ ಪಾರ್ಟೀಸ್ ಇದರಲ್ಲಿ?
ಅಲ್ಲ ಇಲ್ಲ, ಅದು ಅರ್ಲಿಯರ್ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿದ್ದಿತ್ತು, ಅವರಿಗೆ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗಿಲ್ಲ ಸ್ವಾಮಿ, ನಾ ಅದಕ್ಕಾಗಿ ಸಬ್ಮಿಷನ್ ಕೊಟ್ಟಿದ್ದೇನೆ.
ಇಲ್ಲಿ ಬರೀ ತುಕಾರಾಮ್ ಬೆಲಂಕರ್ ಸನ್ಸ್ ಆರ್ ಹಿಯರ್.
ಹೌದು,
ಅದು TR Belamkar is ತುಕಾರಾಮ್ ಬೆಲಂಕರ್.
ಹೌದು ಸರ್.
ವಾಟ್ ಅಬೌಟ್ VR and YN and MN? ಅವ್ರಿಲ್ಲ ಅಲ್ಲಿ.
ಅಲ್ಲ, ಅವ್ರು ಇಲ್ಲ ಅನ್ಸತ್ತೆ ಸ್ವಾಮಿ, ಅದಕ್ಕಾಗಿ ಮಾಡಿಲ್ಲ, ಅವ್ರು ಇಲ್ಲ ಅನ್ಸತ್ತೆ. ನಾ ಅದೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡ್ತೇನೆ ಸರ್. Since, my lord, the writ petition is filed by earlier advocate, my lord, since he has stopped the practice, my lord, I have to look into it.
What is your challenging annexure?
How,
You
sir?
asked only to furnish certain details.
My lord,
Details have to be furnished.
ಅಲ್ಲ, ನಾಟ್ ಮೇಡ್ as parties ಅಂತ ಹೇಳಿ ಕೇಳಿದಾರೆ, ಯಾರು ಅಂತ ಹೇಳಿ.
ಆಯ್ತು, ನೀವು even if we accept that,
Please.
annexure A is only asking you to furnish some details.
ಆಯ್ತು.
And details ಕೊಡ್ಲೇಬೇಕು.
Please, my lord.
But now in view of the repeal of the act, my lord, they are taking the benefit. ಈ notice challenge ಮಾಡ್ಬಿಟ್ಟು
Proceedings have
declare.
not culminated.
ಹೌದು, ಅದಾಗಿ
89.
ಏನ್ ಮಾಡಿದೀರಾ? ಪೊಸಿಷನ್ ತಗೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ, ಅದ್ ನಾನು ಅಸರ್ಟೈನ್ ಮಾಡಿದೆ, ಯಾಕಂದ್ರೆ ಇದು ಡಿಸ್ಮಿಸ್ ಫಾರ್ ನಾನ್ ಪ್ರಾಸಿಕ್ಯೂಷನ್ ಆಕ್ಟ್ ಸ್ಟೆಪ್ಸ್
ನೋಟಿಸ್ ಆಗಿರ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
And AGA accepts notice for respond number 1 to 3. He seeks for and is granted 10 days time to make his submission. Released on 24th February.
Please.
27, B.S. Sankti.
Petitioner is before this court seeking for the following reliefs. A memo dated 5/2/25 has been filed, which bears the left thumb impression of the petitioner and the signature of the counsel for the petitioner. It reads as under. Accepting the said memo and submission of the counsel for the petitioner, petition is dismissed as withdrawn. Pending IAS do not survive for consideration.
28, S.B. Hebballi. S.B. Hebballi.
Who is R2?
My lord, therefore classification must be changed as CFA, my lord. Chit Fund Act under birth.
CPC anfide. EP has been filed in furtherance of the order passed by the registrar. The proceedings in execution having been filed in furtherance of the order of the assistant registrar under section 71 of the Chit Funds Act 1982. Registry is directed to carry out proper classification of the above matter and list before the appropriate court.
Thank you.
29, S.M. Kalbat.
My lord, petition number 3 and 4 are the daughters of the petition number 1, my lord.
3 and 4 not found in the documents. Are the daughters of accepting the submission of the counsel for the petitioner, office objection seal number 41 is overruled. Yes.
The said land is granted to the petitioner father, my lord, namely Chanvasappa, my lord, Pujar. And thereafter the said land is, please. And the said, the said land is granted to the father of the petition, petition number 1, my lord. And thereafter the land is come to the dispute between the brothers and father of the petitioner, my lord. And the brother of the Chanpasappa, Rudrappa has filed the application before the Tahsildar, my lord, and seeking a mutation entry in his name, my lord. And the Tahsildar has rejected his application and agreed by the same the appeal is filed before the assistant commissioner, my lord. Assistant commissioner has mutated his name in the subject land, my lord. And subject land is 14/2, my lord, 2 acre 24 guntas, my lord. And thereafter the petitioner has filed the suit, my lord. Suit is came to be decreed, and as compromised, my lord. And in the said suit, my lord, the said property 14/2, Kshetra 24 gunte akara, it's fallen to the share of the petitioner, my lord. Petitioner number 1, my lord.
Yes.
Only the petitioner is seeking a direction to the respondent to mutate his name in the record of rights, my lord.
It was rejected by the annexure L.
Yes. M.
The reason?
Reason not that the present land comes under, since there is a dispute with regarding to the land tribunal proceedings are going on, pursuant to which
separate proceedings.
There is a order which have been passed under the land proceedings, land tribunal proceedings. And in the cultivation column at it has shown as 6. Mode of cultivation is shown as 6. So, my lord, on that basis, in the year 1980 itself, a land tribunal passed an order. With regarding to the subject property is concerned. So, my lord, he has issued a endorsement stating that this comes under the land, so your name cannot be entered.
Vasannagoda.
Your party illa alli.
Your party ilva?
Illa.
The said land is granted to the petitioner's father, my lord, in the year
Basannagowda, Basuwantagowda, Channabasannagowda. Channabasappa is what they are saying.
ಡಾಟರ್ ಆಫ್ ಚನ್ನಬಸಪ್ಪ ಪೂಜಾರ್ ಅಂತ ಇದ್ದಾರೆ. ಚನ್ನಬಸಪ್ಪ ಪೂಜಾರ್ ಅಂತ ಇದ್ದಾರೆ. ಅಲ್ಲಿ ಚನ್ನಬಸಪ್ಪ ಗೌಡ ಇದ್ದಾರೆ.
Chanbasappa Pujari is the father of the petition number 1, my lord.
Channabasappa Poojar.
ಹೌದು.
ಇದು Channabasappa Basagowda.
ಹೌದು.
Poojar ilwalla ಇಲ್ಲಿ.
ಇಲ್ಲಿ. Pujar, my lord, kindly see the page number 25, my lord. Column number 11, my lord.
Page number?
Page number 25, my lord. Annexure A5, my lord. Column number 11, my lord. Kotrappa Channabasappa Pujar. Kotrappa is the grandfather of the petition number 1, my lord. In the cultivation column number 1, my lord, 91 to since 2002, the.
But there are land reforms proceedings. The orders passed on 1/10/1980, which you are not challenged.
My lord, I will secure the land tribunal grant order, my lord.
ಇಲ್ಲ ಇದೆ. Secure ಅಲ್ಲ. You are not.
Kindly pass over, my lord. Kindly pass over, my lord.
We'll reserve liberty to challenge this if you want. Until then, they can't do it.
Kindly pass over, my lord.
Pass over.
Please.
30. Mallikarjun Madanalli.
Office objection is that, my lord, in the affidavit, my lord, annexure's name is to be stated correctly, my lord. Second, my lord, annexure E to be produced, my lord. Certified copy of the annexure E. It is, my lord, a computer copy, my lord, which have issued the
Council
Tahsil.
submission ಕೊಡ್ಬೇಕಲ್ಲ ಇಲ್ಲಿ ಬಂದು ನೀವು ಹಿಂಗ್ submit don't make us into a clerical post. Counsel for the petitioner seeks fund is granted 10 days time to comply with the office objection. Relist on 24th.
Please, ma'am.
31 CV Angdi.
10 days time is granted to make payment of process fee in respect of unserved respond number 4. If needful is done by 20th February, registry to issue notice to respond number 4 returnable by 22nd April. If needful is not done, relist on 24th for dismissal.
Only one submission. Here the respondent number 4 executed a fraudulent sale deed in favor of respondent number 5. Yes, ma'am. That's the one. It is. Yes.
32 Girish Hiremat.
For the petitioner, needful has been done, my lord.
Counsel for the petition submit that process fee has been paid. Registry direct issue notice to respond number 4 and 9 returnable by 16th April.
33 Sabil Ahmad.
10 days time, same order, 20th.
34 Prakash Badige.
Recalled order dated 28/18.
The notice against respondent 6 to 13 is dismissed, my lord. Hence, I filed a recall application.
Awaiting service of notice on respond number 6 to 13. Relist on 5th March.
Please. I may be dismissed.
ಬರದಲ್ಲ ಅವ್ರು ಬಂದ್ಮೇಲೆ
35 Anandar Kolli.
What is the memo?
Lord, they are seeking for a mandamus to consider their application for regularization of unauthorized cultivation. Form 53.
Has rejected the application for seeking regularization.
ಇಲ್ಲ ಇದರಲ್ಲಿ mandamus ಇದೆ. Annexure E to E series ಅಂತ ಕೇಳ್ತಾ ಇದ್ದಾರೆ.
Does not survive for consideration has become infructuous.
Yes.
Petitioner is before this court seeking for the following relief. A memo dated 4/2/2025 has been filed by the counsel for respond number 5, stating that the representation submitted by the petitioner has been considered and rejected, while order dated 28/1/2025. In that view of the matter, no mandamus could be issued, reserving liberty to the petitioner to challenge the said order of rejection. The petition stands dismissed.
Same, connected to same.
36 PM Shilwant.
Office objection is that I am not party to annexure E. I am challenging annexure E, my lords, wherein the order of status quo in respect of other other extent of properties is concerned, my lords. What happened is There it is a larger extent. Some portion of the land was cultivated by me and these petitioners. and they
Impugned
were
order
granted.
ಎಲ್ಲಿದೆ?
Annexure E, my lords, page number
31.
and relevant pages, page number 36. ಮೇಲೆ ವಿವರಿಸಿದ
31 ಅಲ್ಲಿ ನೀವು ಪಾರ್ಟಿ ಇಲ್ವಾ?
ಇಲ್ಲ ಇದ್ರಾಗೆ
13 ಇಲ್ಲ
ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಪಾರ್ಟಿನೇ ಇಲ್ಲ ಅವರು. They are not the parties in the before the land tribunal.
ಮತ್ತೆ how are you challenging this?
but I am affected by this order, my lords, for the reason Sadari last 3 lines, my lords. Sadari ಅವರಿಗೆ ಮೇಲಿನ
Page
36 ಆದೇಶ.
Yes.
ಆದೇಶದಲ್ಲಿ ಲಾಸ್ಟ್ 3 ಲೈನ್ಸ್. ಸದರಿ ಅವರಿಗೆ ಮೇಲಿನ 2.5 ಎಕರೆ ವಿಸ್ತೀರ್ಣ ಮತ್ತು 2.5 ಎಕರೆ ವಿಸ್ತೀರ್ಣಕ್ಕೆ ಗೇಣಿ ಹಕ್ಕು ಮಂಜೂರು ಮಾಡಲು ಉಳಿದ 17.80 acres ವಿಸ್ತೀರ್ಣ ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಲು ಭೂ ನ್ಯಾಯ ಮಂಡಳಿ. ವಿ ಫಾಲ್ ಅಂಡರ್ ದಿಸ್ 17 acres and 17.80 acres, my lords. ಸ್ಟೇಟಸ್ ಕೋ ಮಾಡಿದ್ದಾರೆ. ಬಟ್ ಆಕ್ಚುಲಿ it has been granted to us as per annexure A.
It is granted to you, it is granted. At the status quo.
ಅಲ್ಲ ಬಟ್ ಬೇರೆ ಎಲ್ಲ ಫಾರ್ ಮಾರ್ಟ್ಗೇಜಿಂಗ್ ಫಾರ್ ಟೇಕಿಂಗ್ ಲೋನ್ ಎಲ್ಲ ಅದು ಇದನ್ನ ಆಗ್ಬಿಡ್ತು.
ನಿಮ್ ಗ್ರಾಂಟ್ ಆರ್ಡರ್ ಇದೆ ತಾನೆ?
ಹೌದೌದು, ಗ್ರಾಂಟ್ ಆರ್ಡರ್. annexure A is my grant order, my lords. ನಮಗೆಲ್ಲ ಗ್ರಾಂಟ್ ಆಗಿದೆ. There are other ಇದು tenants also. It is a larger extent. Out of that they have been granted 5 acres. ನಮ್ದು ಮತ್ ಬೇರೆ ಎಕ್ಸ್ಟೆಂಟ್ ಇದೆ. ಬಟ್ ಉಳ್ಕಿದ್ದೆಲ್ಲ ಯಥಾಸ್ಥಿತಿ ಅಂತ ಹೇಳಿ.
ಅಲ್ಲ, in so far as the petitioners survey number is concerned is 281/C. This pertains to 281/2.
ಅಲ್ಲ that was renumbered as 281/C.
ಅದೇ
ಎಲ್ಲಿದೆ?
Form 10 may lord may at annexure page B2.
281C.
ಹೌದು.
280A.
ಹೌದು. ಅಲ್ಲಿ ಹಾಕಿರೋದೇ ಅವು. ಇಲ್ಲಿ 281/2. Land tribunal order is now at page 14 annexure A. Survey numbers are mentioned 449, 281/C, 280/A. The present land tribunal order is in so far as 281/2.
ಇದು C ಎಲ್ಲಿ?
At page
281 RTC ಎಲ್ಲಿ?
RTC, my lord. RTC mutation produce ಮಾಡಿದ್ದಾರೆ. At annexure D is the mutation 281/C.
37 acres, 47 guntas.
Yes.
281-1, 3 acres, 281-2, 22.80. 281C.
11 acres, 67 gunta.
ಹಿಂಗೆ 37 ಅಲ್ಲಿ ತೋರಿಸ್ಬಿಟ್ಟು ಅವ್ನು ಮತ್ತೆ 11 ಯಾಕೆ ತೋರಿಸಿದ್ದಾರೆ ಇದು?
The application which have been submitted at the land tribunal is 281/2, 281/2 and 281/A at page 33.
281-2, 22 acres, 80 guntas.
ಹೌದು.
22.8
ಹೌದು.
cents. ನಿಮ್ದು 281C.
ಹೌದು, ಇವ್ರದ್ದು.
As per your own mutation.
That is what I have said in the petition, my lords. Petition page number 5 may kindly be seen. First paragraph, last 2 lines, my lords. The land tribunal granted occupancy rights to one Raghavachar in respect of 281/2, old survey number 281/C. That is the old survey number. After grant.
That is not correct because your own mutation shows different. 281-2 is 22.80. ಅಲ್ಲಿ 5 acres ಕೊಟ್ಟು 17.80 ಯಥಾಸ್ಥಿತಿ ಅಂತ, ಅದು 22.80 ಬರುತ್ತೆ. 281/C is 11 acres, 67 cents. That is a separate classification, separate land. Page 26, mutation.
This is the mutation entry, my lords. That is the reason. First it was 281/2, ಆಮೇಲೆ 281/C ಆಯ್ತು. Out of this same extent, my lords.
ಅದು ಆಗಕ್ಕೆ ಸಾಧ್ಯವಿಲ್ಲ ನೋಡಿ. 281-1, 3 acres. 281-2 is 22.80.
22.80, my lords.
281C is 11.67.
ನಿಮ್ದು.
This order is passed as regard 281-2, not 281C. You are not affected by this.
ನಮ್ದು 281-2
ಹೆಂಗ್ ಬರುತ್ತೆ ನಿಮ್ಗೆ ಎಲ್ಲ 281C ಅಗರ ಬೇಡವಾ? 281C ಬೇಡವಾ ನಿಮ್ಗೆ?
ಅಲ್ಲ 281, that was earlier 281-2 ಅಂತ. That is what I have said, my lords.
You said wrong. You can't have both. They are two different properties.
Like page 33 is also clear.
Page
33. Survey numbers which have been mentioned and extent of land 22.80. So ಅದರಲ್ಲಿ remaining extent ಯಥಾಸ್ಥಿತಿ ಕಾಪಾಡಿ only in so far as 2.550 has been granted.
And AGA accepts notice for
1 and 2.
respond number 1 and 2. Notice to respond number 3 is dispensed with in view of the proposed order to be passed. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that while the aforesaid impugned order dated 16/3/2023 at Annexure E, the land tribunal has directed maintenance status quo in respect of 17.80 acres in survey number 281/2, and the said order of status quo adversely affects the petitioner on the ground that the petitioner's land is situated in survey number 281/2. A perusal of the documents would indicate that the application filed by the petitioner was for 281C, which has been granted in the proceedings of the land tribunal dated 14/10/1986. In pursuance of which Form 10 has also been issued in respect of 281C, measuring 3 acres. The mutation register extract produced by the petitioner would indicate that 281/2 measures 22.80 acres, and there is a separate reference to the land in survey number 281/**C measuring 11.67 acres. Thus, the land in survey number 281C being classified and numbered separately, it cannot be said that the land of the petitioner would come within 281/*2. As such, clarifying that the order, impugned order dated
16/3/23
is in relation to survey number 281/2 and not in relation to 281/**C. The petition stands disposed.
37, Sheeta Lakshmi Purli.
Issued to respond number 2 is
Classification is-
returned with the endorsement refused. In service in respect of respond number 2 is held sufficient. Registry is directed to print the name of respond number 2 with the endorsement refused.
Classification is wrongly mentioned and GMCPC, my lord. It has to be GMCFA, my lord. Chit Fund Act.
Idu chit fund. What is challenged is an order passed by the Assistant Registrar under the Chit Funds Act. Registry is directed to classify the same properly and placed before the appropriate bench.
38, SP Kandagal.
In this case, I may be permitted to withdraw the petition
Petitioner is before
with
this
the
court
liberty to
seeking
approach
for the
proper forum. With liberty to approach proper forum.
following reliefs. Memo dated 7/2/25 has been filed, signed by the counsel for the petitioner, which reads as under. Accepting the said memo and submission of counsel for the petitioner, petition is dismissed as withdrawn, liberty being reserved to the petitioner to approach the proper forum.
Accept note.
And reforms.
Accept notice, ma'am.
The DG accepts notice for respond number
Copy.
One.
ಆಮೇಲೆ ಇನ್ಯಾರಿದ್ದಾರೆ ಒಬ್ರೇನಾ for respond number 1.
Respond number 1 and 2.
1 and 2.
1 and
2 ಯಾರು
2 ತಹಶೀಲ್ದಾರ್ ಇದ್ದಾರೆ.
1 and 2.
39,
Copy ಕೊಟ್ಟು.
SP Kadapatti.
Petitioner is before this court seeking for the following reliefs. A memo dated 3/2/25 has been filed, signed by the counsel for the petitioner.
Liberty will also file a fresh petition on same.
In view of the office objection. ಏನ
They feel it is the level of. The petitioner.
ಸೀಲ್ ಹಾಕಕ್ಕೆ ಏನಕ್ಕೆ ವಿಡ್ರಾ ಮಾಡ್ತೀರಾ ಸೀಲ್ ಹಾಕಿ
ಅದು ಅವ್ರ petitioner trustee ಅಲ್ಲ ಇವೆಲ್ಲ. Trustee ಅಲ್ಲ. How the secretary filed a fresh.
ಟ್ರಸ್ಟ್ ಡೀಡ್ ಎಲ್ಲ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರ ಟ್ರಸ್ಟೇ ಇಲ್ಲ ಅಂತೀರಾ Only office objection raised is to affix the seal of the trust.
ಅವ್ರ petitioner trustee trust members ಅಲ್ಲ ಇವೆಲ್ಲ.
how can we give you on the same cause of action? Dismissed as withdrawn.
No, 1 to 4 I accept notice.
A does not survive with the AG accept notice for respondent number 1 to 4.
40. Pooja Saudatti.
10 days time is granted to comply with office objection.
Monday or Tuesday, my lord, as last date for admission is on 15th, I will
Education.
furnish the copies for the,
Petitioner seeks bond is granted 2 days time to comply with office objection. Released on 10th.
how much? obliged?
41. SL Matti.
For petitioner, appeal is directed to produce the typed copy of the manuscript annexure C and J, my lord. I have not read the manuscript and also the relevant portion is the typed copy.
Counsel for the petitioner submits that he would not be relying on the manuscript portion of annexure C and J. Accepting his submission, office objection CL number 28 is overruled. Yes.
The petitioner has filed the suit for partition and separate possession against the present respondent number 192 and his brother and sisters. That suit was decreed, my lord, at annexure A, my lord. I request this honorable court may kindly peruse the relevant page number 23, my lord.
23.
Annexure A, my lord.
Yes.
Additional issues framed on 19/9/2018, whether the dependent number 5, now the present petition number 1. Respond number 1.
Defendant number is the bona
Whether the
fide.
dependent 5 prove that he is a bona fide purchaser of suit properties bearing number PPC number 1773 and 1774. That issue is heard in the negative, my lord. Additional issue number negative.
Township.
Negative.
Yes.
Thereafter, the present petitioner has prepared an appeal bearing annexure B, my lord, bearing RA number 193 and 2019.
Additional issue.
Additional issues, whether the
Issue number 1, 2, 3, 4, 5. Additional issue 1.
one
additional
is
issue
in
2.
the negative.
Additional issue 1 in the affirmative.
Affirmative, yes, my lord. Sorry, my lord. Affirmative. He's a bona fide purchaser.
Ella mix up agu.
Yes, bona fide means purchaser. Next, being agreed by these findings, the present petitioner has prepared a RA, that is annexure B, my lord, judgment. Annexure B, my lord. Relevant portion, page number 62, my lord.
Yes.
The findings recorded by the trial court on the additional issue number 1 is set aside and additional issue number 1 is answered in negative. So the present petitioner, the respondent number 1, the present respondent number 1 is not a bona fide purchaser of the suitable property.
Yes.
Being agreed by this order, he has prepared a
RSA.
RSA. The RSA is pending before this honorable court, my lord. That is annexure E, my lord, page number 85.
Yes.
During the pendency of the appeal, the present respondent number 1 filed a suit bearing OS number 26/2010. That is annexure. That is annexure C, my lord, page number 65.
Yes.
That suit was decreed, my lord.
Yenanta, what is the relief?
The present respondent number 1 executed agreement of sale. Sorry, present respondent number 2 executed. Present respondent number 2 is the brother of present petitioner. Executed a agreement of sale in favor of those property. In respect of those property in favor of respondent number 1. That suit was decreed.
Yes.
While deciding the OS number 95 and RA, this findings was recorded by the trial court and come to conclusion that the present respondent number 1 is not a bona fide purchaser. Hence, I have filed an application during pendency of the OS, that is annexure, on basis of the
Application.
judgment. Annexure H, my lord. During pendency of the suit, I have filed an application impleading in the execution petition. Present respondent number 1 filed execution petition on basis of the judgment and decree passed in OS number 26/2010, annexure C, my lord.
26 is again for specific performance.
ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಿ he's a bona fide purchaser or not, that would be already decided. He is not a bona fide purchaser. But he has filed the execution petition for the execution of the judgment and decree passed in OS number 26/2010. In the execution petition, I have filed the petition pleading as a party in the execution petition on 13/6/2024. Annexure H, my lord.
Yes.
But the trial court passed an order on that IA on 23/1/2025. My application came to be rejected. And he is trying to execute the decree passed in passed in OS number 26/2010. Man. Implicit judgment at page number 151.
You did not produce the judgment.
But during pendency of suit, I have filed the application on.
Para 6 ಅಲ್ಲಿ the applicant has not produced any document along with IA.
Yes, my lord.
You decree produce ಮಾಡಬೇಕಾಗಿತ್ತು.
Fact is that Annexure H, my lord, may kindly be produced Annexure H dated 13/6/2014 during pendency of the suit.
ಆಯ್ತು, ನೀವು ಡಾಕ್ಯುಮೆಂಟ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡ್ಬೇಕಲ್ವಾ?
ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿಲ್ಲ ಸರ್, ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಲಿಲ್ಲ ಅವರು.
ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಇಲ್ಲಿ ನಮಗ್ ತೋರಿಸ್ತಾ ಇದೀರಾ, ಅಲ್ಲ ಅವ್ರಿಗೆ ತೋರಿಸಿಲ್ಲ ಅಂದ್ರೆ you will reserve liberty to file a fresh application.
Yes, ma'am. Yes.
Petitioner is before this court seeking for the following reliefs. Notice to respondent is dispensed with in view of the proposed order to be passed. By way of the impugned order, the execution court has rejected the application for impleading filed by the petitioner on the ground that no documents had been produced. If that be so, it would always be open for the petitioner to file a fresh application enclosing by producing all the relevant documents which would have to be considered by the trial court. With the above clarification, the above petition, in the event of such an application being filed, the trial court, the execution court would have to consider the same on merits.
Yes.
With the above clarification, the petition stands disposed.
42 Gayatri, yes sir. PM Nada.
Petition. Lord, the office objections, counsel submission is, my lord, original defendant number 1, my lord, she expired, my lord, in 2020. I have produced, my lord, the death
Page
certificate.
121 complete copy, kanisalla.
My lord, that it was, my lord, overfolded, my lord, on the vidu. That I got the copy during the course of the day. I will correct it.
Yes, then what is this?
And
Cost title?
defendant number 1 died, my lord. I have given, my lord, a note, my lord, in the cost title stating that, my lord, defendant number 1 died. I have produced her.
Our legal heirs, sir?
She is issueless. I am the adopted son.
Learned counsel for the petitioner submit that defendant number 1B expired on 27/2020 and the petitioner claims to be her only legal heir on being adopted son. In that view of the matter, the submission is accepted. Office objection at CL number 54 is overruled. Yes.
My lord, I filed, my lord, suit in OS number 388 of 2017, now which has been, my lord, renumbered as 102 of 2020. My lord, for declaration, my lord, that I am entitled for half share, my lord, in the all suit scheduled property against defendant number 1, original defendant number, who is my mother, adopted mother, and, my lord, defendant number 2 and 3, who are the respondents number 1 and 2 herein, who were, my lord, purchasers, my lord, of the item number 2 and 3 of the suit scheduled property through my mother in the year 2017. And, my lord, immediately after, my lord, issuance of notice, my mother appeared, my lord, and she filed, my lord, written statement denying my status. And, my lord, also, my lord, will, which was in my favor, executed by my adoptive father. Defendant number 2 and 3, my lord, also files, my lord, their written statement in line with, my lord, written statement of defendant number 1. Subsequently, my lord, all the 3 persons filed separate suits. Defendant number 1 filed a suit, my lord, in OS number 223 of 2018. And these respondent number 1 and 2 filed, my lord, filed OS number 18 and 19.
Proceedings in OS number 102 of 2020 pending on the file of the first additional senior civil judge, Bellary Estate till the next date of hearing. Issue notice to respond
My lord,
number 1 and 2.
all suits are required to be stayed, my lord, because the reason is, my lord,
ನೀವು ರಿಲೀಫ್ ಕೇಳಿರೋದೇ ಒಂದು.
ಅಲ್ಲ ನಾನು interim prayer ಅಲ್ಲಿ ಕೇಳಿದ್ದೀನಿ ಸರ್. ಯಾಕಂತಂದ್ರೆ I filed an application to club, my lord, all the suits. There was an order by the district court
102, 100 and 101 of 2020.
Please.
Issue notice to respond number 1 and 2 returnable by 16th April, process fee and copies to be furnished by 10th February. Acknowledgement of service on the respective counsel for the respondent before the trial court to be filed on or before 14th February, failing either of which, the interim order will stand automatically with you.
Please, please. Oblige.
T group.
10 days time is granted to the petitioner to comply with office objection at CL number 50.
Lord, that is just a page, my lord, I will correct.
Mardi.
Now one.
43, Srinand Achapure.
For the respondent in this matter, my lords.
Yes.
My lords, in this, my lords, Vikram Hulgod last time appeared, my lords, can he be accommodated for 14th, my lords? Is there physically in other matter, my lords? Last time the
14th.
respondent sought time, my lords.
All the matters will not go on. You will have to select which one. Relist on 14th.
Grateful, my lord.
Counsel for the petitioner.
Please.
44, Lakshman T Mantagani.
Amended cost title.
Last occasion ಮಾಡಿನ್ರಿ the commissioner per Merida Singh board has directed to produce the plan.
Amended cost title ಹಾಕಿಲ್ಲ Mr. Mantagani.
Please.
ನೀವು amended cost title ಹಾಕಿಲ್ಲ.
Amended cost, sorry, I amended the, now I am filing.
And counsel for the petitioner has filed the amended cost title. The same is taken on record. Yes. Heli.
This is in respect of the NA conversion was ordered in the year 1970. Layout plan has been converted, and thereafter the lands have been sold by farming the layout. But where in the year 1972, where the Land Reforms Act came in force in 1974, there was the dispute with regards to tenancy. The tenants application was rejected. Subsequently, in the year 1990, that the Land Reforms Appellate Authority granted the land in favor of the tenants. But up to that 1990 it was granted. Here the Tahsildar, without taking into the account of the land converted and also the layout has been formed and the sites have been sold, without considering that he has the Kodi Hissa has been made, and thereafter the mutation entry came to be passed. That too after lapse of 20-25 years, wherein already the petitioner and some other persons have already put up the construction and they are staying there. Now without notice and also without there being the spot inspection, that entire layout has been modified and it has been mutation entry has been certified. The converted land has been granted to the tenants. Now that was challenged before the ADLR. ADLR order has been challenged before the JDLR. JDLR in turn he remanded the matter to the ADLR.
ನೀವು ADLR, DDLR, JDLR ಮಾಡಿದ್ರೆ ಏನು ಪ್ರಯೋಜನ? Land reforms
subsequently
land tribunal ಚಾಲೆಂಜ್ ಮಾಡಬೇಕು.
ಲ್ಯಾಂಡ್ ಅಲ್ಲ ನಮ್ದೇನಿಲ್ಲ ಈಗ ಲ್ಯಾಂಡ್ ಅದ್ರ ಪ್ರಕಾರ ಈ 1 ಎಕರೆದಲ್ಲಿ ಏನಿತ್ತಲ್ಲ 1 ಎಕರೆ ಅದನ್ನ ಆಸ್ ಇಟ್ ಇಸ್ ಬಿಟ್ಟಿದ್ದಾರೆ. ಬಟ್ 2 ಎಕರೆ ಮಾತ್ರ ಅವ್ರಿಗೆ ಕೊಟ್ರು. 1 ಎಕರೆದಲ್ಲಿ ಇದ್ದಿದ್ದ ಆಸ್ ಇಟ್ ಇಸ್ ಐತಿ. ನಾವು Kodi Hissa has been made where the layout has been formed, it has been granted.
There is the land reforms order. Tribunal order.
Yes.
Lord, at page 50.
So what has been granted?
Annexure B, page number 21 is the order of the Land Reforms Appellate Authority. Your Lordship kindly last the 30 page number 30 dalli.
Page 50 is by the JDLR.
ಇದು
Land Reforms Tribunal.
Page number 20 page number 21 30 page number 20 anno order, the operative portion is page number 30. Appeal of the applicants married 30 page number 30. Appeal of the applicants 1 and 2 is allowed. Appeal of the third appellant is dismissed. The order passed by Land Tribunal Dharwad dated 18/4/1988 rejecting the claim of the appellants 1 and 2 is hereby set aside.
2 acres 1 gunta and 54 1A.
Yes, but it is totally 3 acres 14 gunta.
RTC ಎಲ್ಲಿದೆ?
ಅಲ್ಲ ಇದಾಯ್ತು. ನಾವು 1 ಎಕರೆದಲ್ಲಿ ಆಲ್ರೆಡಿ
RTC ಎಲ್ಲಿದೆ? ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟ್ ಅಂತ?
RTC our land tribunal our tenants. I am the purchaser of the property.
54 1A RTC ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ? ಎಷ್ಟಿದೆ ಎಕ್ಸ್ಟೆಂಟ್ ಅದು?
Total extent is 3 acres 20 guntas.
ಯಾವ ಡಾಕ್ಯುಮೆಂಟ್ ಬೇಸಿಸ್ ಮೇಲೆ ಹೇಳ್ತಾರೆ?
This is here even in the order is also mentioned. 2 acre. 3, your lordship kindly page number 23 ದಲ್ಲಿ. Page number 23 ದಲ್ಲಿ ಎರಡನೇ ಪರ. One Srimati Karwa filed an application, farm number 7, the land tribunal Dharwad claiming occupancy rights of 3 acres 23 guntas of land survey number 54 1A situated so and so. But this is 3 acres 23 guntas. Out of that, my lord, 2 acres has been granted. 1 acre ದಲ್ಲಿ as it is hanging.
So 1 acre 22 guntas ಇನ್ನ ಉಳಿಯುತ್ತೆ.
ಹೌದು. ಅಲ್ಲಿನ but 1 acre ದಲ್ಲಿ total 3 acre ದಲ್ಲಿ 1 acre has been made, the land has been converted and layout has been farmed and sites have been sold. Now my lord, the pursuant this is even land tribunal ಅಲ್ಲಿ ಯಾವ portion ಅಂತ ಹೇಳಿಲ್ಲ, only 2 acres 1 acres ಅಂತ ಹೇಳಿದ್ದಾರೆ. Taking into wrongly interpreting that my lord, they have Podi hissa has been made where the layout has been farmed. Overnight, my lord, this mutation entry came to be my lord certified annexure E.
So the contesting respondents are not here. Only the official respondents are here.
ಅದೇ ಅವ್ರ because my lord, way back in the year 1970, my lord, layout has been farmed. Adu my lord, only in the year 1990, once it has been rejected, thereafter my lord, land appellator threat granted. So far as only 2 acres is concerned. 1 acre 13 guntasದಲ್ಲಿ layout has been farmed.
ಅದು ಹೇಳ್ತಾನೆ ಇದೀರಾ ಇವಾಗ. Yes, Mr. Kalsurmat.
At the last occasion, your lordship recollect that my lord, they are directed to my lord, the produce the conversion order. I have produced the approved plan layout, my lord.
ಎಲ್ಲಿದೆ page?
Along with memo I have produced.
ಯಾವತ್ತು?
Memo dated 3/7/2022, my lord. ಅದು ಅವ್ರದ್ದು my lord.
ಯಾವ ಸರ್ವೆ ನಂಬರ್ ಇದು? ಸರ್ವೆ ನಂಬರ್ ಎಲ್ಲಿದೆ?
ಸರ್ವೆ ನಂಬರ್ my lord,
My lord, 54/1A.
54/2 approved layout of RS number 54/2 ಅಂತ. Your approval is 54/2, not 54/1.
54/1. In here also your lordship tells me that this is 54/1.
ಅದು ಯಾವ್ದಪ್ಪ?
54/1.
ಅಲ್ಲ, along with the memo they have produced copy.
ಹೌದಾ?
ಇದೆ ಅಲ್ಲ ಮ್ಯಾಪ್ ಅದು.
54/1 ಇದೆ.
ಅದೇ ರೀ.
ಅಲ್ಲಿ ಮಧ್ಯದಲ್ಲಿ ನೋಡಿ ಅಪ್ರೂವ್ಡ್ ಲೇಔಟ್ ಆಫ್ RS 54/2 ಇದೆ.
ಮಧ್ಯೆ ಇದೆ.
ಮೇಲ್ ಬೇರೆ ಏನೋ ಬರ್ದಿದ್ರ
54/2.
ಅದು ಒಂದು ಬೇರೆ. ಅದು ಇದೆ. ಇದು 54 ಅದು ಒಂದು ಇರ್ಬೇಕು. ಅದು ಬೇರೆ ಇದೆ. ಇದು ಮೇಲ್ಗಡೆ ಕೊಟ್ಟಿದ್ದು 54/1.
ಯಾವ್ದ್ರದ್ದು ಇದೆ ಅಪ್ರೂವಲ್?
Layout plot in survey number 54/1 of Saptapur Dharwad ಕೊಟ್ಟಿದೆ. ಇದು ಒಂದು approved layout. Therefore, my last occasion your lordship directed my lord to.
Yes.
Approved layout.
So far as order of conversion is concerned, so it is not there.
ಕನ್ವರ್ಷನ್ ಪ್ಲಾನ್ ಸ್ಯಾಂಕ್ಷನ್ ಯಾವ ಸರ್ವೆ ನಂಬರ್ಗೆ ಕೊಟ್ಟಿದ್ದೀರಾ?
I will produce it, my lords, and get the copy of it. Since it was a planning authority then you could, you have traced the file now, and we will produce it, my lords, in the next week.
Whether any plan sanction had been granted. Already we have said that. Conversion is for AGA.
Lord, I will ascertain. Order dated.
Order dated 7/1/25.
7/1.
ಇಬ್ಬರದೂ ಇದೆ.
ಅಲ್ಲಲ್ಲ, My colleague appeared, so adike.
Both counsel for learned AGA and counsel for respondent number 8 seek for and are granted weeks time to comply with the order dated 7/1/25, released on 20th February.
Please.
Hanuman Reddy Sahukar.
Yes, Mr.
Please
Sahukar.
start, my lord, is the land in question, my lord, is
VP Kulkarni.
I am appearing.
Yes.
The respondent number 5, my lord, created the document. The earlier, my lord, the property was in the name of the mother of the, my lord, the petitioners. One Bhima Kamrats. The after her demise, it has to go to 3 children. That is how, my lord, it was arrangement was made. But respondent number 5, who has no right whatsoever, created the document and got mutated in his name. And petitioners have filed the appeal, my lord. In the appeal, my lord, it is set aside the order of mutation and enter the name of
Kulkarni Alappa, son of Malleppa.
Yes, miss.
Respondent number 5 is son of respondent number 6.
Yes, my lord. 5 is
Respondent
the,
number 6 had given up his share.
yes, miss.
It is their contention, my lord.
In the appeal, my lord, appeal is allowed and the name of respondent 5 is deleted and name of the petitioner is ordered to be entered. Against that, my lord, the respondent number 5 has filed the revision petition. The deputy commissioner, that is in the revision, he has confirmed the order. But however, in addition to the name of the petitioner, he is ordered to enter the name of the respondent number 6. Though he has not filed any revision petition and he has not challenged the order of the respondent number 2 assistant commissioner. That is the main grievance, my lord. And after the order is passed, my lord, they immediately moved an application and deputy commissioner stayed the order till the appeal period is over. Then immediately filed the writ petition and this Honorable Court granted the stay of the annexure
Yes.
C, my lords. Though, my lord, the respondent number 6.
Respondent number 6 is the brother.
Yes.
This is a document on which basis you say that he had given up his right over the property.
The document as such is not there.
Not there.
But thing is not just not. He has not prepared any revision petition before the deputy commissioner.
The respondent number 5's name has been deleted. All the names of the sons have been added.
The son has filed the revision petition.
All the names of the son of Bhimaka
Bhimaka has been ordered to enter. That is there. I am not.
Are able to place on record that he has released, relinquished, gifted something. Or ಹೆಸರು ಬರಲೇಬೇಕು. Nothing wrong with the order.
But I was told that he has total linguist. Therefore, he has not filed any revision.
Document kodi. If you are able to give us a document, we will consider that.
That I will ask.
ಯಾವುದು ಇಲ್ಲ.
I will get the instructions because what they say is he is totally not interested. His son has created the document. He
Not
has,
interested ಅಂದ್ರೆ ಇಲ್ಲಿ ನಿಂತಿರ್ತಾ ಇರ್ಲಿಲ್ಲ.
Actually, earlier we try to compromise.
ಅದು ಮಾಡ್ಕೊಳ್ಳಿ.
But subsequently, one of the brother is not happy with the petitioner.
ಏನ್ ಕಾಂಪ್ರಮೈಸ್ ಆದ್ರೂ ಮಾಡ್ಕೊಳ್ಳಿ. If you say he is relinquished, you have to place a document on record for legal consideration.
Yes, that you will grant some time. I will find out from my
After arguing for some time, learned counsel for the petitioner seeks for and is granted a week's time to place on record the document on which basis the petitioners contend that respondent number 6 had given up a share in the land in question in favor of the petitioners. Since the submission of Yardo, whose submission? VP Kulkarni na nimda?
On behalf of VP Kulkarni.
Submission of Shri Sangram Kulkarni on behalf of Shri VP Kulkarni is that respondent number 6 has not given up any right in the property belonging to Srimati Bhimaka. Released on 19th February.
Please.
If by then no document is placed on record, adverse inference would have to be drawn and the matter proceeded with.
Please.
46, 47 adjourn, 48. Prashant Kardevar,
I prefer petitioner, Lordship.
Yes.
Lord, the respondent advocate, Lord, Mulal, Lord.
Mr. Ulial,
He wanted time.
no time. ನೀವೆಲ್ಲದಕ್ಕೂ ಟೈಮ್ ಕೇಳ್ಕೊಂಡು ಕೂತ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ. ಕೇಳಿಸ್ತಾ ಇಲ್ಲ, ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ.
Objections are ready, my lord. Commission was transferred. Therefore, only 3 days time may be given.
2015 matter.
And then objection ready, my lord. Even copy was also served on the respondent. But in of transfer the commission, some amendments have been made in the objections. So I will file it within 3 days.
Counsel for the respondent seeks for and is granted 3 days time finally to
Yes,
file a
please,
statement of objection. Released on 13th.
Please.
49, RK Kulkarni.
My lord, short accommodation. Next week, any date, my lord. Any date, I shall go on.
ಹಳೆ ಮ್ಯಾಟರ್ಸ್ ಇವತ್ತು ರೀಚ್ ಆಗ್ತಾ ಇದೆ ಇವತ್ತು.
Next week, any date, my lord.
At the request of counsel for the petitioner released on 17th, it is made clear that no further adjournment would be granted. If arguments are not advanced, petition would be liable to be dismissed or not.
Date, my lord.
50, Shivkumar Badwadgi.
Copy of the petition. Petition by the management challenging the order passed by the court below as at Annexure C, whereby the Labour Court has set aside the order passed by the disciplinary authority dated minutes 31/1/2001 in a reference raised in the year 2013.
2001 in 2013.
And directed us to minutes give back all the benefits to the workman.
The 2015 order.
Yes, minutes.
Reinstate ಮಾಡಿದೀರಾ?
He is in service, minutes. He is.
ಮತ್ತಿನ್ನೇನಂತೆ?
Increment was minutes withheld. One increment was withheld with cumulative effect. He was not dismissed from service. Though minutes he was involved in 39 cases as on date of minutes punishing the workman. The Labour Court minutes holds that minutes
ಇದು reinstate ಮಾಡಿದ್ಮೇಲೆ ಸಾರಿ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಆದ್ಮೇಲೆ ಏನಾದ್ರು ಫರ್ದರ್ ಇಶ್ಯೂಸ್
ಅದರ ಬಗ್ಗೆ ಏನು ಬೇಡ. I am not having any. My only contention before my lord says it's a stale dispute. The court below should not have entertained it.
There is nothing. If we had committed anything, we would have. Petitioner is before this court seeking for the following leaves. The Road Transport Corporation is before this court challenging the award dated 26/9/2015 passed by the Industrial Tribunal Hubballi in ID number 340 of 2013, by virtue of which the order of the disciplinary authority imposing a punishment of reducing the basic pay of the workman by one incremental stage has been set aside. The submission of Shri Shivkumar S. Badwadgi, learned counsel for the petitioner, is that the said order of the disciplinary authority having been passed on 31/1/2001, a reference could not have been entertained in terms of the reference order dated 7/10/2013 after a lapse of 12 years.
10 years. 10 years.
2001 to 13 up 12 years.
2012.
But the issue is followed, issue number 2, page number 18. Whether the petition is stale on account of delay in raising the dispute.
Wrong issue. Set aside ಮಾಡಬೇಕು. On the face of it is 12 years.
Yes.
After a period of 12 years. On inquiry with the learned counsel for the petitioner, if from the year 2001 to 2013 and thereafter, if there has been any delinquency on part of the respondent workman, Shri Shivkumar S. Badwadgi on instructions fairly submits that there is no such delinquency or no.
I can't. I'm not having any instructions insofar as that aspect is concerned.
That he has on instructions, has no instructions. submitted that he has no instructions. ನೀವೇನ್ ಹೇಳ್ತೀರಾ?
My lord, the punishment order
Like
imposed,
any other proceedings initiated against you?
my lord, two punishment orders are imposed. That was also called in question before the labor court. He suffered an award and, against him. Thereafter, he attained the age of superannuation long back.
ಅದೇ ಹೇಳಿ ಫಸ್ಟ್ ಆನ್ ಎನ್ಕ್ವೈರಿ ಬೇಡ. ದಿ ರೆಸ್ಪಾಂಡ್ ವರ್ಕ್ಮನ್ ಹ್ಯಾವಿಂಗ್ ಸೂಪರ್ಅನ್ಯುಯೇಟೆಡ್ ಆನ್
ಅದು ಗೊತ್ತಿಲ್ಲ.
ಬೇಸಿಕ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳ್ಬೇಕು.
Let's, as and date of let's filing the claim reference before the court below.
58 ಅಲ್ವಾ ನಿಮ್ದು?
ಹೌದು.
60.
60ನಾ?
Please.
60 ಅಂದ್ರೆ ಆಗಲ್ವಲ್ಲ. 2013 having superannuated in the year 2023.
Yes.
In that view of the matter, I am the considered opinion that this would not be a proper case to consider these issues when the workman is already superannuated and the punishment imposed was only withholding of one increment, as at the petition stands dismissed.
May I request that benefit may be ordered to be released.
Needless to say that the
That was
orders
observed by
passed
the court below.
Yes,
Labor Industrial Tribunal would have to be complied, if not already complied,
please,
within a period of 30 days from the date of receipt of a copy of this order.
please. Oblige.
T1, Lakshman T. Mantagani.
Father of the petitioner was the tenant of the land during survey number 273.
ಯಾರು ಇಲ್ವಾ?
Yeah, response served and 100%.
Yes, AGA.
And here, in respect of measuring, land measuring 4 guntas and 6 ana, where in out of 2 acres, 3 guntas. The father of the petitioner prior to 1950 was the tenant.
In a 1979
79 order. Howದು.
Here, what happened, Malad?
17.
Here, Malad, your lordship kindly see, Malad. The father of the tenant subsequently, Malad, he purchased the property in the
First explain the delay.
delay, Malad, he father of
38 years.
constructed the house. His name in the year 1953, Malad, the father of the petitioner, though he was a tenant, however, he purchased the property. He constructed the house. His name was entered in the records of the property extract of the Gram Panchayat. Your lordship kindly take the page number 26. Page number 26. However, in the revenue record now, because he purchased the property, therefore he didn't file form number 7. Subsequently, his name by virtue of purchase.
Verify who is in possession.
Position is because I will ascertain and make submission. But since for the first time 2013 he came to know, and when he gave an application for to enter, thereafter he would have immediately approached. But again he stayed for 4 years. Thereafter in the year 2017 he files an application.
They are not in possession.
I will ascertain and make submission.
That AGA seeks fund is granted a week's time to ascertain who is in possession of the land in survey number 273 of Kasargod, Manki Obli, and make a submission.
Please.
List on 17.
Please.
(52) Anand P. Savadi.
Non-prosecution.
Lord, annexure page 23 is the impugned order passed by the
ಬರ್ತಾನೆ ಇಲ್ಲ.
labor court. Award. Wherein, my lord, at page 27, internal page number 5 of the award. Internal page number 5, para 12 and 13.
27.
The oral evidence of the claimant is not supported by the document regarding the work done by him. On the self-served statement of the claimant, it cannot be said that he has worked for 240 days in a calendar year proceeding. Admittedly, the claimant is working in a department of PWD of state government. The Honorable High Court of Karnataka so and so held in PWD department cannot be treated as an industry within the meaning of section 2(8) of the industry. Therefore, on this proposition of law, the activity of the respondent does not come within the definition of industry. On this ground, my lord, Tribunal has dismissed his claim.
ಬರ್ತಾ ಇಲ್ಲ, we can't pass order.
ಅಲ್ಲ ಇದರಲ್ಲಿ ಇಂಟ್ರಿ ಮಾಡರ್ನು ಇಲ್ಲ ಏನಿಲ್ಲ.
Quite the order dated 23/1/25, none appears for the petitioner today also. Clerical of the order sheet indicates that there is no appearance on earlier occasions. In that view of the matter, it appears that the petitioner is not interested in prosecuting the matter. Petition is dismissed for non-prosecution. Like Anand Savdi ಬರ್ತಾರಾ?
ಬರ್ತಾರ ರೆಗ್ಯುಲರ್ ಇಲ್ಲ ಬಟ್
ಬರ್ತಾರೆ,
ಮ್ಯಾಟರ್
ಇದಕ್ಕೆ ಬರ್ತಾ ಇಲ್ಲ.
ಬಂದಿಲ್ಲ ಅಷ್ಟೇ.
53 PM Shilwan.
Annexure A is under challenge, wherein I am directed not to proceed with the construction work. Annexure A, my lords. I purchased the plot and I applied to the respond number 1 for seeking permission to construct. Permission is granted. Thereafter, one person, that is Ambedkar Sangha, objects for the permission and says that their land has been encroached. And that is the reason the respond number 1 directed me to stop construction. I stopped construction and report was called for from the Tahsildar by the Deputy Commissioner as per Annexure H. In the Annexure H, it says that there is no encroachment or there is no Annexure H, my lords, page number 30 is the relevant page. Last paragraph.
Yes.
ಮೇಲ್ಕಂಡ ದಾಖಲೆಗಳ ಮೇಲ್ಕಂಡ ಎಲ್ಲಾ ದಾಖಲೆ ಸ್ಥಳ ತನಿಖೆ ಮತ್ತು ಸರ್ವೆ ನಕ್ಷೆ ಡಾಕ್ಟರ್ BR ಅಂಬೇಡ್ಕರ್ ಭವನ್ ನಿವೇಶನ ಮಂಜೂರು ವೇಳೆಯಲ್ಲಿ ಅಂಬೇಡ್ಕರ್ ಭವನಕ್ಕೆ ಹೋಗಲು ಹಾಲಿ ಖಾತೆದಾರರ ಬಿ ವೀರೇಂದ್ರ ತಂದೆ ಲೇಟ್ ಸೋ ಅಂಡ್ ಸೋ ಮೆಜರಿಂಗ್ ಸೋ ಅಂಡ್ ಸೋ ಅಡಿಗಳ ವಿಸ್ತೀರ್ಣದ ಖಾತೆದಾರರಾದ ಟಿ ನಾಗರಾಜ್ ತಂದೆ TG ಸಕ್ರಗೌಡರ್ ರವರ ಜಾಗದಲ್ಲಿ 10 ಅಡಿ ಸಂಪರ್ಕ ರಸ್ತೆಯನ್ನು ಈ ಹಿಂದೆ ಅಳತೆ ಮಾಡಿ ಅವರ ತಪ್ಪಾಗಿ ಅಳತೆ ಮಾಡಿ ನಕ್ಷೆ ತಯಾರಿಸಿ ಮಂಜೂರ್ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ವಿವಾದಕ್ಕೆ ಕಾರಣವಾಗಿರುತ್ತದೆ ಮತ್ತು ಡಾಕ್ಟರ್ BR ಅಂಬೇಡ್ಕರ್ ಭವನಕ್ಕೆ ಹೋಗಲು ಮೂಲ ನಕ್ಷೆಯಲ್ಲಿ ಕಂಡಂತೆ ದಾರಿ ಇರುವುದಿಲ್ಲ ಎಂದು ಮಾಹಿತಿಯನ್ನು ಲಭ್ಯವಿರುವ ಅಗತ್ಯ ದಾಖಲೆಗಳನ್ನು ಲಗತ್ತಿಸುತ್ತಾ ತಮ್ಮ ಮುಂದಿನ ಕ್ರಮಕ್ಕಾಗಿ ಸಲ್ಲಿಸಲಾಗಿದೆ.
ಏನ್ ಹೇಳಿದ್ರು?
ಅಲ್ಲಿ ರೋಡೇ ಇಲ್ಲ ಅಂಡ್ ದೇರ್ ಇಸ್ ನೋ ಎನ್ಕ್ರೋಚ್ಮೆಂಟ್ ಅಂತಾನೆ ಹೇಳ್ತಾರೆ. That is the reason annexure
instruction, because as per the direction of this annexure H, tappagi antide swami. Just short accommodation.
So when you are yourself saying that complaint is false, how can you stop them from continuing the construction? What instructions ಬೇಕಿದೆ? It's a order in writing by you. What instructions?
2 days.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that on a false complaint which had been filed, the petitioner had been the first respondent directed the petitioner not to go ahead with the construction being carried out by the petitioner in presence of a plan sanction issued by respondent number 1. The submission of Shri Vinay Kaujalgi and counsel for the petitioner is that respondent number 1 having called for a report had been submitted by
Tahsildar
the Tahsildar
to the Deputy Commissioner
stating that there is no encroachment by the petitioner as falsely alleged in the complaint. If that be so, the report having been received by the first respondent, it was for the first respondent to have issued necessary endorsement, recalling the order dated for
endorsement has been received by the report has been received by the second respondent.
By second respondent. First respondent kotilva.
Illa. It is the Deputy Commissioner who directs.
Placed it before him.
Pardon me.
You should have placed this before the first respondent.
At the instance of the respondent number 1, the record was called.
If you had placed this report before the first respondent, you would have passed orders.
Yes, but till today, we issued notice to the chief officer, which is an annexure J. Annexure J may kindly be seen, my lords.
Your chief officer has passed annexure A on the basis of a complaint received.
How?
You are saying it is false on the basis of a report submitted by respondent number 3, Tahsildar, to respondent number 2, Deputy Commissioner.
Please.
That report has not gone to the first respondent.
It is gone, my lords. Annexure J may kindly be seen. Legal notice. Next page number 32. Page number 32, the survey was also conducted and there is no way in the property of my client. My client is demanded and requested your
The
authority.
Nimdo story. Where is that report given to first respondent?
Illa.
He reported annexure H.
Ah.
Has it been given to the first respondent?
Illa. No, my lords, but
So you place
legal
it on
notice
record
also-
with, before them, we'll direct them to take action. As order that. The second respondent, Deputy Commissioner, had called upon the third respondent to inquire into the complaint. The third respondent has reported to the second respondent on 16/20/06/2016 at annexure H that there is no encroachment by the petitioner. If that be so, it was for the petitioner to have placed the said report for consideration before the respondent number 1 for necessary orders. In view of the above observation, I pass the following order. Writ petition is disposed, granting liberty to the petitioner to place the report at annexure H for consideration of respondent number 1, who shall act in terms of the said report within a period of 30 days.
Lord,
54, Vidyavati, Pattur Shettar.
Cover by judgment.
Same, huh?
Annexure D and E, they are seeking for refund of the
Same order as in WP 107910 of 2017. Annexure D and D matter replacement.
55, Borkar.
And for the petitioner, my lords.
Yes.
My lord, appear for number 1 and 3, my lord.
Yes, Mr. Olial.
We require 2 weeks.
ಎಲ್ಲದರಲ್ಲೂ ಟೈಮ್ ಕೇಳ್ತೀರಾ ನೀವು?
Short accommodation may be given.
Counsel
my
for
lords.
the respondent seeks
Yeah.
for 10 days time finally to file a statement of objection and address arguments.
Please.
Released on 20th. If arguments,
Yes, please.
if statement of objections are not filed, the same will be taken as not filed and proceeded with. If arguments are not advanced by respondent number 1 and 3,
Please.
the matter will be taken up for consideration on the basis of submission of
My
counsel
lords,
for the
may I seek a short accommodation, my lords? Earlier date than 20th, my lords.
We don't have that, 20th.
My lords, the name of previous counsel may be deleted. Name of Sajid
Sajid Gudwala has entered appearance for the petitioner. Registry is direct delete the name of Sri Borkar Surendra Kumar Buddhaji as that appearing for the petitioner.
Grateful, my lords.
56, Rajesh Rajna. Hidikeri.
My lord, kindly have a next week, my lord. Next week, man.
At the request of counsel for the petitioner, released on 20th.
Please.
57, Sangram Kulkarni.
This case, I need to appear for the response.
Yes.
I appear with Mr. Kulkarni for the
Yes.
petitioners.
Yes, madam.
Is it, you want to? Okay. Because the genesis of this matter is actually an order passed by your lordships earlier. If my lord will kindly turn.
So genesis of the litigation is an order passed by us.
No, I wouldn't say the litigation, my lords.
Yes.
I wanted to take your lordships directly to the issue rather than, my lords.
Yes.
Because the suit arises in terms of certain partition and other issues. I'm not going into the merits because I'll tell your lordships what has happened. My lords, the petitioner and the respondent are related, uncle and aunt. The respondent had filed a suit for partition, she expired. And my lords, the applicant trust claims, in fact, by two wills, in fact, two separate wills which are disclosed in the pleadings, but I won't take my lords to that also, that the will bequeaths her share of the suit property to them. This is, my lords, the suit about. Now the respondent, the applicant trust, my lords, filed, and I'll just give your lordships two dates. I've just made a dates and events. May I hand it over to your lordships,
Yes,
my lords?
please.
Because it is. Just give it to. Sorry.
Yes.
Because I have given a completeness of the dates, but I'll take my lords to the relevant ones. If your lordships will see, my lords, one Mr. Venkatrao Pikade, he died and left behind his widow, son, and a grandson. In 62, my lords, when the husband of the original plaintiff, that is the respondent, was 14, the suit house was built. And my lords, in 62, he had honored his father's last wish by having the property in the name of the petitioner hearing. Now, your lordships will see, for the purposes of today's petition, my lords, item 6 on page 2, 26/11/2011, my lords, the plaintiff in the suit, Miss Prema Pikade, she passed away. And my lords, according to us, my lords, the suit abates by force of law. On 30/5/2012, my lords, an application was preferred by the trust to come on record as a legal representative under Order 22, Rule 3, and invoking Section 151 of the CPC. The trial court, my lords, passed an order on 22nd of November 13. We moved, your lordships, and I must tell my lords that at Exhibit E, Annexure E, page 82, my lords, we have annexed the petition only for the limited purpose to show to your lordships. I'm sorry, Exhibit D, page 71. That is the petition, my lords. And if my lord sees at page 77 for a moment, para 14 and 15 may be noted. This is the specific ground taken before this honorable court. The trial court failed to appreciate the settled law that consideration of delay under Section 5 of the Limitation Act and setting aside of abatement under so and so are distinct and separate actions. The trial court failed to consider that suit having abated on 24/2/12, the legal consequences of abatement cannot be set aside by preferring an application under Order 22, Rule 3. Please see overleaf notes, next page, para 16. The trial court failed to note that the applications under Order 22, Rule 3 and under Section 5 of the Limitation Act read with 151 were not maintainable without seeking the setting aside of the abatement. So these were specific grounds pleaded before this honorable court. Your lordships passed an order allowing my writ petition, which is at page 82.
Yes.
If my lord sees para 2 at page 83 for a moment.
Yes.
I
We read
numbers.
the order.
My lords, my lords.
We read the order, yes.
Very good.
Liberty was reserved to file applications.
That's right. That's right.
Yes.
My lords, I'll just tell your lordships what exactly happened when the order passed. In all fairness, my lords, this honorable court condoned the delay, which was about 1,473 days. No difficulty on that, my lords. We have not even gone in appeal or anything. The intention was to go on with the matter on merits. The 3-week period, which if your lordship sees, is at page 84. And in fact, my lords will also note one important sentence at page 84, my lords.
Yes.
That is in para 3. I'll just read that, my lords. The society cannot be brought on record with such application. Admittedly, bequest is not in the name of the administrator, but in the favor of KLE society. Proposed plaintiff has also not filed necessary application to set aside abatement. This may kindly be noted.
Yes.
And then, my lords, if your lordship sees fresh application, etc. And then para 5, petition is allowed, impugned order is quashed, 3 weeks time is granted to make necessary applications. If such applications are filed, they shall be considered on merits, etc., and opportunity to us. Now, the 3-week period expired on 10/2/2016. I'm not going into that. I'm just pointing that out to your lordships. We have stated that in this chronology as well.
Yes.
If my lords will for a moment look at my chronology, item 12 on page 3. This expired. That's all right. On 26/2, that is nearly 5 weeks after that, they filed, my lords, the application. Plus, I am not making much of an issue of this 2 weeks at all. What happens is these applications are verbatim almost copies of what is filed earlier. And the submission, and I'm going to point out to your lordships, the averments made in these applications, your lordships will see the fresh applications start from page 85, my lords, of the present petition. My lords, I'll breeze through it. I won't take my lord's time. Order 22, rule 3 is once again repeated. My lord has that, my lords, at page 85.
Yes.
Then
Yes.
my lords will see page 86. What do they say about the disposal of the writ, or rather the allowance of the petition in my favor? Please see paragraph 4. However, writ petition number so and so was disposed of on 21/2016, and it was held that the bequest by the original plaintiff through her will is in the name of KLE Society, not in the name of the administrator, and that no applications were filed to set aside abatement. Please note thereafter, though they were filed and suitable orders were passed in this behalf. However, to avoid the technical defect, KLE moves fresh applications in this behalf to come on record as legal representative, etc. Next, my lord's page. If your lordships will see second paragraph, about 4th line. This is the reason they give for condonation of delay. The application could not be filed earlier as our society office is at Belgaum, and there was need to scrutinize the matters in detail, etc. My lords will see that, my lords. It is not intentional one, all that. If my lords will see the next application, page 88. Because I'm not going into the fact that they claim they are owner by will, etc. We'll cross that bridge later. But please see 88, my lords. Second para. For the reasons stated in the accompanying affidavit, it is most humbly prayed that a delay of 1463 days caused in filing application of so and so be condoned. So 1463 days as on 26th of February 2016. My lords have noted that much.
Yes.
Again, similar affidavit in support. I won't take my lord's time. Further applications filed at page 92 and 94. In fact, 94 was for my lord's preponement of the matter. Anyway, my lords, we filed our reply, which your lordships will find at page 96. And immediately, please note the date of this reply. The date of this reply is 7th of March 2016. In fact, hardly a week's time was given to us to file a reply, though the applicant, my lords, had come on record 5 weeks later. Please see. At 97, we pointed out, the defendant has read a copy of the application dated 26/2/16, claiming to be authorized by KLE under provisions of so and so, that is 22(3), in preferring the application for bringing legal representatives of the original plaintiff on record. The defendant denies that the applicant KLE is entitled to the relief as prayed, and that Dr. Bhatkar has rightly filed the application in conformity with the order dated so and so passed by the Honorable High Court. So this is what we pointed out, and in detail your lordship will find our averment at para 16 of this very my lord's reply, if my lords will see. My lords, para 16 is at page, your lordship will give me a minute, 114, my lords. My lords have that, my lords?
Yes.
Just, my lords, will only scrutinize one important sentence, which is second paragraph. In fact, a specific order is necessary under Order 22, Rule 9 of CPC for setting aside abatement. My lord has seen that in the original writ, the specific ground was taken. This honorable court, my lords, allowed my petition, gave them the 3 weeks time. I'm not on that 5 weeks. I wouldn't, my lords, go into all that. But your lordship will note when I'm filing this reply on 7/3/16, I'm pointing out to them on 7/3/16, see again you have done the same mistake. You need to file a proper application.
Yes.
Now what happens is, thereafter, if your lordship sees, various hearings are held. This applications, they pursued with the application nevertheless, despite me pointing out, etc. And if my lords will go to the dates I handed over for a minute, my lord will see item number, my lords, 15, 11/3/2016. The matter was heard as pleaded on 4 applications. This was the first hearing. So from 11/3/16, we had series of hearings. The matters on which, my lords, the matter was not taken up are merely mentioned. But if your lordship will note item 20, 5/9/2017, again the applications were heard. My lords, KLE presented, my lords, we presented our arguments. Then on 9/10/17, there were further applications, etc. We submitted our case law, my lords, in October 17. Then again, series of, my lords, dates. Now what happens and what changes everything is at item 26, 23rd of October 2019. Well, there was a change of the presiding court and therefore a fresh full hearing, which we understand, no difficulty. On 2/11/2019, my lords, we submitted our arguments. Their application had been heard. We submitted our arguments. On 8/11/19, my lords, the respondent sought time. But what is most, my lords, shocking is what happens on at item 29. These applications which were pending and heard in these 2 tranches before the learned trial court are kept pending, and on 12/11/2019, the applicant files for the first time an application under Order 22, Rule 19. Because by then, the delay is 1,463 days, which your lordships condoned. And rightly so, my lords. Everybody should have a chance. Delay should not be, my lords, a ground to throw out a matter. But by then, we add 1,370 days. Total days are about 2,800 odd days. My lords will see 2,833 days. In the meantime, the petitioner's age today is 93. We have filed an additional affidavit. He can't hear. His comprehension has gone very badly. Because delay, your lordships have always considered liberally, no difficulty.
Any legal heirs of the petitioner?
I'm sorry?
Any legal heirs of the petitioner?
Yes.
Not legal heirs, are there any children of the petitioner?
Yes.
Yes.
Yes. Now, Manoj, your lordships will see. Once condoned, fair enough. I'm not even, Manoj, pressing that they did not adhere to the time limit set by the court. On 7/3/2016 was the first time the petitioner told KLE by way of its affidavit in reply that, look, you have once again done the mistake of filing the wrong application.
Yes.
The delay, your lordship, goes to the root of the matter. Because I'm relying on a decision of the Supreme Court in Balwant Singh, where the diligence which is required of a litigant is, my lords, considered. I'll just tender that to your lordships. Because today, the great amount of prejudice is going to be that the petitioner has aged considerably over this period. From 2011, when Mrs. Pickle died, we are in 2025. Once your lordships have liberally condoned the delay of 1,463 days, my lords have seen their own application before the trial court. No difficulty. I would go to the extent of, my lords, very humbly telling your lordships that even if they had rectified themselves post my reply on 7/3/2016, my lords, it was a different issue. It would have been an issue where court has already condoned 1,400, few days doesn't matter. But they persisted, and see the averments in their application. It is like we had filed a correct one. Now High Court has asked us to file. Now we are just doing this technicality. Plus, a conduct of the litigant. It's not just diligence. The conduct your lordships will kindly countenance. That would be, my lords, my humble submission. Plus, may I tender to your lordships, Balwant?
What are the judgments that
Yes,
you want to
please.
Para?
My lords, this is a 2010 judgment, and if your lordship only has a look at para 3 for a minute, which gives us the facts. Yeah, just give me a copy, please. Para 3, I'll just read this. During the pendency of the appeal on 28/11/2007, the sole petitioner died. From the record, it appears that no steps were taken to bring on record the legal representatives of the deceased appellant for a considerable period of time on record. Somewhere on 15/4/2010, IA number so-and-so has been filed along with IA number so-and-so, praying for condonation of delay in filing the application for bringing the legal heirs on record. As is evident from the above narrated facts, the appellant died on 28/11/7, while the present applications have been filed on or about 15/4/10. Thus, there is a delay of 778 days in filing these applications. Now, if I may go straight to para 7. If my learned friend wants me to read something, he may tell me, I'll do that. Para 7. Here there is admittedly a delay of 778 days in filing the application for bringing the legal representatives on record. To explain this delay, the applicant has filed a one-page application stating that they were not aware of the pendency of the appeal before the court and came to know only in March 10 from their counsel that the case would be listed for final disposal during the vacations in May 10. Then the applications, as already noticed, were filed on 15/4/10. In order to examine the reliability and worthiness of the alleged sufficient cause for condonation of delay, it will be appropriate to refer to para 2 of the application, which is the only relevant paragraph out of 4-paragraph application. That the LRs of the applicants are residing on different addresses because the LRs of the appellant deceased are in service and they were not aware of the pendency of any appeal before this honorable court. However, when the letter from counsel Shri so-and-so was received at home at Ambala that the appeal is being listed for final hearing during vacation in the month of May 10, that these LRs came to know about the pendency of the appeal. Thereafter, these LRs contacted the council in the month of so-and-so to find out the position. When they contacted the council at New Delhi, these LRs, the council was told about the death of Balwant Singh, which had taken place in November.
We have read the entire judgment, 39 and 40.
Yes, absolutely. Because I thought I should show your lordships the facts because it should not happen that I have selectively read something. Also, if my laws permit, only para 26 may also be seen for a minute. Para 26
Yes,
is
26,
also,
27. but
yes, my lords.
It's basically 39, 40.
Yes, my lord is right.
That even in a abatement, it should be the substantive law.
Substantive. That's it. Plus, I'm on something else as well. If your lordship sees 3 applications filed under section 5 for condonation of delay over a period of time. The first one, which your lordship set aside. The second one, which was along with the wrong application. The reason is the same. We all know they have an office in Belgaum. That can't be the reason. Not only.
Not a government organization. To get that benefit of your office.
Plus, I'm conscious of the fact, standing before my lords, as a responsible counsel, that most of the times, we tell the people whom we represent that let the delay be condoned. But in this case, we have done that once. 1,473 days condoned, now 1,300 odd, whatever is the figure. Because in my humble submission, this is a fit case, Minos, where the second application, and here, Minos, the trial courts conduct, your lordship will kindly countenance under 227. When applications are heard,
Nothing is mentioned about the delay.
yes, my lords have, my lords have very speedily seen that. Minos,
Mr. Rajeshwar,
My lords,
you will have to, at para 86, this para 4.
my lords.
Though they were filed and suitable orders were passed in that behalf, you will have to show it to us.
My
When we
lords.
come back,
Yes, ma'am.
we'll have to show this para 1, 2, 3, 4, unnumbered para 4,
Please.
page 86.
88.
Were filed to set aside abatement, though they were filed and suitable orders were passed in that behalf.
I'll
So
show.
if already abatement has been set aside, this argument will not be there. But if this application was not filed and a false statement has been made,
I understand.
then rest
I
of
understand.
no other consideration will be there.
Understand.
Because this is an attribute to the order of this court.
Please.
Page 86, per however WP. Sikta?
in fact, Minos, that is repeated in every affidavit of the 4 applications, 4 different.
We are showing only one.
Yes, I know.
You don't need to ask it 4 times.
Yes.
I understand. Minos.
You will have to show that to us. Yes, Mr. Angri?
Serial number 31, my lord, interim order granted earlier, may kindly be.
31.
31, my lord, may
31
kindly be
interim order.
My lord, in serial number 28 also.
28 interim order.
Serial number 77, for petitioner, like wait for a week's accommodation.
77. 77 at the request of counsel for the petitioner released on 20th.
Interim order.
Interim order earlier granted is extended. 50?
58.
8.
Inform to the other side. Next.
At the request of counsel for the petitioner released on 20th.
ಬೆಳಗ್ಗೆನೇ ಕಾಲ್ ಅಟೆಂಡ್
Serial number 25.
ಬೆಳಗ್ಗೆನೇ ಕಾಲ್ ಔಟ್ ಆಗಿದೆ.
To explain page 86, my lords.
Yes.
My lords, I must say that only two applications were filed, IA number 2 and IA number 3, one for bringing on record, another for condonation.
So
There is-
this statement made in this affidavit is
Lords,
wrong.
I would say, my lords, if my lord sees the order passed by the honorable trial court on IA number 2 and 3 on the earlier occasion, my lords.
Page?
Lords, page, my lord, 67. It begins at page 57, annexure C. Lords, may kindly see page 68, para 15.
Para 15.
Please, must. In view of the order 22 Rule 9 CPC, the person claiming to be the legal representative of the deceased plaintiff may apply for an order to set aside the abatement, and if it is proved that he was prevented by sufficient cause from continuing the suit, the court shall set aside the abatement of dismissal. So the honorable trial court was conscious of the fact that under order 22 Rule 9, setting aside the abatement is necessary. A formal application was not filed.
This was observed way back when?
Way back in 2013, my lords.
This was set aside.
This order was set aside on the ground, my lords. The application.
That observation did not wake you up.
It woke me up in 2019, my lords. Oh, my lords, it's like this. On 26/11/2011, she died. Applications are made on 30th May 2012. Plus 90 days lapsed on 24/2/2012. So to make an application to set aside, I should have filed it on or before 24th April 2012. The applications are made on 30th May 2012. So as on 30th May 2012, they were aware that we have a right in the property. A formal application was not made.
Yes, everybody knows you have a right, but if you don't
No, my lords, here
do it
kindly see,
within
my
a
lords,
time period,
the right of the plaintiff to half share is denied on the ground that there is a worthy given to the revenue authority.
that's on the
all.
merits. That's on
My
the
lords,
merits.
therefore, my lords, it's a case for partition. It's a suit for partition. In a suit for partition, my lords knows, even if my suit is dismissed for default, it doesn't preclude me from filing another suit for partition. Notwithstanding the fact that under Order 9, Rule 9, my lords, there is a bar to file a separate suit if the suit is dismissed for default on the same cause of action. Similarly, my lords, there's a analogous provision under Order 22, Rule 9, which says if the suit is abated, then I cannot file a fresh suit on the same cause of action. So Order 22, Rule 9 and Order 9, Rule 9 are analogous provisions, my lords, and this the division bench of this honorable court has held that there's no bar for filing any number of partition suits, even notwithstanding the fact that the suit is dismissed for default.
So file.
Now, therefore, my lords, ultimately the trial, this is a case of multiplicity of proceedings. And once see the order, my lords, order imputed before my lords.
You go through the undergo the pain of filing a fresh suit.
My lords, kindly see the order under appeal, my order before my lords.
Yes.
It doesn't decide anything. My applications are not yet allowed. It says inquiry is required under Order 22, Rule 5. Page, my lords, 192. My applications are not allowed. Under the para 7, under the present circumstances, this court comes to the conclusion that if the due execution of the gift deed and will is proved, it is just and proper to impute the proposed plaintiffs as the LRs of deceased plaintiff and continue with the proceedings, and in turn it will to avoid multiplicity of proceedings. The Order 22 Rule 5 provides that their question arises as to person is a legal representative or not, deceased plaintiff or deceased defendant. Such question shall be determined by court by due inquiry. Hence, call on for inquiry. So, court has not allowed my applications. It's only posted the matter for inquiry on my applications.
Why should there be inquiry if you have not even filed an application?
Because now we have applications filed in 2019. my lords.
Should not the court have considered whether that application can be considered or not?
My lords knows, my lords, the recent circular passed by this honorable court, my lords, only one application is sufficient.
One application is sufficient, but you should have asked for setting aside abatement.
Lords, in the judgment relied on by my learned friend. Lords,
But you have to ask for all the three prayers.
My lords, in fact, the judgment of the Honorable Supreme Court, my lords, only two applications were made.
those 778 days
You
delay.
file only one application.
All
There's
the
no
3
need to
periods.
waste paper on it
Please.
at all.
Please.
But we have to ask for the reliefs.
Lords, I would say, my lords,
Instead of
going
that,
by
you are going
35
on in a
days is the
convoluted manner saying we had filed an application that was allowed, therefore it was not required. You are doing favor on the court by filing application. The way the
lords, I must say, my lords,
way the affidavits have been worded leaves much to be desired.
I totally agree with my lords.
And it only smacks of high-handedness. Which is not.
May not be high-handedness, it is smacks of.
You know what we are saying and you know what it is. So they should not be doing like this.
Lords, kindly see, my lords, 2011 she died November, 2016 May the applications are filed.
But what is your conduct?
I am at my lords.
That you are.
I am at my lords. So far as
So there is no application filed, and your contention is that there is no order passed. Anything else?
My lords, the decision which my learned friend relied upon, my lords.
Hmm?
There also only 2 applications were filed, my lords. The Honorable Supreme Court did not take exception to not filing an application order 22 Rule 9. Lords, kindly come to my lords.
Dismissed.
Application to bring on record is dismissed because there is no ground to condone the delay of 778 days. But here, my lords, it's not as if it is 2,833 days, my lords. It's virtually 35 days. Delay is virtually 35 days. If my lord considers my earlier applications. My earlier applications were dismissed on the ground that society should have filed the application. Instead of society filing an application, an individual had filed an application. That was the ground on which the writ petition was allowed, my lords. And my lords, before my lords, the respondent made is not the society, is a person who is made the party as respondent. Though the application which is challenged is filed by the society. So these things do happen, my lords.
Yes. Anything else?
Therefore, my lords, my submission is, my lords, since a partition suit.
You said there's another judgment you want to learn. Yes.
Only reading the head note, my lords. An order made under Order 9, lords, paragraph 41.
41. Yes.
Ultimately 49, my lords, after noticing all the judgments, paragraph 45. Paragraph 45.
5.
Rule 9 of Order 9 is based on sound public policy that no defendant should be vexed twice on the same cause of action. The only effect of an order made under Order 9, Rule 8 is that a fresh suit based on the same cause of action is precluded by the provisions of Order 9, Rule 9 of the court. It will not apply to the cases where cause of action is recurring or continuous. A suit for partition dismissed for default under Order 9, Rule 8 of CPC does not bar a subsequent suit for partition. The reason is that the right to enforce partition is a continuous right, which is a legal incident of a joint tenancy and which endures so long as the joint tenancy continues. Causes of action is continuous in partition cases which subsist so long as the property is held jointly. In other words, the joint owner can file a suit for partition until partition is actually effected, irrespective of the fact whether earlier suits for partition were dismissed for default or withdrawn, or an earlier decree for partition was not acted upon. The plaintiff in a suit for partition of certain joint family property, which was jointly held at the time of the previous suit and continues to be joint up to now. When it was dismissed for non-prosecution, the plaintiffs applied for restoration of the suit, but their application was dismissed on the ground that they have failed to establish sufficient cause for their non-appearance in the court. The dismissal of the suit for default would not put an end to the joint status of the property. The effect of such dismissal is joint status continues. The property continues to be joint. The co-sharer's right to seek partition of the property held jointly continues. It is a recurring cause of action. The cause of action comes to an end only after partition of the property held in joint is severed and share of each of the co-sharers is entitled to is put in possession of their respective shares. Therefore, the order of dismissal for default passed under Order 9, Rule 8 would not have the effect of filing yet another suit for partition on the same cause of action. The language of Order 9, Rule 9 and Order 22, Rule 9 are analogous, my lords.
Yes.
Therefore, my lords, as my lord said, I have to take the pains of filing another suit.
Yeah, it is what Supreme Court judgment says. What is the suit in that matter?
Yes, that was a suit for ejectment, my lords.
Ejectment.
The suit for ejectment. Lords, I'm not very clear who was the appellant before the Honorable Supreme Court, whether it is a tenant or the landlord. I'm not able to decipher that properly from the facts, my lords. I tried to read it. I tried to go to the website of Punjab Haryana High Court. I could not get the judgment
What
of the
the
first
original
appellate court.
court did is not here.
Yes, my lords.
The
And section
appellate authority set aside is there.
Yes, my lords. Section 15, my lords, of Haryana Control of Rent Act, my lords, provides for appeal as well as revision, my lords. So in exercise of revisional power or appellate power, that's also not forthcoming. I feel, my lords, it was a case of a tenant filing a petition before the Supreme Court. Both the rent controller and the appellate authority had allowed his claim. High Court set aside. And then, my lords, the appeal was filed in the Supreme Court. And that case, my lords, that's what, because, but the facts are not very clear, my lords.
It appears that the landowner had expired. Landlord had expired.
Yes.
Yes.
Grateful.
Heard Ms. Deepa Chauhan, learned counsel appearing for the petitioner, Shri P.N. Rajeshwara, learned counsel appearing for respondent, reserved.
Great. Yes, if there's anything, my lords, Mallikarjun would intimate the Honorable
Submission
Court.
on
Please.
whether it is settled between both of them, we'll see.
Great.
Grateful. my lords.
230 matter. 81 Sadiq Kanvi.
Yesterday, we made a submission that it is arising of no confidence motion wherein an interim order is granted. Wherein, my lord, now on 4th, my lord, proceedings have been taken place.
Stayed.
How?
They have final outcome.
Subject to the outcome of writ petition and then.
So 7 out of 8 members have moved.
Here's the idea.
My lords, the Assistant Commissioner, first respondent, has adjourned the meeting, my lords. It is not been acted upon, my lords.
Very good. Merits mein le li.
My lords, section 41 clause, 49 clause 1 of the Karnataka Panchayat Act Raj is not this one, my lords, complied, my lords.
What is not complied in 49(1)?
No resolution is passed, my lord, before moving motion of no confidence, my lord. Directly
Form
Assistant
number 1
Commissioner
is not enclosed with form number 2.
Yes, my lords.
It's
Yes, my
not
lords.
required to be attached, enclosed. We'll dismiss the petition. Petitioner is before this court. Mr. Girish, but you will accept notice for 2, 5 to 7, 5, 7 and 8? Shweta Kirstaidia?
Yes.
Shri Girish V. Bhatt, who has appeared for respond number 6, accepts notice for respond number 2 to 5, 7 and 8. The petitioner is before this court seeking for the following reliefs. The grievance, the petitioner is aggrieved by a notice issued by the first respondent assistant commissioner fixing 4/2/2025 fixing a meeting on 4/2/2025 at 11 a.m. at the office of the Gram Panchayat for consideration of a no confidence motion said to be moved by respondent number 2 to 8. The submission of Shri Sadiq Kanvi and counsel for the petitioner is that there is a material irregularity in the notice issued by respondent number 1 assistant commissioner inasmuch as the requisition notice is not enclosed along with the notice fixing the date of the meeting. This issue is no longer res integrated. This court has in
100,205.
100,205
100,205
of 2025 has come to a categorical conclusion that form number 1 or the requisition notice is not required to be enclosed along with the notice fixing the date of meeting by the assistant commissioner. 100,364 of 25, my dear. In that they said judgment being applicable to this present matter also, there being no requirement to enclose the requisition notice in terms of requisition notice along with the notice under form 2, no grounds being made out, petition stands dismissed.
'82 J. Gachinmat.
Where there was a direction, my lords, to ascertain as to whether, my lords, the number, my lords, that number of admissions that is being taken crosses beyond 60.
NCISM.
Yes.
Respondent number 4, Avinash Angadi.
My lord, happy for these. Even I have also filed a memo, my lords, wherein I have submitted the list of students to the Rajiv Gandhi University of Health Sciences. And, my lords, the petitioner number 2, my lords, is the 60th candidate, my lords. 60 number, my lords, have been given.
60.
Please.
60 other end.
It comes within 60. The permitted strength is also 60, my lord, and she is the last.
Our first party ಮಾಡ್ಬಿಟ್ಟು ತಗೊಂಡಿದ್ರೆ ಅವತ್ತೇ ಆರ್ಡರ್. 82. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner number 2 is that she, being a student of petition number 1 college, has not been
Given the admission order copy by KE.
formally admitted by respondent number 1, despite the petition number 2 having complied with all the requirements. On an earlier occasion, when the matter was argued, learned counsel for Ms. Surbi Kulkarni, learned counsel for respondent number 1, submitted that the approved intake for the petition number 1 college was 60. And the petitioner and respondent number 1 being under the impression that more than 60 students had already been admitted, and the petitioner number 2 would be the 62nd student, did not approve the admission. In that background,
Did not issue the admission order because no seat was allotted.
approved the admission by allotting the seat to petition number 2. It is in that background that the concerned authority, being NCISM, was brought on record to ascertain from NCISM if, as regard the total number of students who had been admitted into the petition number 1 college. Shri Avinash Angadi, learned counsel, who appears for respondent number 4 today, categorically submits on instructions that the approved intake of petition number 1 college is 60 and petition number 2 is the 60th student
Yes.
admitted into the first petitioner college, and such admission would be within the approved intake. That being so, petition number 2 having appeared for the counseling session, and only reason why the approval of admission was not granted, being as regards the issue about the approved intake, and the considered opinion that the petition is required to be allowed. In that view of the matter, I pass the following order. Writ petitions allowed. Mandamus is issued directing respondent number 1 to consider the representation of petition number 2 dated 1/12/2023.
The representation is to the government.
To issue the KE admission order copy, second prayer. First prayer may not survive. Second prayer, they will have to issue the admission order copy.
My lord, since it is direct admission, the government and NCISM has to approve, my lord, sir. Only KA can only issue admission order if it is through counseling.
So counseling, now you are functus of issue.
It is, my lords, for the government and NCISM to approve the admissions.
The submission, writ petition is allowed. Since respondent number 4 has submitted that the petition number 2 would be the 60th student, it would be for respondent number 4 to pass formal orders in persons of which state illa party. Let's
the Karnataka Examination Authority, Milords, and Commissioner Ayush, Directorate of Ayush and Rajiv Gandhi.
In further which second respondent would also have to pass formal orders. With the above observation, petition stands disposed.
Milords may observe that it is
The orders to be passed within 15 days. When is the NRV examiner?
They should be permitted to write the exams.
Within 15 days. In the meanwhile, if any exams are scheduled, petition number 2 ought to be permitted to take up such exams. Yes, madam, what were you saying?
My lords may observe that this may not be treated as precedent since, my lords, the regulations don't.
What is the precedent about it? If they are within 60, they are entitled to.
Please.
There is no exception made to any rule.
Since, my lords, direct admissions are not permitted, wide regulations, my lords, of the NCIS.
ನೀವು correct ಆಗಿ verify ಮಾಡಿದ್ರೆ it would have all been proper.
KA allotted, my lords, 2 seats. And she was not, there was no vacancy to allot a seat, my lords, to her.
Yes, when there was when they were told that they were not there and you could have admitted them.
My lords, this
It's
was
not
on the
that
last day of the counseling. I allotted 2 seats to 2 other candidates, my lords. Please.
Pending.
I was told that he is in the VC.
Anand? KR Anand?
Mr. Anand? Mr. Chinandaya? Pass over.
84, Santosh Maligwar?
I appear for petitioner. Yes. But the matter pertains to, my lord, a reservation, reservation of the post for the vice president in town municipal council. When the candidate is not available, last occasion, lordship, pleased to hear. When the candidate is not available, whether it can be de-reserved for the general SC woman. I had produced certain judgments on last occasion, wherein, my lord, the section 42 of the Municipalities Act does not empower.
Judgments.
42 to A. Not that judgment. I have produced memo of citations with 4 judgments.
Citations.
In this, my lord, first judgment is of our own High Court, wherein it is held that this is a case where, my lord, the election was conducted and candidate not belonging to the category, reserved category, had contested. And this honorable court, para 9,
yes,
held that, my lord, when the post is reserved for a certain category, only that candidate can contest for the election. Para 9, referring to the Saraswati's judgment, my lord.
Yes.
The election was held to be illegal and set aside. Para 16.
There it was reserved for scheduled caste women. Huh?
Yes, scheduled caste woman, it was reserved. Para 9 ali. The married Raniamma is elected from the constituency reserved for the scheduled caste women, whereas the post of Adhyaksha was reserved for scheduled castes. Even though, my lord, she belonged to scheduled castes, since she was not contesting from the scheduled caste women category, she was her election was declared to be illegal. Para 9.
She is a woman. She is belonging.
She is a woman. The post was reserved for scheduled castes. She belonged to scheduled caste women. Since the post was not reserved for scheduled castes women, she could not have contested for that post, and the election was held to.
So a woman is not a scheduled caste. In your submission, we are not able to.
My submission is, my submission is, my lord, I will take your lordships through the notification, my lord, first.
Let us
Yes,
read
this judgment, my lord, in this judgment, it starts from para 8, my lord, may I request. Para 8, Supreme Court's judgment is observed.
That was where it was. She was elected from a different constituency.
Yes, yes.
That will not have any.
Yes.
What is parallel? Elected from scheduled caste women.
Yes.
She was elected from a constituency reserved for SCW.
SC.
Adhyaksha has been reserved for SC.
SC.
Shall be filled up only from among the elected from the constituency reserved for SC.
And I have also relied upon identical matter Bombay High Court judgment. Next judgment.
Was this judgment challenged?
No, ma'am.
It's
Karnataka
not
High Court
challenged.
judgment, ma'am?
It's not challenged.
Karnataka High Court judgments?
First
Vimala Nayaka versus Rani.
Yes.
Vimal Naik.
Ah.
This I have to verify.
Thereafter, my lord, I have also filed one more. My lord.
It is not.
That I will answer
will.
that question.
She was selected from scheduled caste woman.
Please.
Adhyaksha is reserved for scheduled caste.
Yes.
Please.
The finding given is it could be only a scheduled caste person, not a scheduled caste woman.
That is
only
wrong.
the finding.
Yes.
That is very, against judgment is against the very concept of reservation. Because if it is for the general, even women can be participating.
General, everybody can participate. That is not
many number of this.
When it is reserved for scheduled caste women can also
Be
participate.
That is the issue. That is the issue.
How can that?
That
be
is the issue.
prevented?
My lord, I am that is the issue. My lord, may I take to lordship?
So we are asking
Yes.
this is
Third-
challenge because
Yes.
there is some confusion which
Yes.
has happened.
For clarity, my lord, the third judgment I am relying, identical issue arose before the Bombay High Court also.
Bombay.
Married. Para 8, it starts from para 8. A. Para 8. A. Married, my lord. The bone of contention of the learned counsel for petitioner is that as per the second proviso to rule 4A of the rules, if the office of Sarpanch is reserved originally for a woman belonging to backward class of citizens, then the office of Sarpanch for the same tenure can be de-reserved and the office of the Sarpanch can be allowed to the backward class citizen, including male and female members.
That was back BCW.
Yes, yes.
And BCW was to be made into BCM or BC.
Yes. The issue is just this, my lord. When the post is reserved for SC, when the post is reserved for SC women, and the candidate belonging to SC woman is not there, whether SC man can contest for the election for the reserved post.
Facts. What are the facts here?
In the present set of facts. Present set of facts, my lord. Your lordship may kindly see page 23 is the notification. My lord, the earlier round of litigation, the rotation with respect to various town municipal councils were challenged. It went up to the Supreme Court. The matter is still pending before the apex court. Before the apex court, my lord, state filed an affidavit.
STW.
Yes, ma'am. The state filed an affidavit and issued fresh notification, page 22. Page 22, this is the notification. In this notification, my lord, across the state, various town municipal councils have been reserved for the post of president and vice president. The petitioners would be at serial number 5, page 23, serial number 5. The post for president is reserved for ST women.
Yes.
We are only concerned with president, my lord. And similarly, my lord, in all the other town municipal councils, the category has been subclassified between men and women.
Yes.
Men and women. Now, in the petitioners,
not men and women. Men again illa.
Men again illa. Oh, men again illa.
So and so woman or
yes,
so and so.
Yes. That is the case, my lord. Now, in the present town municipal council, there is no candidate belonging to ST women. Now, the decision is taken by the deputy commissioner, stating that since there is no woman candidate, we will allow men to participate for that post. That I have challenged before this court on the ground that section 42 of the act does not allow such subclassification within the reserve category.
Change of classification.
De-reservation, change of classification. On that context, my lord, I am relying upon this Bombay High Court judgment.
Yes.
Para 8A, my lord, this is the contention taken. The bone of contention, my lord, para 8A. Sarpanch can be allowed to the backward class of citizens, including male and female members. That was the contention taken. On this analogy, learned counsel for the petitioner contended that in the present case, the office of Sarpanch is reserved for women from general category and no candidate is available for the women members of the general category to be appointed to the office of Sarpanch. Therefore, petitioner can be allowed to contest the election to the post of Sarpanch and his nomination form ought to have been accepted because there is no other contesting candidate available either from the general category or from the reserved category. This contention of the learned counsel for petitioner is devoid of any merit. And the identical provision section 42, my lord, in the Maharashtra Act is extracted. Para 9 is very relevant. May I read para 9?
So what is said is it has to be kept vacant.
It has to be kept vacant. There are subsequent developments also. After this, my lord, the High Court held that there cannot be subclassification within the category. Maharashtra government brought in an amendment to the identical provision, wherein subclassification, when there is a candidate, women is not available, it can be reserved for men also. Similar amendment was brought into force. And this question came again before the High Court, Bombay High Court. This time, my lord, last judgment. This time, noting the amendment to the law, the High Court held it is, since the law is amended, the provision is amended, de-reservation is permissible. Therefore, it cannot be found fault with. Amendment is at page 3.
Which is the provision 42?
42. In the current Karnataka Act, there is no such provision enabling for de-reservation and subclassification within category. It only speaks, my lord, when if ST is not there, SC, if SC is not there, then backward class. 2A, 42 2A.
Where's the impugned order?
Yes, impugned order is that, my lord, page,
Page 33, annexure F.
page 33, my lord.
It's passed by the deputy commissioner.
Yes,
Let's read this.
yes. Last,
Full one.
ಆದ್ದರಿಂದ ಜಿಲ್ಲೆ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆ 10ನೇ ಅವಧಿಯ ಅಧ್ಯಕ್ಷರ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳಿಗೆ ಕರ್ನಾಟಕ ಪೌರಸಭೆಗಳ ಅಧಿನಿಯಮ 1964 ಹಾಗೂ ಪೌರಸಭೆಗಳ
ಮೇಲಿಂದ. Let's see the reason from the beginning.
May I read from top, my lord? ಮೇಲ್ಕಾಣಿಸಿದ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಉಲ್ಲೇಖ 1 ಪತ್ರದಲ್ಲಿ ರಾಜ್ಯ ನಗರ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳು ಮತ್ತು ಅಧ್ಯಕ್ಷರ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳಿಗೆ 10ನೇ ಅವಧಿಯ ನಿಗದಿಪಡಿಸಿದ ಮೀಸಲಾತಿ ಅನ್ವಯ ಚುನಾವಣೆಯನ್ನು ಜರುಗಿಸಿ ವರದಿಯನ್ನು ಸಲ್ಲಿಸುವಂತೆ ನಿರ್ದೇಶಿಸಿದ್ದು ಇರುತ್ತದೆ. ಉಲ್ಲೇಖ 2ರಲ್ಲಿ ಪುರಸಭೆಗಳ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳಿಗೆ 10ನೇ ಅವಧಿಯ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆಯ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಹಿಂದುಳಿದ ಅಪ್ರವರ್ಗದ ಮೀಸಲಾತಿಯನ್ನು ನಿಗದಿಪಡಿಸಿದ್ದು ಇರುತ್ತದೆ. ಆದರೆ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆಯಲ್ಲಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆ ಸದಸ್ಯ ಸ್ಥಾನವು ಇಲ್ಲದೆ ಇರುವುದರಿಂದ ಸದರಿ ಪುರಸಭೆಯ 10ನೇ ಅವಧಿಗೆ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳಿಗೆ ಚುನಾವಣೆಯನ್ನು ಜರುಗಿಸಿರುವುದಿಲ್ಲ. ಉಲ್ಲೇಖ 3 ಮಾನ್ಯ ಕರ್ನಾಟಕ ಸರ್ಕಾರದ ಪತ್ರದಲ್ಲಿ ಕಾನೂನು ಇಲಾಖೆಯೊಂದಿಗೆ ಸಮಾಲೋಚಿಸಿ ಕಾನೂನು ಇಲಾಖೆಯ ನೀಡಿರುವ ಅಭಿಪ್ರಾಯದನ್ವಯ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆಯ 10ನೇ ಅವಧಿಯ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮಹಿಳೆ ಮೀಸಲಾತಿಯ ಬದಲಾಗಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಮೀಸಲಾತಿಯನ್ನು ಪರಿಗಣಿಸಿ ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮ ಕೈಗೊಳ್ಳುವಂತೆ ನಿರ್ದೇಶಿಸುತ್ತಾರೆ. ಆದ್ದರಿಂದ ಜಿಲ್ಲೆಯ ಅಣ್ಣಿಗೇರಿ ಪುರಸಭೆ 10ನೇ ಅವಧಿಯ ಅಧ್ಯಕ್ಷರ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಸ್ಥಾನಗಳಿಗೆ ಕರ್ನಾಟಕ ಪೌರಸಭೆ ಅಧಿನಿಯಮ 1964 ಹಾಗೂ ಕರ್ನಾಟಕ ಪೌರಸಭೆಗಳ ಅಧ್ಯಕ್ಷ ಮತ್ತು ಉಪಾಧ್ಯಕ್ಷರ ಚುನಾವಣೆ ನಿಯಮಗಳ 1965 ನಿಯಮಗಳಂತೆ ಚುನಾವಣೆ ಜರುಗಿಸಲು ಈ ಕೆಳಕಂಡಂತೆ ಕೋಷ್ಟಕದ ಅಂಕಣ 2ರಲ್ಲಿ ಸ್ಥಳೀಯ ಸಂಸ್ಥೆಗಳಿಗೆ ಅಂಕಣ 3ರಲ್ಲಿ ಮೀಸಲಾತಿ ಅನ್ವಯ ಅಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಅಂಕಣ 4ರಲ್ಲಿ ಮೀಸಲಾತಿ ಅನ್ವಯ ಉಪಾಧ್ಯಕ್ಷ ಸ್ಥಾನಕ್ಕೆ ಚುನಾವಣೆ ಜರುಗಿಸಿದ ಬಗ್ಗೆ ನಡುವಳಿಯೊಂದಿಗೆ ವರದಿ ಸಲ್ಲಿಸುವ ಅಂಕಣ 5ರಲ್ಲಿ ಅಧಿಕಾರಿಯನ್ನು ಗೊತ್ತುಪಡಿಸಿದ ಅಧಿಕಾರಿಯನ್ನು ನೇಮಿಸಲಾಗಿದೆ. ನಾವು ಇನ್ ದಿ ಬಾಕ್ಸ್ ಮಲೋಡ್ ಯು ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ಅಧ್ಯಕ್ಷ ಮಲೋಡ್ ಇಟ್ ಈಸ್ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಅಂತ ರಿಸರ್ವ್ ಮಾಡಿದೆ. ಉಪಾಧ್ಯಕ್ಷ ಹಿಂದುಳಿದ ಎ ವರ್ಗ ಅಂತ ಮಾಡಿದ್ದಾರೆ. ಅಂಡ್ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್.
Corresponding change happened in any other constituency, in any other panchayat?
No, it has to be, that is.
Is there a corresponding change happened in any other? This is only for Annigiri.
Yes.
ಬೇರೆ ಎಲ್ಲಾದ್ರೂ SC
ಆಗಿದಾವ್
ಇರೋದು STW ಆಗಿದೆಯಾ?
7 constituencies.
There are about
7 constituencies, there is a changes. 7 constituencies, there are the changes.
Page 28, my lord, page 28.
Yes. 28.
Page 28, my lord, is another notification issued on the very same day of reservation notification. This prescribes, my lord, at any given point of time, total number of men, women, that classification, this has to be maintained. If there is any change in one constituency, my lord, it creates a ripple effect everywhere. That has to be changed.
Yes.
Now, your lordship may kindly see page 23, page 23 ali, in the main notification.
Yes.
They have subclassified into men and women all the constituencies, not only one.
Men classification.
I mean, de-reserve ಮಾಡಿದ್ದಾರೆ. They have reserved for
STW na ST
yes, ಮಾಡಿದ್ದಾರೆ. Almost all of the constituencies now they have reserved.
ಬೇರೆ ಎಲ್ಲಿ ST ಇದ್ದು ಚಿಕ್ಕನಾಯಕನಹಳ್ಳಿ ST ಇತ್ತು.
Yes.
ಅದು STW ಆಗಿದೆಯಾ?
ಅಲ್ಲಿ ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. ಇದು one petition I have also filed wherein
ST.
Bhatkal town municipal council there also this similar decision was changed. This honorable court has stayed that matter also. That is also pending before this. There are several instances, there are several town municipal councils where the candidate itself is not available. Now they are arbitrarily de-reserving and giving favorable this thing.
De-reserving and okay. Anything else?
That is one submission, my lord. My submission is, my lord, the solution for this anomaly, if I may suggest, is that, my lord, if a change is done in the one of these council, it creates a ripple effect. All the constituencies have to be changed. Instead, my lord, as per this section 42, it says that when the ST candidate is not available, SC has to be prepared or backward classes. Now they have reserved for ST women. Candidate is not available. I am the next available candidate in SC. The opportunity should be given to me. That is my submission.
SCW.
Yes.
Yes.
Please. My lord, the section 42 mandates that for every municipal council, there shall be a president and vice president. Kindly mark this.
Yes.
So the question of giving a vacancy of the particular post does not arise. This is my first submission. Second is, this is not a de-recognition of the reservation. This concept is never contemplated under the Karnataka Municipalities Act. Karnataka Municipalities Act section 42 only direct the government to, in the mandate, considering the mandate of section 42 and considering the constitutional mandate, to provide for the notification. Well, admittedly, in the present case, A notification or order has been issued by the Deputy Commissioner of Dharwad. She have no locus standi to issue the notification, I admit that. The only proper party is the government is required to be issued in this case, but that has not been done in this case.
ಇನ್ನ ಮಾಡಿಲ್ವಾ?
ಮಾಡಿಲ್ಲ ಅವ್ರು ಗೌರ್ಮೆಂಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು.
ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗಲೂ ಮಾಡ್ಲಿಲ್ವಾ?
ಅಲ್ಲ ನಾವು ಕೇಸ್ ಹೇಳಿದ್ವಿ ತಮ್ಮ ಮುಂದಿರ್ಬೇಕಾದ್ರೆ ಬೇಡ ಅಂತಂದು ಹೇಳಿ ಬಿಟ್ರು ಅಷ್ಟೇ. So that is the reason why it is the Deputy Commissioner Malad have no authority to issue the notification like this.
Now it is 50% number ಎಲ್ಲ ಇದೆ ಇಲ್ಲಿ.
Please.
And of 2A, such number of officers of the President, Vice President, State for the purpose of so on, as nearly as may be in proportion to total number of officers in the state. So ಅದೆಲ್ಲ ನೀವು workout ಮಾಡಿ 27% ಅದೆಲ್ಲ ಬರುತ್ತೆ. And now if there is no particular constituency which is fixed as STW ಅಂತ ಯಾವುದು ಇಲ್ಲ.
ಯಾವ್ದಿಲ್ಲ.
That also will undergo a change every
roster will be
every roster every twice in a election
per year ಗೆ ಎರಡು ಸಲ ಚೇಂಜ್ ಆಗುತ್ತೆ.
So now you are midterm idu.
Mid the last term.
Second term.
Yes, second term. It is second term.
Term of election, second term.
Yes,
please.
So if you are now you have done a reservation for, when you did that only you should have known.
Please.
Who is elected, who is not elected.
ಅಲ್ಲ ಅದನ್ನ one proposition. One Malad, the data which is at the lower level is not available because this reservation will be made on the basis of state-wise population and all those things. Whether the particular woman is represented or not, that will not feed it into that software which has developed. So therefore, this anomaly has caused. This anomaly has caused because of that. At the point of when the reservation is given, the overall picture has been taken the state and reservation has been given. So because of that, ST woman was not there in the particular municipality. So this problem has occurred. So therefore, this honorable court in the writ petition has directed the government to consider this.
Yes.
So there is in respect of same person. This order, in terms of this order, state has an obligation to act and issue the notification. That they have not done it. And not the court has accepted that if the woman candidate is not available, state is directed to, in terms of the Supreme Court, this we have not done it.
Do the entire exercise.
This we have not done it by issuing the notification.
Now that STW undergoes a change in Anigiri.
Please.
Somewhere else there should be one more STW.
Yes. Please, but now, my lord, all the 98% of the elections have been already completed.
If it is completed, then how do we?
Therefore, my lord, the problem has to be answered by the government. I'll make one submission. In terms of the direction given by this honorable court in the earlier writ petition, the government will issue the appropriate notification, not the manner in which be done in the present case.
Then,
my lord, otherwise, my submission is that
that submission doesn't answer.
Maybe, my lord, one woman may be not represented. The consequences, no. Reservation. Suppose, my lord, if the ST
urgent, but this is an important issue which
please.
has ramification.
Please.
Now yellow ಹೋಗ್ತಾ ಇಲ್ಲ ನೀವು ಎಲ್ಲೂ ಇಲ್ಲ.
Please.
See, if you do it that way,
please,
then we cannot answer the contention that ST woman illa SCW ಮಾಡಿ ಯಾಕೆ ST ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಅಂತ.
Please, I answer that question. In the previous occasion, scheduled caste is already represented in the Anigiri municipality more than twice. ST was never represented for last 25 years. Last 25 years, ST was not represented.
It is totally.
So, suppose, my lord, if the SC has been given, if the contention of the petitioner is accepted, that is also that will also increase in the reservation is given to the scheduled caste also.
Adike, there has to be a corresponding change.
Please, so therefore,
corresponding change, this kind of argument will be there.
So therefore, my most respectful submission is that, in terms of the direction given by this honorable court, I admit that the deputy commissioner should not be done it.
Solution has to be there. We are not on that.
Please.
Suppose the STW and ST madidira. Are there any other constituency where ST is there and elections are not held? It can be made into STW if there's a woman candidate.
That I'll verify. That I verify.
Parallel lag then the numbers remain the same.
Please.
Nobody can have any issue.
Correct.
And in future in your software you should have that.
Please, that even considering the lower data also, data which is available, whether the particular candidate is available. While doing the circle manner, So if one aspect is being taken,
Put it simply, it is complete non-application of mind in notifying, reserving a president post for STW when there is no STW in that panchayat.
ಅಲ್ಲ, ಅದು ಡೇಟಾ ಫೀಡ್ ಆಗಿರಲ್ಲ ಅದಕ್ಕೆ, ಅದು ಈಚ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂನ್ಸಿ ವೈಸ್ ತಗೊಂಡಿರಲ್ಲ.
ಸಾಫ್ಟ್ವೇರ್ ಬ್ಲೇಮ್ ಮಾಡಕ್ ಆಗಲ್ಲ.
ಅಲ್ಲ, ದಟ್ ಇಸ್ ಹ್ಯೂಮನ್ ಮೇಡ್.
MS Word use ಮಾಡ್ತಾರೆ ಅಂತ we can't blame MS Word.
But even one submission, even if the contention of the petitioner in toto accepted, my lord, that is also amount to change. One or other way it is going to be changed itself.
Change is inevitable.
Inevitable. Please.
Because the
that is the
post
only
has to be
message.
filled.
Please.
But it has to be done in terms of 42 by a corresponding one.
Please.
So if there is some some constituency which has ST, and elections are not held.
Please.
If there is a woman candidate available, that can be made into STW, and this could be made into ST, so that 42(2)(a)
Please.
sanctity is preserved.
Please. Keeping in the mind of mandate of section 42, the authority will redo.
Collectively, it has to be done collectively, not individually with respect to each town municipal councils.
Only 2 municipal councils have to undergo a change.
Yes.
We don't need to do everything.
No, not everything.
This is coming from STW to ST.
Yes.
Another ST should become STW.
Yes. But one more submission, my lord.
Reservation.
No, I'm not on that. My one more legal anomaly is there, my lord. Legal anomaly is
last time elect agidra.
No, I was not elected. That is one incorrect submission made by the learned respondent. Annexure really last 40 years in the SC no yaru illa, ST no yaru illa. That is incorrect submission. Annexure prakara the official communication annexure
2018 ಅಲ್ಲಿ will
Deputy Commissioner himself.
2018 scheduled caste women is
Deputy
represented.
Commissioner himself annexure
This change. Monday helakagutta.
ಅಲ್ಲ, one submission. Let me direction to the government considering this.
Our
litigation ಬರುತ್ತೆ.
Please, please. ಆಗ್ಬೋದು. That's fair enough.
Approve it, then
Fair enough.
let them place any change before this court, my lord.
Please. Yes. ಆಗ್ಬೋದು.
So ಯಾವಾಗ ಹೇಳ್ತೀರಾ?
Monday ಬೇಡ. Tuesday, my lord.
Tuesday.
Let them place the changes before this court, my lord. Please.
ಅದೇ ಹೇಳ್ತಾರೆ.
Yes.
At the request of learned AG, relist on. We won't say anything. We'll just relist on.
Please.
Relist on Tuesday, 11th at 2:30 p.m.
Please.
Hello. 85 SC Solar Guppa.
Please, my lordship. I'm for petitioner. Petitioner is educational institution.
ಎಷ್ಟಿದೆ ಅಮೌಂಟ್?
ಬ್ಯಾಂಕ್ ದೊಳಗೆ
Bank
8,48,000 ಇದೆ.
8,40,000 is the
8,32,000, sir. Sorry.
told.
Bank statement I brought.
8,32,000.
Please.
So we'll restrict the attachment to 5,31,000. The claim. No balance you can deal with.
50% of that 5,32,000.
50% ಹೆಂಗಾಗುತ್ತೆ? ನೀವು ಕೊಡ್ಲೇಬೇಕಲ್ಲ.
Madam, actually the liability is very less, sir, but he has passed the order on ad hoc basis.
ಎಷ್ಟಿದೆ liability according
Liability around 2 lakhs ಮಟ್ಟ ಬರ್ದಿದೆ, sir.
On what basis do you say that?
So actual wages ಮೇಲೆ ಮಾಡಿದ್ರೆ around 2 lakhs ಬರ್ದೈತಿ, but they have passed order on ad hoc basis. So ಅದಕ್ಕೆ kindly 50% of that amount ಆದ್ರೆ agree, sir.
This order is final. ಇದು ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ ನೀವು.
45A is a part of this petition.
The order passed under 45A ಚಾಲೆಂಜ್ ಮಾಡಿಲ್ಲ.
It is a part of this petition.
You challenge it here.
It is a appeal ಮಾಡ್ಬೇಕಂದ್ರೆ ಅದು ಇಟ್ಸ್ ಆಲ್ರೆಡಿ ಲ್ಯಾಪ್ಸ್.
ಅಪೀಲ್ ಹೋಗ್ಬೇಕು, ಇಲ್ಲಿ ಬರಕ್ಕೆ
ಲ್ಯಾಪ್ಸ್ ಆಗಿಬಿಟ್ಟಿದೆ ಸರ್, ಭಾಳ ಲೇಟ್ ಆಗಿದೆ ಡ್ಯೂ ಟು ಕಮ್ಯುನಿಕೇಶನ್ ಗ್ಯಾಪ್ ಬಿಟ್ವೀನ್ ದಿ.
So now that that has attained finality, I cannot say that my liability is less.
Please, madam.
ಅದು ಅಮೌಂಟ್ ಕೊಡ್ಲೇಬೇಕು ನೀವು.
ರಿಮೈಂಡ್ ಬ್ಯಾಕ್ ಮಾಡಿದ್ರೆ at least provide one more opportunity regarding reassessment ಮಾಡಿ ಕೊಡ್ತೀನಿ.
ಕೌಜಲ್ಗಿ
ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದೆ ಸರ್ ಬಂದಿಲ್ಲ.
ESI ಅವರೇ ಅಪೇರ್ ಆಗದ ಕೌಜಲ್ಗಿ ESI.
Vinay Kausalgi?
Please, my lords.
Mr. Kaujalgi, there is
Consequential order has been challenged, my lords, without challenging the original order that is under 45A. And the order under 45 has to be appealed, my lords. There is an appeal under section 75 of the ESI Act, my lords.
But at time lapse agogideyalla Mr. Kaujalgi.
But they can file an application for condonation of delay because we calculate on ad hoc basis if they do not provide us the records. Though all those records has to be submitted before the ESI court, and the ESI court will assess, my lords.
So what we'll do is we'll restrict the attachment to 50% of it, which comes to around 4,20,000.
Please,
which will be a security for you, permitting him to file an appeal.
Please, my lords.
Petitioner is before this.
Name, one more submission, my lords. Name of VM Shilwant may kindly be shown. He is on the panel, my lords.
Registry is direct print the name of Shri VM Shilwant as that appearing for respond number 1 and 2, and delete the name of Shri Vinay S. Kaujalgi as that appearing for respond number 1 and 2. The petitioner is before this court seeking for the following leaves. The grievance of the petitioner is that attachment order has been passed as regards the bank account of the petitioner without any application of mine, inasmuch as the said account holds much more money than what is claimed to be due to the respondents. His submission is that even as per the original order passed under section 45 capital A of the ESI Act 1948, the amount due was rupees 5,38,981, out of which 25% was to be deposited within 60 days. The said deposit not having been made, the attachment of the bank account of the petitioner has been made where there's an amount of rupees 8,32,006. The petitioner maintaining only one single account. The operation of the college has come to a standstill, causing harm, loss, and injury to the petitioner. On inquiry as to whether an appeal had been filed as regards the order under section 45 capital A, learned counsel for the petitioner submits that an appeal is proposed to be filed. Taking into account the said submission and the considered opinion that the petitioner being a college, the interests of students and the staff would be adversely affected if the petitioner were not to be able to operate the account. The account as indicated above, having a credit balance of 8,32,006, the attachment is restricted to a sum of rupees 4,00,000, subject to any appeal to be filed by the petitioner within a period of 30 days from today.
Please, ma'am.
In the event of no appeal being filed within 30 days from today, the aforesaid indulgence extended to the petitioner will cease to exist and the petitioner would be liable to pay the entire amount as directed under the 45A order.
Please.
The other above observation petition stands disposed.
Must apply.
86, Suraj Beldakki.
Please, my lord.
Yes.
I appear in 86.11, 86.14 and 86.15.
11, 14 and
15. Mr. Madhu Naik, my lord, has advanced
11 for the petitioner, 14, 15 for the respondents.
for the respondents, land losers.
Yes.
My submissions, my lord, would be very brief. I will, I have prepared a convenience note that is on the file of this court, my lord. And earlier when the had heard, I had given a separate note, particularly with regard to the Gujarat High Court judgment.
Where is the convenience?
It's
Who is
there
going
on
to-
the, it's there on the file, my lord. It's already filed
On what date?
on 25th, my lord.
25th January.
Yes, when it was last listed. In fact, on 24th it was filed. I directed us to file the synopsis before 17th. So we have also exchanged it with the other side.
You filed it in 86.11.
Yes, 86 point. They are all convenience notes in all three, my lord. It's with a caption.
In which
All the
petition have you
three.
filed it, Mr. Nayak?
First one, my lord, 86.11.
86.11, my lord. Yes. You filed it only in 86.11.
Please, with the caption continue.
ಇದು ಬೇರೆನಪ್ಪ ಇದು. This is 2023 ಇದು. Memo for production of judgment 1823.
Yes, that is memo for production of judgment, my lord.
What
By
is
the court judgment. On the last occasion, we have filed convenience notes.
Convenience note, yes, we got it.
Yes, with a caption, my lord, convenience notes in WP so and so connected with so and so and so and so.
Yes.
Please, my lord, the background facts I need not recapitulate. Quickly take your lordship through the basic facts. There are two land losers. One, my lord, 103322 of 23. That is the petition filed by us. Petition number 1 is one Deepa Dilip Naik.
Yes.
She is the owner of 3 acres, 7 guntas, 8 acres, Shirwad village of Karwar Taluk.
Yes.
So, preliminary notification dated 19/10/93 for the benefit of Konkan Railway Corporation, my lord, her land was acquired. Konkan Railway Corporation is respondent number 1 in my writ petition. Now, my lord, as I will, for sake of completeness, my lord, I will also refer to the other 3 petitioners. The other petitioners in this writ petition are representatives of Vitoba Shankar Faide.
Yes.
Who was the original land loser. Your lordship gets it at serial number 2 or paragraph 2 on the second page.
Yes.
So they are LRs of one Vitoba Shankar Faide who died during the pendency of 28A
Yes.
before the SLAO. He was owner of 1 acre, 28 guntas, 12 enas in very same village, whose land was also acquired for KRCL by the notification.
Yes. There are no dispute about all these things.
There is no dispute, my lord, as these petitioners did not seek a reference under 18, they filed section 28A application. So to be decided on various dates, different dates, my lord, by the SLAO, and a sum of 18,250 has been awarded per gunta. As my lord, the beneficiary Konkan Railway did not comply with the award passed by the SLAO. All of us collectively, my lord, filed the first petition seeking a mandamus from this honorable court. When notice was issued, and after nearly 9 months, Konkan Railway, my lord, would file the other 2 writ petitions challenging the award. That is Then, my lord, after nearly 9 months from the date of award, and after 7 months or around 7.5 months from the date of filing of the writ petition, they woke up from this slumber and they filed these two writ petitions challenging the award on various grounds. Mr. Naik, my lord, on the last day, that is Mr. Madhusudan Naik, had submitted on 9/1, he had, my lord, submitted a brief synopsis with 4 propositions.
Yes.
Then subsequently, when he argued on 8th or 29th, on 28th, my lord, he has filed 2 separate notes. That is one in my writ petition, 03322 of 23. My lord, he has added one more proposition. This is similar to the note which he had filed with 4 propositions. The only proposition which he has added in this note.
When was that filed? 9/1/25 is the first one. Second one?
Yes, 9/1/25, my lord, is a 1-page note.
Yes.
One note containing 4 propositions. On your lordship was pleased to direct all of us to file our brief synopsis by 7th.
When was that filed, Mr. Naik? Please answer.
9th. He had handed it over to the court on 9th. He was physically
9th,
present.
we have that. You said another one has been filed. When is that?
Yes, another is filed on 27th. I'm sorry.
27th.
27/1. That is dated 27/1. Yes, that is dated 27/1, and on 28th, Mr. Madhu Naik argued.
Judgment alappa, no to.
My lord, the caption is in WP 103322. The caption is note of submissions / written arguments of respondents.
No writ would lie to execute an award, and therefore the present writ petition is not maintainable. Is that what?
Yes, whether a writ petition would like to enforce, yes, 5 propositions.
Dated 22/11/23, what we have.
Probably it's filed multiple such things, but the latest one filed before your lordship is this. On 27/1, running into 21 pages.
That was filed in which matter?
That was filed in 103322 of 23.
10.
That is in my petition, where I am the petitioner, or rather where we are the petitioner.
86.11.
Yes, 86.11.
My lords, I would just like to clarify, my lords, that note was not handed over to the court. My lords, Mr. Naik had made reference to his note
of 23.
No, my lords, filed on 27. There's only one note, my lords, the main note, and the propositions have been elaborated in that note, my lords, where Konkan Railway is the petitioner and the respondents are the landlords, my lords. It's a 33-page note, my lords.
That is in the 2 petitions filed by KRC.
Yes, the reference was made only to that note.
Judgment.
My lord, there is some confusion. Mr. Suraj is clarifying that note which I am referring to is not presented.
Yes, but there's another note of 23 pages. So we are looking at
33 pages.
33 pages.
Yeah.
Yes, we remember that note, but it's got mixed up with all the papers. We have made
Please,
notes.
anyway, my lord, if your lordship has the proposition dated 9/1,
Yes, we have that.
to the proposition which he has raised and argued finally on 28th.
ಇಲ್ಲ ಅದನ್ನೇ ಅರ್ಸತಿ ನೋಡ್ ಪ್ರಯೋಜನ ಇಲ್ಲ ಅಲ್ಲಿದೆ ಇದನ್ನೇ ನೀವು ಉಲ್ಟಾ ಮಾಡ್ಕೊಂಡ್ರೆ ಏನು ಸಿಗಲ್ಲ. Yes.
The 91 proposition, my lord, were 4 propositions which he finally argued on 28/1/25. So to meet his propositions, my lord, my convenience notes from page 3 onwards, my lord, I have formulated in question and answer form. That is, I'm sorry, page 4, Roman 3.
Yes.
My lord, the first proposition was whether a requisite would lie to enforce payment of an award made under 28A. This, my lord, my first submission, a very brief submission would be that award is not disputed. Award passed by the collector is not disputed. My lord, well settled proposition of law that a mandamus can be sought when the person seeking mandamus has a right in his favor. So admittedly, my lord, we have requested this honorable court to direct the beneficiaries to deposit the undisputed amount. So, my lord, their contention that a execution will have to be filed is baseless. And more so, my lord, kindly see 1.3, my answer. Your lordships, in number of judgment, in fact, I have suffered, my lord, an order from your lordship's hands in this WP 2542. Which is at item 5 of the compilation of judgments dated 1/8/2023.
Yes.
Where, my lord, your lordship, in WP 2542 of 22, by judgment 35/2022, had directed, your lordship gets it at page 99 of the compilation.
Yes.
Had directed, my lord, beneficiary therein, that was the Commissioner Ruda, Ramnagar Urban Development Authority, not to deposit the awarded amount under section 28A. The important, my lord, observation is on page 110, the internal page 12 of your lordship's judgment.
Yes.
Wherein your lordship has referred to your lordship's earlier judgment in MSA passed before the Kalburgi bench, where it answers the point of limitation. Para 16, I will not, my lord, read and trouble your lordship. Your lordship has held that this court cannot lose sight of the fact that in most cases, the compensation which is fixed is on the lower side. Further, in that petition, there was a prayer to award the present market value. That was also accepted because the delay was on the part of the authorities. And after this judgment, my lord, passed by your lordship, I prevailed upon the commissioner and him to deposit the amount. And then I am also instructed, my lord, that subsequently another writ petition has been filed by the land losers. Of course, that has no bearing, my lord. Kindly come to page 116 of the compilation.
Yes.
Your lordship's order, operative portion of the order, a mandamus issued directing respondent number 3 to consider the representation of petitioners dated so and so and pass orders in accordance with law within a period of 2 months. Respondents shall act on said representation without reference to any delay as held by this court in MSA so and so dated 19/11/2021. 3. The respondent shall act on a printout of the uploaded copy, etc., etc.
Yes.
So, my lord, my respectful submission is such directions issued when there is an award and they sleep over the matter. Konkan Railway, my lord, as I submitted earlier, sleeps over the matter happily And this is a project, my lord, which was initiated in the year 1991 by the central government. They have acquired all the lands in and around Karwar Taluka, my lord. And they are happily operating for the past 30 odd years now.
Here your prayer is mandamus to pay the compensation.
Yes,
It is
as
not enter a
as
representation.
no,
They are
there,
also-
my lord, there the representation was to give the present market value. In addition to a prayer made therein, an additional prayer was made in the presentation.
To pass award. There was no award passed. Now there's award in your favor. Yes.
Yes, there is an award in my favor, my lord.
Yes.
Because left over the matter, even after nearly 9 months, we had to file this writ petition. They did not dispute, my lord, till such time we filed the petition seeking a prayer for mandamus. So, my lord, now they cannot argue that a writ petition is not maintainable, is my respectful submission as far as the first proposition. Because they don't dispute the award.
Yes, Mr. Naik, proceed.
Yes.
Don't be
Please, my
repeating.
lord, now the second proposition, my lord, is with regard to some suo motu review. This is only with regard to Deepa's case. The review which Mr. Madhusudan Naik, my lord, was trying to highlight was the calculation. So in that regard, my lord, I would request the court officer to hand over 105586. That is the writ petition filed by Konkan Railway against Deepa. 86.14.
Yes.
There, my lord, the award has not been reviewed. Your lordship may turn to
Page
page
number?
37, which is produced as Annexure A.
Yes.
Kindly see the award, my lord. This is award dated 1/7/2022.
Yes.
This is the award given to Konkan Railway as well as the land loser Deepa. Now, along with that, my lord, there is a calculation sheet which is at page 39. This is provided to land loser. Your lordship may kindly see the calculation. 1,44,82,778. The calculation, my lord, made by the LAO, which was appended along with the award. Now kindly page 40. This is the award, my lord. If both are juxtaposed, the award which is furnished to Konkan Railway. If this is juxtaposed with the award that is furnished to Deepa, both are same. There is no review of award. Award is same. It's a 2-page award, my lord. Award is same. The calculation sheet furnished to Konkan Railway is on page 42.
Yes.
Now, in this calculation, my lord, the SLAO says it is 1,50,49,314. So this is what Mr. Madhusudan Naik was arguing, that there is a review of award. There is no review of award. There is review of calculation that is provided.
Yes.
My lord, if page 39, the calculation sheet provided to me on page 39 is juxtaposed with the calculation sheet at page 42 furnished to Konkan Railway, the difference, my lord, is in the tree values. Your lordship may kindly see in my calculation sheet, the tree values and structure values were added.
Yes.
Whereas in the calculation sheet given to KRCL, it is 0, 0. So the total compensation in my calculation sheet was 2641,431. Then accordingly, my lord, correspondingly, the solatium and the 12% additional compensation, etc., was around, so the total compensation was 3615,359 in my calculation, whereas in their calculation it is 3263,618. The change in figure is the amount awarded and paid by SLO, that is item 8. On page 39 given to me, it was 779,788. Whereas in the calculation sheet given to KRCL, the SLO has corrected the amount, that is 317,125.
So which is the correct amount?
Now that the state government will have to, my lord, answer. But if I am entitled to this, then certainly, my lord, your lordship can direct, because I had sought a mandamus based on the calculation given to me, that is 144,82,776.
Which is the lesser amount?
Which is the lesser amount. On the day when I filed the writ petition, I had this calculation sheet.
So you're not asking for the higher amount at page 42.
No, if I am entitled to, my lord, certainly I will. If it is the mistake of the SLO in calculating, so it cannot be argued that the award is reviewed. It is absurd to contend, to say the least. Because if both are juxtaposed, my lord, what is the review is he talking about? There is no review.
Yes.
Be responsible in making such submissions. If 37 and 40 are compared, that is the actual award. The comma, full stop, my lord, of the award is same.
Yes, go ahead, Mr. Nayak. You are repeating.
So, my lord, there is
and
no, please, there is no review of the award, my lord, is my respectful submission.
Yes.
As far as third proposition, that is, my lord, with regard to limitation. He relied on the Gujarat High Court judgment to contend, my lord, that I have obtained the copy from the advocate of Nethalkar and I have annexed the copy. 28A application. Hence, there is delay. Delay, my lord. On the very next day, Mr. Nethalkar's counsel has applied. So it has been delivered to him on a particular date. So I have reckoned the date from the date of delivery to Mr. Nethalkar's counsel, that is Mr. K.S. Kinnerkar. Even if that is seen, my lord, there is no delay. In answer to proposition 3, I have mentioned, my lord. So there is no delay is my respectful submission.
In this, you are saying that another note of 18.124 has been filed, which may be looked into. Where is 18.124 now?
Yes, that is specifically, my lord, with regard to, that is the 4-page note.
18.124 note.
For ready reference, I think Mr. Chiknargun, my lord, I had requested him to have that note.
18.124 note.
With the caption, with the caption clarification with regard to judgment of Gujarat High Court. Your Lordship got it.
Yes.
Yes. My Lord, here I have referred to the Constitution Bench judgment in Hansoli Devi, 2002 judgment, my Lord, and also refer to your Lordship's judgment in MSA, where I have called out paras 13.16, 13.17, 13.18, 19 and 20. And that I have produced along with the compilation also.
Yes.
So, my Lord, in a nutshell, your Lordship had held in this MSA, which has attained finality, that the land loser cannot be expected to sit on the corridors of the civil court. Here is a case where they have obtained copy on the very next day. And on the day, on the very, within 90 days, the copying period, my Lord, that consumed to be supplied to Mr. Netalkar's advocate has been deducted. So we are well within time.
Yes.
So that is my respectful submission, my Lord. And in Hansoli Devi, the Honorable Supreme Court, if your Lordship permits me, has held, and that's a Constitution Bench judgment, my Lord, which I have produced as at item 1 in the compilation 2002 7 SEC 273.
Yes.
The Honorable Supreme Court in paragraph 9, my Lord, has held that when the words of the statutes are in themselves precise and unambiguous, then natural and ordinary meaning should be assigned to them. So 28A1 of the Land Acquisition Act refers to the word copy of the award. Proviso, my Lord, to 28A1 of the Land Acquisition Act refers to copy. So we have annexed the copy. So, my Lord, they cannot argue that because we have obtained the copy and relying on a 98 judgment of Gujarat High Court, they are trying to argue, my Lord, that our application is time barred. And this contention they had not urged before the land acquisition officer. For the first time before this honorable court, they have urged this contention, my Lord, is my respectful submission.
Yes.
And as far as the fourth proposition, my Lord, is whether in the absence of a provision for payment of interest under 28A, in a nutshell, contention of Mr. Madhusudan Naik was there was delay of 12 years in deciding the 28A application. Hence, cannot be faulted with, and as a result of which the interest cannot be mulcted on Konkan Railway.
Yes.
Now, my Lord, look at their conduct. All along the applicants, that is the land losers, have appeared before the land acquisition officer. For reasons best known to the land acquisition officer, my Lord, the application was not decided, mainly attributable to transfers by the government. After it was heard in 2019, where personally I appeared, after delivered the judgment in Kalburgi bench, I issued a notice to the Deputy Commissioner as well as the SLAO, which is annexed, my Lord, along with my objections in 103 in KRCL versus Deepa's petition. My objection may kindly be seen, my Lord.
In which petition?
In both the petitions I have filed.
Objection statement. 105586.
Yes, 105586. Annexure R1B may kindly be seen.
R1B.
R1B, B for Bangalore, Miller.
Hmm.
There I have issued a notice. That is 24/6/21 to the Special Land Acquisition Officer. That is a joint notice on behalf of both the land losers.
Yes.
There I said in para 2, this will also bolster my argument with regard to limitation. Para 2, the said applications were filed on 17/11/2008 and 5/11/2008 respectively. On 9/7/2019, the said cases were heard and reserved for orders. However, orders have not been passed till date. Para 3, it is relevant to mention here that the Honorable High Court of Karnataka, Kalburgi bench in so and so, in paragraph so and so, has held as under 4, my lord. Hence, it is crystal clear that it is incumbent on the part of the state to award higher compensation to similarly placed land losers arising out of the same notification. 5, who are requested to kindly expedite the hearing in the above mentioned cases and dispose of the same at the earliest, as the same is pending for the past more than 12 years and the claimants are all senior citizens. Request you to kindly hear these cases through video conferencing, as the said mode is adopted by all the courts in the country. So, my lord, I have done my duty. I cannot be faulted with this. Notice is dated 24/6/21.
Yes.
There is no scrap of paper on the part of Konkan Railway, not even a memo filed, because the very office represented by Suraj Naik, they used to appear before the SLAO. They have not whispered about delay all along. For the first time, my lord, they have raised this contention, saying that there is delay, hence we.
Anything else?
That's all, my lord. And moreover, I have relied on an Allahabad High Court judgment, which Mr. Nargun will pass, my lord. That is in addition to what was furnished in the compilation. This is 2024 SEC online Allahabad 1253. Paragraphs 18, 21 to 26. Relying on the Supreme Court judgment, my lord, in paragraph 21, your lordship may kindly turn to paragraph 21. Relying on Union of India versus Pushpavati.
It is only on interest.
Yes, interest, my lord. Further, para 22, Sri Vijay Cotton and Oil Mills has been relied on. Then, my lord, 23, 24 and 25, Pradeep Kumari, a 3-judge bench of Supreme Court in Union of India versus Pradeep Kumari, held, that is para 25, held that at the stage of proceedings under section 28A, the collector would act under section 34 in awarding interest on the additional amount of compensation awarded by him. Para 13 of the law reported is quoted below.
Yes.
Para 26, in our opinion, viewed from any angle, the irresistible conclusion is that the collector shall have full power to award interest on the enhanced compensation amount awarded by him under section 28A of the Act.
Yes.
Not apart from these 5 propositions, Mr. Naik, while arguing, may not relied on or rather argued that in Mr. Fide's case, that award is passed against a dead person. That is, my lord, in fact, in my statement of objections in 105650, I have produced, my lord, the application filed by LRs of Vithoba Shankar Fide, that is produced as R1B on ink page 9.
R1D.
R1B, my lord, B for Bangalore.
Yes.
There I have produced the LR application.
He died on 26/4/22.
Yes. Under order 22, rule 4.
No
This
orders
is,
have been passed on this.
please, my lord.
No orders have been passed on this.
Orders have been passed. In fact, by oversight, the LO in the award didn't mention the name of LRs of Mr. Vithoba Shankar Faide.
So where is the order passed on this application?
My lord, no formal order is passed in the order sheet.
That is what we asked you. Is there an order passed? They can only
No,
be
my
a
lord, that
formal
is-
order, Mr. Naik. They cannot be informal order by a court or by authority.
That is not forthcoming because they don't maintain an order sheet. at the civil
We
court.
will pass an informal order now, rejected petition.
Your lordship,
Number 86.11. Dismissed 86.14 and 15 allowed. There has to be a formal order only.
because they don't maintain an order sheet, unfortunately.
Yes.
This is dated 6/12/22. Award,
SLO is not maintaining any order sheet.
at least this, my lord, is not seen.
He is a quasi-judicial authority. He has to maintain an order sheet.
Please, but on this application, there is no order, my lord, at least to
But
my knowledge.
fact is you have filed the application. Yes.
Yes, filed much before the date of award.
Yes. Anything else?
Well, that's all, my lord. They have suffered for nearly 33 years now. The land acquired in 91.
Yes, please.
My respectful submission, my lord, is 86.11 maybe award, maybe allowed, and 86.14 and 15 be dismissed.
Yes. We have
In
passed
fact,
an
Mr.
informal order is passed. Yes.
In
Yes.
fact, my lord, with risk of repetition, if I may submit, Vithoba Shankar Faide, my lord, died during the pendency, waiting for nearly 30 years.
You yourself are saying at the cost of reputation, from that time you have been repeating. Not required. Yes.
Please.
Really.
When it appear for other writ petitions,
How long will you take?
short time only. Because on the interest,
Yes.
on the interest portion of it, I believe Ms. Nayak has argued at length. I'll take that point later on, my final stage.
The same
Meantime, my lord,
judgments are relied upon here also. What Mr. Naik has relied upon. Babua Ram, Papa.
Baba Ramelan, can I take your lordship to that just particular? I have given the citation just now.
Yes, please.
Yes. Now, can you take that particular judgment, Babu Ram, in my compilation, page 49?
Yes.
Page number 49. Relevant paragraph, Malad, is at 44 at page 86.
Yes.
After becoming aware of the introduction of section 28 capital A, it would appear that several antedated applications on section 28A or section 18 were made to use the award made on section 26 to get the benefit of section 28A. Therefore, the application made in 28A create a doubt whether the award in section 26, which forms the basis for which application had been secured on an antedated or fraudulent application purported to have been made under section 18, shall be open to the state to have the matter thoroughly examined by an officer of the status of the district collector or the commissioner to find the truth, and such officer, if on inquiry made with reference to relevant records, finds that the applications under section 28A1 are genuine and were made within the limitation, or the award in section 26 founded on genuine application made on reference under section 18 with limitation. He would cause proper inquiry made so that the benefit of the award in section 26 may become unavailable for such spurious applicants who fraudulently or collusively made applicants in 28A.
What do you have to show that they have made like that?
Yes, ma'am. I have not made some scrutiny on that. Out of 15 cases before the court, 5 cases we have found some defects, serious defects. I may bring to Lordship kind of notice.
Others,
Others are, we did not find anything. Only 5 out of 15, 5.
by the best of efforts made, only 5.
Out of whatever you could do it.
What are the issues?
Well, at petition number 100224. Well, at that Babu Agram case, last sentence also led to complete, Millard. Last sentence also. However, it has been remembered that the collector of the yellow decided in section 28A application that the compensation for land given in the award on 76 or judgment in appeal should form the basis for redetermination of compensation for the applicants. The same amount of compensation need not be given where there are differences in nature, quality, and situation of the comparable land. I'm submission on these 2 points I like to make.
One is spurious application, spurious fraudulent
Spurious
application.
qualification.
Second is difference in the
Yes, whether it has been considered or not.
Okay.
Application.
ಇನ್ನೆಲ್ಲ ಹೋಗ್ತೀರಾ 445 ಗೆ ನಿಮ್ಮ ಸೀನಿಯರ್ ಕೌನ್ಸಿಲ್ ಕೇಳ್ಕೊಳ್ಳಿ. Yes.
Well, at 100224, can you take page number 115?
0224 ಕೊಡಿ. Yes.
That is the application under 28A. Kindly appreciate, Milord, there is no acknowledgement, there is no invert seal, there is no invert number. Whereas in other cases it's there. Here nothing is there. Copy. And Milord, the reference court order they have produced a notarized copy at 99, page number 99. They have produced. And
Yes.
and kindly go to page 112.
112. Yes.
Attested by a notary. Kindly see the date, my lord. 2/12/17. Yes, sir. 10/6/17. Attested by notary public 10/6/17. Similarly, this also, no? 240.
We have verified it.
Yes.
Similarly, my lord, we have verified the invert register also and the original records. Nothing is there. These documents are not there.
It is?
These documents are not available.
Which document is not available?
My lord, the 28 application, not there in the invert register, not the no invert number.
Yes.
My lord, another application 100245. Page number.
61.
Again, no invert.
No invert seal, no acknowledgement seal, no invert seal, no invert number. And also there also, my lord, the page 60, my lord, you may kindly see the notary by 10,617.
10,617.
17.
And 100,785.
I'll come one by one. This is 1245. Then 785.
Inward, but no inward number.
In these two, the other one, no notarized was there. In all other locations, no invert, no acknowledgement, no invert number, nothing is there. It doesn't exist. They are produced, well, kindly see, put on 785 only, page number 51.
Yes.
There is invert seal, acknowledgement. But no number. There is no entry in the invert register.
Yes.
Similarly, in other three cases,
Seal, but no number.
and they have produced the notarized copy of the reference court order,
Yes.
not a certified copy.
Yes.
Similarly, in 298 and 292, same manner.
What about 294?
24. The applicant, there is probably a small mistake is there. I'll let
So the application is prior to the date of the section 18 order.
there could
28A application is 28/6/2012.
well,
18 order is.
but in the SOL record as 12/7/2012, maybe a small mistake. 28/6/2012.
Before the order of
Before
the
the
reference.
order.
294.
Page number.
Page number 81, application.
The dates.
Dates ಬೇಕಾ sir? 137. 81, 137. 137.
The application recorded in the SLA's order. That's a minor.
That's what that's why I'm not very.
Thinking it is the award date.
These five are very serious issues.
Yes.
There are 500 applicants, I believe, pending. We are only seeing a sample of 15. Out of that, 5 itself is fraud. Kindly appreciate, what is the state of mind of the, how is such an order can be passed by a state law?
What are you doing there? You should have pointed at this. Pointed out
Now only we are trying to see scrutiny.
What were your council and your officers doing before the SLO?
But all records are in possession of SLAO.
Huh.
Our officers don't have that, this one.
SLO sits in your office.
No, he is a revenue officer.
He's a revenue officer, but he sits in your
Revenue
office.
department.
His address is your office.
It's a very serious issue.
It's a serious issue, but the SLO is sitting in your office. All the documents are there in your office, and you don't do anything.
They are keeping, I believe they are keeping in the revenue department, not here.
They're not in the revenue department.
Okay.
The SLO is in your office.
No, I don't think so. I'll
Please
get
verify.
instructions. I'll get instructions.
We have verified that in another matter. SLO is exclusively for KNNL.
And deputation from revenue department.
He virtually is a officer of KNNL. And you are saying, your own person who is sitting in your, is doing this.
Well, we have to bring it to the notice of, because this is a very serious. This is the main.
Mr. Kalsurmat will also have to answer that. So, yes.
706.
Where the SLO is sitting, what is his functioning, and what are all these issues? Yes.
Well, another submission, the last sentence of that Babu Ram case, where comparables. Well, kindly see the finding given by the SLO on the award.
In which one?
706. Improved now. Hmm? One same isn't there. It is only same notification. Really.
This is 120. 120.
And on the same notification.
Really?
Same notification.
ಹೌದು ಸರ್.
My request, may read in Kannada.
In which matter?
Page 127, read petition number 100706.
100?
706.
706.
Same notification.
ಹೌದು ಸರ್. ಹೌದು ಸರ್. ಹೌದು ಹೌದು.
Page number?
127, my lord.
Odi. Yes.
My request, my colleague to read in Kannada.
Yes, please.
ಮುಖ್ಯವಾಗಿ ಭೂ ಸ್ವಾಧೀನ ಕಾಯ್ದೆ ಕಾಲಂ 18ರಲ್ಲಿ ಸೋನ್ಸೋ ಅರ್ಜಿ ಸಲ್ಲಿಸದೆ ಸೋನ್ಸೋ ರೈತರು ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಹೋಗಿದ್ದೇ ಇರುವವರಿಗೆ ಅವಕಾಶ ನೀಡಿ ವಂಚಿತರಾಗಿ 28A ರಡಿ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಹೆಚ್ಚಿನ ಪರಿಹಾರ ಹೆಚ್ಚಿಸದ ನಿರ್ದೇಶ.
Where are you reading?
127 ಪೇಜ್ ನಂಬರ್.
127.
ಆಕ್ಷೇಪಣೆ 4
ನಂಬರ್ 4 ಮೇಲಿದೆ. ಮುಖ್ಯವಾಗಿ ಎಸ್.
ಸೋನ್ಸೋ ಆದೇಶದ ನೀಡಿದ ಸರ್ವೆ ನಂಬರ್ ಹಾಗೂ 28A ರಡಿ ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿದಾರರ ಸರ್ವೆ ನಂಬರ್ ಒಂದೇ ಅಧಿಸೂಚನೆ ಕಾಲಂ 4(1) ಅಡಿಯಲ್ಲಿ ಇದ್ದಲ್ಲಿ ಭೂಸ್ವಾಧೀನ ಜಮೀನಿಗೆ ಹೆಚ್ಚಿನ ಪರಿಹಾರಕ್ಕೆ ನೀಡಲು ಕಾನೂನಿನಲ್ಲಿ ಅವಕಾಶ ಇರುವುದರಿಂದ ಅರ್ಜಿದಾರರು 28A ರಡಿ ಅರ್ಜಿಯನ್ನು SLAO ಇವರಿಗೆ ಸಲ್ಲಿಸಿದ್ದಾರೆ. ಮಾನ್ಯ ಸಿವಿಲ್ ನ್ಯಾಯಾಲಯ ಸೋನ್ಸೋ ಪ್ರಕರಣದಲ್ಲಿ ಆದೇಶ ಮಾಡಿದ ವಿವರ ಈ ಕೆಳಗಿನಂತಿರುತ್ತದೆ.
It only goes by notification.
Yes. What is the difference?
Nature, that's what the Honorable Supreme Court says. There are so many differences. Whether he has considered those points, whether he must consider.
What are those differences that you have pointed out there, and what are the differences that you are pointing out here?
In our objection, we have set in the objection. Objection.
Page
117, 118.
Page 118, my lord.
Page 118.
118.
118. Yes.
This is objection which is filed. Second paragraph. This is the objection which has been.
Yes.
Second paragraph. ಆದರೆ ಅರ್ಜಿದಾರನು ಸದರಿ ಪ್ರಕರಣವನ್ನು ದಾಖಲಿಸುವಾಗ ತಾನು ಈ ಹಿಂದೆ ಯಾವುದೇ ಹೆಚ್ಚುವರಿ ಪರಿಹಾರಕ್ಕಾಗಿ ಅರ್ಜಿಯನ್ನು ಯಾವುದೇ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಅಥವಾ ಪ್ರಾಧಿಕಾರದಲ್ಲಿ ಸಲ್ಲಿಸಿ ಸದರಿ ಅರ್ಜಿಯು ವಜಾವಾಗಿರುವುದಿಲ್ಲ ಅಂತ ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಲಗತ್ತಿಸಿರುವುದಿಲ್ಲ ಮತ್ತು ಹಾಗೆಯೇ ಸದರಿ ಈ ಅರ್ಜಿಯು ನ್ಯಾಯಭರಿತವಾದ ಕಾಲಾವಧಿಯೊಳಗೆ ಪ್ರಕರಣವನ್ನು ಸದರಿ ಪ್ರಾಧಿಕಾರದ ದಾಖಲಿಸಲಾಗಿರುತ್ತದೆ ಎಂದು ತೋರಿಸಲು ಯಾವುದೇ ದಾಖಲೆಯನ್ನು ಅಥವಾ ಪ್ರಮಾಣ ಪತ್ರವನ್ನು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ. ಅಲ್ಲದೆ ಸದರಿ ಪ್ರಕರಣ ವಿಶೇಷ ಭೂ ಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳು ಕಚೇರಿ ದಾಖಲಿಸಿದ 1 ವರ್ಷದ ಒಳಗೆ ಸದರಿ ಪ್ರಕರಣಗಳನ್ನು ಸದರ ನಾವು ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಸದರಿ ಜಮೀನನ್ನು ನೀರಾವರಿ ಅಂತ ಸಾಧಿಸಲು ಯಾವುದೇ ದಾಖಲೆಗಳನ್ನು ಅರ್ಜಿದಾರರು ಹಾಜರುಪಡಿಸಿರುವುದಿಲ್ಲ.
That is objection taken, well, after remanded by the Honorable High Court. You should have conducted an inquiry into that matter.
This is mere denial, Mr. Ravi.
My lord,
your officers have all the details. If you are going to only say, I deny, this has not been done, you should have been positive enough to say that it does not have.
Both have not done that duty proper. Both, I will not say I am right or wrong, but they have not produced, we have not produced.
Burden is on you also.
But they are claimant, asserting they are claiming. So burden is also on them.
They are saying it is in terms of so and so.
Notification.
Notification. It is for you to say that it is not so. See, Comparable, you should have.
Both have failed, my lord. I will not say I am wrong. Both have failed.
You take action against your officers who have messed up like this.
My only the thing is that, sir,
Probably
my lord,
everybody has colluded with each other. ಆಗಿರೋದು. ಜಾಸ್ತಿ ಆಗಿದೆ, ತಗೊಂಡು ಬನ್ನಿ, we'll increase it. Come and pay, file the application. We'll take care of it. And you'll get this much, you give us this much. That's all. You should take action against your officers. You should have complained against the SLO. That the SLO is not discharging his work properly. Then we could consider your submission. You don't do any of it and then come before us and say SLO is not done properly.
in fact, my lord, till 2021, we were not the picture at all. We were not having any notice or heard, hearing and all. After, my lord, we filed a writ, then we were brought in the picture. So very late stage we have come on record. Only based on the.
Yes. Anything else?
Capitalization method. Then well, this is away from, my lord. Another point, my lord, the Honorable Supreme Court, in page, my lord, same.
Page?
Page 83, Lord's making. We have taken this objection.
Yes.
Page 83, first para, last 5 sentences, my lord. Before proceeding with the determination, he should obtain an affidavit from the party making the application under section 28A. The no appeal against the award under section 26 read upon was filed, or if it had been filed, was disposed of by the appellate court and put a certificate copy. No affidavit is found in any of the petitions.
Is there an appeal filed?
We don't know. We have taken the objections.
Okay, at least if you were to show that, then you can say false.
These are excess we have done this.
Yes.
Anyway, these are the submissions, man. Because it is there. One more small issue that because of the under interest of part of it, my lord, of course, possession has been taken. Once possession is taken, my lord, I cannot say that. No, I will not bother you.
In possession, buried the land underwater.
But the only thing, my lord, only one submission and limit. I became then the liability on me became imposed on me only after the redetermination, and I could have deposited. From that day, my lord, liability normally arises. But the act is the date of termination. And section 28A, there is no inbuilt provision for interest, except 28A(3) says if the former landlord is aggrieved, then he can go for reference under section 18. Then once goes under 18 to 28 applies. Section 28 applies. In section 28, my lord, if redetermination then by the court, not by the LO, by the court, then my lord, the interest liability is there. 28, my lord, refers to may, not shall. In that connection, I will, my lord, place upon one judgment of Honorable Supreme Court, where I mentioned. Third judgment, page 20.
We are not cutting you short at all. Only repetition we are avoiding. Whatever argument you want to advance, please advance.
Page 22, my lord.
22. Major General Kapil Mehra. Para 45.
Can you take page 44 in that? Relevant paragraph 45.
Yes.
Award of interest under section 34 is mandatory, inasmuch as the word used in the section shall. The scheme of the act and express provisions thereof establish that interest payable in section 34 is statutory. The claim for interest under section 28 proceeds on the basis that due compensation not having been paid, the claimant should be allowed interest on the enhanced compensation amount. The award of interest under section 28 is discretionary power vested in the court, and it has to be exercised in a judicious manner and not arbitrarily. The use of the word may in section 28 does not cover any arbitrary decision on the court to disallow interest for no valid or proper reason. Normally, the court awards interest in if it enhances the compensation in excess of the amount awarded by the creditor, unless there are exceptional circumstances. My case is my humble submit, we come under the exceptional circumstances. The beneficiary now comes in exceptional circumstances. Because last till 2021, I was not in the picture at all.
Why did you come?
Because-
The state prosecuted. This is voluntary non-fit injury. You come and you say you have come late. Why did you come into being? Why was
Liability
your
came
company
on me.
born at all?
Liability came on me, that's the problem.
Liability, you took on the liability.
Compensation,
Your company has been formed for that purpose. You received grants from the state for
but
that.
my lord, the only question was like Mr. Raman Naik, who is to be saddled with that huge liability? Because now, my lord,
You should have moved the matter and asked for early disposal.
no, we came to only 2022 and immediately we have come.
You ask your parents, the state, why they did not move. And whatever you are saddled with will be paid by the state. You don't have any source of income.
We don't have.
All of it is grant from the state. So state itself will pay. If you have a problem with the state, then take it up with the state.
Right hand to left hand.
Exactly. So can we hear you say that I came into being later, therefore don't give them? The landowner did not ask you to come into being at all. That may not be possible, Mr. Ravi.
Or you can lodge me against the apportioned.
Apportion and
Till the date I on state and Niyam.
it is between both of you. to
Between
sort
both
out.
party, intercy. Intercy.
Left and right
Well,
speak
intercy.
to each other and sort it out. Yes, Mr. Patil. how long
And
will you
well,
take?
it's a discretion.
I request.
I mean, my whole summary is I leave it to honorable court. So I later discretion power. It can be a date of application, not from the award or apportion. That's one limited. At least some savings.
Discretion Angodre, it will go everywhere between.
A huge liabilities.
It is.
Lord, I request you, Lord, kindly take, Lord, the.
How long will you take?
One double zero
ಎಷ್ಟೊತ್ತು
seven.
ಅಂತೀರಾ? ಎಷ್ಟೊತ್ತು ತಗೊಂತೀರಾ?
Lord, more than half an hour.
Half an hour ಇವತ್ತು ಬೇಡ.
I'll finish.
ನಿಮ್ದು ಎಷ್ಟೊತ್ತು? 10 minutes. ಒಣ್ಕರ್? ನಿಮ್ದ ಇಲ್ಲ ಇದ್ದೀರಾ? ಬಿಡ್ಲಿಲ್ವಾ? Heard Sri Murthy Nayak Leonard, Senior Counsel, appearing for the petitioner in WP 10332223 and for the respondents in 86.14 and 86.15. Third, Sri MRC Ravi Leonard, Senior Counsel, appearing for the petitioner in 86.10 and 86.12
And 1-3.
and 86.13. Released on Monday.
My lord.
Released on 2:30 PM for further hearing.
I mean, permitted to appear through VC.
Yes, please.
My lords, we may be permitted a short reply, my lord, on Monday. my
You
lord.
will obviously be entitled to a reply.
Yes, yes,
Once everybody finishes, then
yes,
a reply.
yes, yes, great.
And Mr. Murthy Nayak will also have a reply, which he'll repeat again. So don't repeat again, Mr. Nayak. So any reply is not repetition.
No, my lord. Certainly not as much as Mr. Madhu Naik argued for 3 hours. He repeated as he could.
He made various points, he argued. Don't
Please,
repeat.
I have answered those, my lord. That's all. Repeated in the course of my argument. I'm sorry.
Mr. Naik, we should not be saying this to you, but you should not be making any statement against another lawyer,
Please.
whether senior counsel or not. That should never be done.
Please.
I also will not submit case law. Any order obtained by fraud is a nullity.
Yes,
Any order obtained by fraud is a nullity in the submitted.
that they've relied upon. Chengal Rai Reddy, I think they have relied upon for that. ಇದೇನು ಇದೆಯಾ?
233 matter. Ashwin C. Hubli.
Yes.
Lord, the petitioner is challenging the impugned order at annexure E issued by the respondent number 2, whereby the respondent number 2 has directed me to remove the alleged encroachment made on the road in respect of arrest number 71 of Savga village, Your Honor. Now, prior to this notice, my lord, at annexure annexure E, there was another notice issued by respondent number 3, that is the Tahsildar, at annexure C.
Yes.
Yeah, which is to be found at page number 28 here, my lord.
What happened to that?
As against that impugned notice, Your Honor, my lord, I have prepared a writ petition bearing WP number 107078/24, which is pending consideration.
Any stay order?
No stay order, my lord.
Then
it is yet to be.
You don't reply there, you come here, you don't get a stay order, they have proceeded.
No, my lord, because this was subsequently the DC was in fact the competent authority to issue the notice, which is impugned notice, which is being issued at annexure E, Your Honor.
Kalsum might get details, we'll have it next week. Don't
Lord, I'll
take coercive steps. And AG accepts notice for respondent number 1 to 4. Connect the above matter with WP 107078 of 2024. The respondents are directed not to take any coercive steps against the petitioner until the next date of hearing. Relist on 14th February.
My lord, for
13th February.
18th, I can request it on 18th.
18th February.
To Dinesh Kulkarni.
But I made an application under order 21 rule 97 pending consideration. Now the
21 rule
21 rule 97 application.
97 objector.
Yes, objector. Now the, my lord, pending consideration of those applications. Page number 158, my lord, the impugned order. Delivery warrant is issued with the aid of police. Pending objections of decree holder counsel for IA number 4 and 5 filed by JDR number 3. Legal aid.
Issue notice to respond number 1 to 11. Returnable by emergent notice returnable by 12th March. The further proceedings in EP number 27 of 2018 pending on the file of the senior civil judge and JMFC HB Early itinerate court Uinalli. State till the Uina Adagalli.
Uina Hadagali.
State till the next date of hearing. Process fee and copies to be furnished by end of day 10th February. Acknowledgement of service on the respective counsels for the respondent before the execution court to be filed on before 14th February, failing which the interim order will stand automatically vacated.
Lord, so far as some office objections are there.
Meanwhile,
mainly, my lord, they are revolving how my locus standi to challenge, my lord.
Comply madi.
I will give submission.
Submission. I will give submission. Comply madi illa submission.
Submission I will give.
We won't be considering each one here. We will be wasting other people's time.
3. Venkatesh Harvik.
Petitioner is my lord's Adhyaksha. Was unsuccessful candidate in the, my lords, he was unsuccessful in the no motion confidence against the petitioner. That was held on 18/1, my lords. So subsequently, I have challenged this notice, my lord, before this honorable court, page number 35. That was dismissed by this honorable courts on the ground that the representation according to law section 49(1). Thereafter, my lords. Thereafter, my lords. Only one ground I have come to the court, my lords. Before conducting the election, my lords. So order under rule 3 subclause 9 of the Panchayat rule has made given a notification that declarations to hold the office of the Panchayat.
Rule 3(9).
Rule 3 subclause 9 of Panchayat rules 1994.
As soon as may be notify such suggestion and also
Rule
inform
3 subclause 9
regarding such suggestion.
Rule subclause 3(9). If the motion is carried by majority of not less than 2/3 of the total
ನೀವು ಅಟೆಂಡ್ ಮಾಡಿದ್ರ ಮೀಟಿಂಗ್ ಇಲ್ಲ ಮಾಡಿಲ್ವಾ?
Yes, I have attended the no motion. I have unsuccessful myself, my
So
lords.
again,
Subsequently, my lords, if they conduct the election before that, they have to publish it. My lord, under order 3 subclause 9, my lords. That if the motion is carried by majority of not less than 2/3 of the total number of members of Gram Panchayat, the Adhyaksha or Upadhyaksha, as the case may be, shall forthwith cease to function as such, and the Assistant Commissioner shall, as soon as we notify such session on the notice board,
ಇವಾಗ
the
ನೋಟಿಫಿಕೇಶನ್
office of the
ಕೊಟ್ಟಿಲ್ವಾ?
Gram Panchayat, and also inform.
ನೋಟಿಫಿಕೇಶನ್ ಮಾಡಿಲ್ಲ.
Illa madilla, that is what, my lords.
And without that elections are.
Yes, my lords, that is 311.
Where is that?
My lord, 3:9 and 3:11.
Where is the election notification?
Election
my lords,
notification is
7
conducted,
notice.
my lords, page number 57, my lords.
57.
57. Proceedings are 50, my lords, and 27/1/2025.
11/2, na?
Yes.
11/2.
And AGA accepts notice for respond 1 to 3. 4 gyaro.
4 is the AU, my lord. It is also government.
Where?
Taluk Executive Officer. Yes, issued a notice.
Panchayat Development Officer MB Pujar.
Yes.
MB Pujar for respond number 4. Respond 4 to 17 dispense ಆಗಿತ್ತು. Relist on 10th at 2:30 PM for learned AGA to make a submission as to whether a notice in terms of sub-rule 9 of rule 3 of the so-and-so rules of 1994 had been published.
My lords, kind leave.
Yes.
I'm sorry, my apologies to my lord, serial number 83. One fraction of a second, by the time I could realize that I should appear, it was mistake is mine. I did not appear with the.
ಚಿದಾನಂದನು ಇರ್ಲಿಲ್ಲ.
Serial number 9.
ಅದರಲ್ಲಿ
We'll give
order
a
on
date.
extend ಆಗಬೇಕು, date may be fixed, my lord. 83.
83.
One date may,
Serial number
230 minutes.
Interim order also to be extended, my lord.
Yes, Mr. Anand, yes, Sati.
Serial number 9, my lord.
Yeah,
That is passed over today. That is preliminary hearing matter. Will have held up in court hall 4.
Date ಕೊಡಿ.
Monday, my lord.
One submission, my lord.
67 and 70, my lord. Kindly next week.
May I make a request, my lords?
Any date, no problem.
Matter pertaining to the principal bench.
My lord, one submission, my lord. My lord, this pertaining to serial number 82, my lord, at 2:30 it was listed, my lord. Insofar as the KEA matter, my lord. My lord, the admission are 60, my lord. But my lord, one seat, my lord, the aggrieved party, whoever has approached before this court, my lord, she has not, my lord, appeared before the KEA.
She appeared before the KEA, but not recommended because 60 ಆಗೋಯ್ತು ಅಂತ. Formal order was not passed.
My lord, but she hasn't taken admission through KEA, my lord.
She has not taken admission.
Please.
But she had appeared, she was not given admission only on the ground that 60 intake has been completed.
It was 59, my lord, actually.
ಅದು ನಿಮ್ ಕಮ್ಯುನಿಕೇಶನ್ ಗ್ಯಾಪ್ ಆಗಿದೆ, ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್.
Monday.
Monday.
Serial number 5, my lord, passed on Monday.
Monday.
Please.
Any date, 12th or 13th.
Serial number 78. No conference motion. No conference motion, my lord.
78 Monday.
Please.
Lords, the election petition of the principal bench.
Yes, Mr. Rajan.
Lords,
We'll do it once we get back to Bangalore. ಇಲ್ಲ ಆಗಲ್ಲ ಇದು. ನೀವು 1 hour argument ಮಾಡ್ತೀರಾ ಅಂದ್ರೆ ಇಲ್ಲ ಆಗಲ್ಲ. Not at the cost of Dharwad matters.
Lords, it's been kept pending by the respondent.
We'll have it in Bangalore. ಇಲ್ಲ ಇಲ್ಲಿ ಕರ್ವಿ ಅವ್ರು ಬಂದು ಇಲ್ಲಿ ನಮ್ಮ ಗುರ್ರ ನೋಡ್ತಾ ಇದ್ದಾರೆ. You are wasting our time.
With your lordship's kind leave, my lord.
Date could be fixed in my matter.
Date will be fixed as 5th March.
Please, my lords.
My lord, with your lordship's kind leave.
Yes.
The matter was adjourned to 10 to, can it be 11 to, my lord? I have some difficulty on 10 to. I'll inform Mr. Suraj and Mr. Patil.
11 to it won't happen because our yaad kodi calendar kodi. 11 to won't happen. 12 to you can take a chance.
Please, my lord. 12 to 2:30. I'll inform them.
My lord, serial number 73.
Yes, Mr. Javalkar.
Serial number 73, it is in respect of seeking permission in respect of a Kannada medium 9th and 10th standard school. So since the education, again, it will be
73, na?
73. 73.
Monday, 2:30.
Please.
My lord, 83,
Please.
83 interim order is to be extended, my lord.
Mr. Anand, this is the 5th time you are saying that.
ಹೌದು ಕೇಳಿಸಿದ್ಯಾ? ಅಯ್ಯೋ ನಂಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಐ ಆಮ್ ಸಾರಿ, ನಂಗೆ ಗೊತ್ತಾಗ್ಲಿಲ್ಲ. ಐ ಆಮ್ ಎಕ್ಸ್ಟ್ರೀಮ್ಲಿ ಸಾರಿ.
ಶ್ರೀರಾಮ್ 6770.
ಕೊಡಪ್ಪ. ಬುಧವಾರ ಶ್ರೀರಾಮ್ ಸರ್ ಸೆಕೆಂಡ್ ಮಂತ್ ಯಾವಾಗ ಕೊಡ್ತೀರಿ? ಮಂಡೇ ನಾ ಇರಲ್ಲ
ಸರ್ 83 ಸರ್.
ಶ್ರೀರಾಮ್ ಸರ್
ಮೇಡಮ್ ಒಂದು ಕಾಲ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್, ಕಾಲ್ ಮಾಡಿ.
ಮುಗಿದ್ಮೇಲೆ ಕಾಲ್ ಮಾಡಿ ಸರ್.
83 ಯಾವಾಗ ಕೊಡ್ತೀವಿ ಸರ್ ಡೇಟು?
ಸರ್ 13
28
83 13.
ಓಕೆ 13 ಫೆಬ್ರವರಿ. ಮ್ಯಾನೇಜ್ ಮಾಡಿ